Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 1st. Happy Black History Month. We have 15 bills on the docket. We're going to start off with Senator Salling, and then we'll go with Senator Muse, and then go to Senate Bill 87, 100, 39, 378, 111, 398, 17, 379, Senate Bill 11, Senate Bill 123, Senate Bill 318, Senate Bill 4, and then we'll end up with Senator West, Senate Bill 380. It's a lot of bills in one day. Before we gavel in and before we let you go, Senator, just a reminder that it is a privilege to serve all of you, the constituents and the folks that come before the committee. It's a privilege to serve in this committee, and vigorous debate is obviously allowed and in fact encouraged, but civility is at a premium. When we're engaging with each other, I just remind the members to be civil. You can disagree without being disagreeable, and we can have a vigorous exchange of ideas without being offensive to one another. So with that in mind, Senator Salling, welcome to the Judicial Proceedings Committee. The floor is yours.
Thank you. Thank you. First of all, thank you, Mr. Chair, Vice Chair, and Judicial Proceedings Committee. For the record, I'm Senator John A. Salling, and presenting Senate Bill 382. It's criminal law display of obscene material to minors, age verifications. I have my delegate who's cross-filing this bill and add into law. And just for the record, we are changing this bill to the Louisiana law on the bill. And you will be getting those amendments. But the problem that we have, if you think about obscene materials to minors and the ages that you present certain things that pop up, we want to make sure that there's something that can be displayed for age verifications, those pop-ups to minors for accessing pornographic materials. Years of research, they say that the human brain is not fully developed until the age 25 to 26. And children who access this material may very quickly develop a warped idea of sexual interference, of materials, of mental, physical, emotional intimidation, and it may have unrealistic ideas that can have negative impact in their family relationship with their other family members. Again, there's doctors that have stated that extreme pornography can really bungee cord or jump in a threshold that it can develop extreme measures where they can do worse things, and I believe nobody want that. I think more than anything that when we add more out there to our minor kids and they see things that I believe that are not right for them and their young mind, it could go to a place where they can do drastic and dire things. And again, I believe we don't want that. So again, I stated I would like to add in closing that I have now an understanding that there were other issues and language in this bill, and I'm working to amend and file and clarity in some ways so we can change this bill so we can have nobody or opposed. And I've met with them and they told me that they will be favorable with amendments. So I thank you for this opportunity, and I am open for any questions that you have, and I'm going to thank you again.
All right, thank you very much, Senator. Or questions from the committee? All right, so I think you have one witness here to sign up as in support. I don't know if he's you know if it's so is Mr. Ayo Kamathi here from Brothers of the DMV? Okay. Seeing none, no questions. Thank you very much, Senator.
Thank you, and I'll see you tomorrow.
Thank you.
Thank you again. That
concludes the hearing for Senate Bill 382. We'll now move on to Senator Muse with Senate Bill 177.
Thank you, and good afternoon, Mr. Chairman, Vice Chair, and members of this Senate Judicial Proceedings Committee. For the record, I'm C. Anthony Muse, Senator from 26th Legislative District. I have a panel I want to invite up our State's Attorney, Aisha Braveboy, and Assistant State's Attorney Ashley Elias. Very simple. Senate Bill 177 is the amended version of last year's bill that this committee heard. SB 177 would prohibit a law enforcement officer, correctional employee, or a state or court-ordered services provider from engaging in sexual activity with the person that is in his or her custody. Also, if convicted, this bill would change the act to a felony instead of a misdemeanor, something I very seldom push for. And the defendant would be subject to imprisonment up to 10 years or fine up to $3,000 or both. Now, members of the committee, no one that is in the custody of an officer while they are in their official capacity should be forced to subjected to any sexual contact. We can't tolerate these heinous acts or behavior by a person who takes an oath to protect the community. Some recent incidents that occurred that brought about this bill and some changes. A case, not recent, but a case in 2018, a 6-year veteran officer forced an undocumented Latina woman into engaging in a sexual act in exchange for evading a ticket or an arrest. In October of 2022, a Maryland sheriff was charged with second-degree rape and assault of an individual while in custody. And then finally in 2020, an officer from a local municipality sexually assaulted a 19-year-old woman while in custody after a traffic stop. I'm going to let my panelists talk more about these cases, as they were the ones to try this case in January of this year. In closing, there are 1,000 wonderful things that I can highlight about our offices across the state of Maryland. But unfortunately, a small number of officers that commit these crimes reduce the public's trust. So SB 177 would hopefully deter law enforcement officers, correctional officers, and or a court-ordered service provider from committing such a disgraceful act. Therefore, I will again urge for a favorable report on SB 177. I'll turn it over to my state's attorney, who I'm very proud of, and who was once a long time delegate here, Aisha Braveboy.
Thank you. Thank you so much, Senator, and thank you for introducing this bill again. And thank you to this esteemed committee. Good afternoon. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee for considering this bill, Senate Bill 177. When a law enforcement officer or a person who's in a position that can really impact someone's liberty, when they engage in sexual contact with someone, the question often is, was it consensual? Well, how can it truly be consensual if the person who you're engaging in a sexual act with has the ability to arrest you, detain you, charge you? These are powers that the average person doesn't have. And so when individuals agree, quote unquote, to engage in those sexual acts, it's not because they want to, it's not because they're getting any pleasure out of it, it's because they're often in fear. And the current statute does not really truly focus on the fear that these oftentimes women, but it could be anyone, has when they're encountering someone who is in a position of authority. And so we're just asking this committee to do what I believe you will do, which is look at this as a non-consensual act and treat it as such in the law and in the punishment. And so our office, unfortunately, has had to deal with this issue on numerous occasions. And the results are are not what we desire. The outcomes, the types of sentences that are recommended based on the sentencing guidelines just don't provide the level of deterrence that we think is necessary. So thank you all so much for considering this, and I'll turn it over to Ms. Elias, if that's okay with you, Mr. Chair.
Come on.
Good afternoon. My name is Ashley Elias. I'm an assistant state's attorney with a special victims unit in Prince George's County. I prosecuted the case that was actually mentioned where a 19-year-old was pulled over for speeding. She was actually on the way to the hospital because her toddler son had a head injury. So she was speeding to the hospital to get to her son. She was arrested then for disorderly conduct. And while at the station, the officer, who was our defendant, said that she could either have sex with him and be released to go to her son, or if she refused, that she could go to jail. He was only found guilty of sex in custody based on defense's arguments that this was a consensual encounter because he did not pull a gun, he did not hold her down, things of that nature. However, the changes that are proposed here today will address the significance of the abuse of power that is inherent in these types of crimes. Because that's what happens in these types of cases. These individuals are using their power, their authority, their ability to arrest or detain individuals for their own sexual gratification. And these changes will address the sentencing disparities that we see. For instance, in our case, the defendant was released, not even with a probationary period. He does not have to register as a sex offender after telling a 19-year-old that she could either have sex with him or go to jail. And so in conclusion, I would ask for a favorable report for this bill. Thank you.
Excellent. Thank you, Senator, and thank you to the panelists. Questions from the committee? All right, seeing none, thank you all very much.
Thank you.
Thanks. All right, with that, that'll conclude the hearing for Senate Bill 177. We'll now move on to Senator Carrozza, Senate Bill 87. Welcome.
Good afternoon. For the record, Senator Mary Beth Carrozza, representing District 38, Maryland's Coast, that's Worcester, Wycomico, and Somerset counties. And I want to thank you, Mr. Vice Chair, and the members of this distinguished Senate Judicial Proceedings Committee for this opportunity to present Senate Bill 87, a priority public safety bill and victims bill that increases and strengthens driver accountability when their criminal driving actions kill or cause life-threatening injuries, the most serious of driving accidents. This past year, since last session, like many of you, I've worked on public safety initiatives with input from schools and churches, community organizations, businesses, law enforcement, and local states' attorneys to help develop a bipartisan package of bills addressing violent crime and juvenile crime. But through this process, I also became more aware of the need to increase driver accountability when their criminally irresponsible conduct leaves others dead or permanently injured. This bill is important and it's a priority for victims and their families and loved ones. I've heard stories, some of which you're going to hear today, some of which you've heard during compelling testimony during your consideration of Jamari's Law last week about sentences that offend many, especially victims and their families, that utterly fail to capture the impact of these offenses. I heard stories about individuals who, despite being sentenced to years in prison, are released on parole after mere months. Many Marylanders are astonished to learn that a repeat drunk driver who gets behind the wheel while impaired and kills someone only faces a maximum sentence of 5 years. Even more astonishing, that same individual even if they receive the maximum, could be released on parole after having only served 15 months. 15 months for a repeat drunk driver that stole someone from their family, from their community, and from our state of Maryland. Senate Bill 87 makes 3 significant improvements for driver accountability for those who have been convicted of driving crimes causing life-threatening injuries or death. It takes a thoughtful approach by looking at the driving crimes and penalties together for both first offense maximum and subsequent offense maximum, current law, and proposed changes in SB 87, as well as looking at parole eligibility. First, it provides that violations of Wade's Law, which is a conviction of criminally negligent driving causing life-threatening injuries, will qualify a defendant for subsequent offender penalties if they continue to drive in a criminally irresponsible manner and cause the death or serious injury of another. Currently, a driver who has previously violated Wade's Law and continues to drive in a criminally negligent manner, going on to kill someone, is treated as a first offender by that statute and only subject to the penalties that a first offender is subject to, despite having already engaged in similar conduct. Senate Bill 87 increases accountability by adding a subsequent offender penalty and recognizes that perpetrators should not get a pass simply because their criminally negligent conduct did not kill someone the first time. Second, Senate Bill 87 provides modest increases in sentences, primarily for subsequent offenders. You should have in your packets a chart prepared by the Maryland State's Attorneys Association that summarizes these long overdue increases. Subsequent offender penalties exist to deter individuals from continuing to engage in the same criminal conduct and to protect the public from those individuals. Right now, a driver who kills someone with criminal negligence and then after they have been released from their sentence does the exact same thing again, killing a second person, is subject to a 5-year maximum sentence. This penalty is offensive to victims and their families and wholly inadequate to protect the public from someone who has demonstrated by their conduct that they are incapable of following the law and driving safely. And finally, Senate Bill 87 provides that criminal driving offenses which result in death or serious physical injury, the most serious offenses one can commit while driving, short of intentional murder, will be treated as violent crimes for parole purposes. As the law currently states, defendants serving sentences for these offenses can be considered for parole after having served only 1/4 of their sentence. The violent, life-ending, and life-altering consequences of this conduct should not be treated more leniently simply because perpetrators use a car instead of a knife or a gun, and it is absurd that they are treated more leniently than offenses like burglary of a storehouse, which is violent only in the most abstract sense. Senate Bill 87 would require individuals to serve half of their sentence for these crimes before they can be considered for release on parole, an outcome that fits the severity of this conduct. Our victims' testimony highlight that these offenses, by definition, permanently alter the lives of victims. My colleagues, SB 87 offers common sense, modest revisions that will increase driver accountability when their criminal driving actions, often repeat behavior, kills or causes life-threatening injuries. Mr. Vice Chair, I respectfully urge you and the members for a favorable report on Senate Bill 87. And I would also ask that if we could hear from the victims and witnesses before we take questions. Our first lead off would be our Baltimore State's Attorney, Kurt Borglin, who will introduce the victim.
Thank you, Senator. Good afternoon, Mr. Vice Chair, members of the committee. My name is Kurt Bjorklund. I'm an Assistant State's Attorney with the Homicide Division, Baltimore City State's Attorney's Office. Been a prosecutor for nearly 19 years. I've devoted my career to prosecuting crimes of violence and advocating on behalf of victims and their families. I'm here today to provide support for SB 87. Ladies and gentlemen, motor vehicles are deadly weapons, especially when operated recklessly and by those under the influence of alcohol or drugs. The enumerated crimes included in SB 87 should certainly be considered violent crimes for the purpose of parole eligibility. Currently, 3 degrees of burglary offenses are considered violent under the Correctional Services article, crimes where the offender need not ever come in personal contact with the victim. 9 years ago, I prosecuted Heather Cook for striking and killing Thomas Palermo with her vehicle and for leaving the scene. Tom was merely riding his bike. Cook, an alcoholic with a prior for DUI with accident, was both drunk and texting while driving. Without question, Cook's crimes were violent in nature. Tom suffered fatal head injuries. Ms. Cook pled guilty, received a 20-year sentence with all but 7 years suspended. Though she was appropriately denied parole multiple times, she ended up only serving 3.5 years in prison for taking Tom's life. She should have served more. She deserved to be classified as the violent offender she is. In fact, Cook had planned to drive from Baltimore City to the Eastern Shore that day, addled with a .22 BAC. Ladies and gentlemen, passage of this bill will continue to strengthen the message to the public that we will not tolerate violent vehicular crimes and driving under the influence. Passage and publicity will deter bad decisions and invariably save lives. Thank you very much. I'm introducing Rachel Rock Palermo, please.
Hello, I'm Rachel Palermo. Thank you for allowing me to speak. In 2014, while riding his bicycle on a sunny December afternoon, my husband, Tom Palermo, was killed by a person who later pled guilty to a DUI-related manslaughter. Our kids were only 3 and 6 years old. The person who killed Tom served a total of 3.5 years of a 7-year sentence and is already finished with her probation period. After only 18 months in prison, the defendant requested parole. The shock that the defendant could be released sent a searing pain through me. This person had been convicted of crimes that were supposedly non-violent crimes, but my husband's death was anything but, and it all felt extremely violent to me and my family. Yet here we were at 18 months. 6 requests came over the next 3.5 years, 2 parole hearings, 2 home detention requests, 1 work release consideration, 1 consideration for modification of sentence, 6 requests over 3.5 years. Each time there was a fresh wave of added grief and pain for all of us who loved Tom. Each time I had to move my focus away from our young kids and back to this person who had killed my husband. Today, 9 years later, my kids are teenagers. The trauma that my kids and I have been through resurfaces when we least expect it. I miss Tom daily. I stand here in front of you feeling fresh pain in my loss. I ask you to help those who have lost loved ones in a sudden and violent way. I ask that you change the laws so that others can focus on their grief and the complicated restructuring of their lives. Our grief is already big enough. Thank you.
Good afternoon. My name is Jamie Sterling. I'm the state's attorney for St. Mary's County. I'm here to explain or to really, part of my job as a prosecutor, let me start there. Part of my job as a prosecutor is to ensure if there's something that we see in the courtroom, something that's happening in prosecutions that doesn't seem fair, that's unjust, is to figure out what the solution is. The solution that this bill helps to solve is something that is out of the control of the prosecutor's hand. And quite frankly, it's out of the control of the judge's hand. It's after a sentence is sentenced, it's the parole requirements of the diminution credits or how someone is eligible for parole. That's something that's completely out of our hands. It's something that I cannot control. So when I prosecute a case, and in these, we're talking about prosecutions of vehicular homicide. In these instances, they're considered nonviolent crimes. I'm here to speak about how vehicular homicides are anything but nonviolent. When we talk about homicides, the intent field homicides, we understand what a firearm does, and we understand what perhaps a knife does. And in the context and comparison of what we see with autopsy reports and others, they're pretty sterile in nature. You see gunshot wounds and you see knife wounds. And we would all agree that if that was a fatal blow, that sure, that is violent. I'm here to explain to you, as I'm someone who goes on the scene for these crime scenes are the most brutal and the most violent that you will see. There's something that a bullet can do to a human body. There's something that a knife can do to a human body. But what a vehicle can do to a human body is unimaginable. What a vehicle can do when you're trapped in a vehicle is unimaginable. But worse, what a vehicle can do to a pedestrian or a cyclist is unimaginable. These are some of the instances where I believe it's important for everyone to understand just how violent these cases are, and to say and to categorize vehicular homicide cases as something that is not violent absolutely defies logic. It is indescribable. And what I'm here to do is to really to strike that message, is to say these are violent crimes. And for the families that have to go through the convictions and have to go through the process of a prosecution to then later be told that what happened to their family member, most of whose bodies have been completely brutally mutilated, some of which are decapitated, some of which are burned, and they're denied the opportunity to have an open casket funeral, but we classify them as nonviolent. It is an absolute discredit, disservice. This is not justice. There's nothing I can do as a prosecutor. There's nothing the judges can do. It's only something you can do. So I'm here to please plead with you to classify this as a violent crime, because once you do that, all the offenders, regardless of what the sentence is, the judge will decide what the sentence is, but that person will serve 50% before they're parole eligible. I have Mr. Scales here. His son was killed, not by a drunk driver, not by a drug driver. I prosecuted the person who killed his son for vehicular homicide. That driver was going over 80 miles an hour, and his son was outside of his vehicle. So he was struck as a pedestrian. Richard Jackson was 20 years old. And Mr. Gary Scales is here to ask you to think about his son and everyone else like his son, and treat the killing of his son as a violent crime, so that those who commit those crimes are treated that way. So I'm going to ask Mr. Scales to please come up.
Appreciate it.
Good afternoon. Sorry. Thanks for allowing me to speak today. I'll tell you a little bit about my son. Richard was a smart, energetic, loving child. He had a bright future. He attended Guilford University. He was playing basketball. He ran track. He had a lot of friends. What he loved most was tinkering on this beater of a car that he had. He was so proud that he had purchased it himself and constantly working on it, doing little modifications. I remember a story that his mom told when they were at the fair. Richard kept jumping in and out of line at the cakewalk. He'd jump in, he wouldn't win, he'd put another ticket, jump in the line again, walk, wouldn't win, put another ticket. So his mom was concerned and said, why aren't you riding the rides or playing games, with your tickets? He said he wanted to win a birthday cake for his mom. Richard was the best friend to his sister, a role model for his little brothers, who I had to explain at the ages of 6 and 9 years old, that he was gone forever. He was taken from us by a guy who literally hunted him down with a vehicle. He was struck at over 80 miles per hour in a 25-mile-per-hour speed zone. It was actually on a tract property, so it wasn't even on the main road. We looked to the legal system to, handle this and give us some type of, we looked for some justice, only to have the judge state that it would be cruel and unusual for him to sentence this guy to the maximum sentence. 4 months after the sentencing, this guy was released. We actually had to contact an organization to go back and actually appeal that and have him put back in, where he was released 3 months later. During the time he was in jail, we received numerous requests for parole and to let this guy out and what have you. There was no remorse at the trial. There was no compassion from the judge. It was like we were on trial. The people who were riding in the vehicle with this guy some of them didn't even show up to trial. They hid from their request to come to court. They hid. One gentleman at the scene made a statement that they had smoked weed before in the day, but no sobriety was given to this driver. He killed my son. We miss him dearly, and I'm asking that you consider us on this bill. Sorry.
Thank you so much for your testimony. The sponsor has requested that we hear from additional panels before taking questions, and we're happy to honor that request.
Could the next panel come up, please?
So as the next panel is coming up, our tradition in this committee has always been that elected state's attorneys, elected officials are not timed. As we have increasingly had elected state's attorneys join us here, multiple on the same bill, we're going to try to enforce the 2-minute time limit.
My name is Megan Moore, and I'm here today to share my support for Senate Bill 87. I testified last week in favor of Senate Bill 26. So many of you have seen a photograph of my son Noah and know that on June 5th, 2021, Noah's life was taken in a car crash caused by an impaired and reckless driver. I would not be here. I would not put myself through this emotionally draining and extremely difficult experience if I did not feel it was important to share my perspective. I was shocked to learn that manslaughter by motor vehicle is not identified as a violent crime. In my opinion, it most certainly should be. Parole eligibility and penalties should reflect the severity of crime. I know people mean no harm when they say, well, at least Noah died quickly. But it was, and it is a violent death. So it's my sincere hope that Senate Bill 87 addresses this issue and ensures that justice is served for victims and their families. Thank you.
Good afternoon, and thank you for your time. My name is Daniela Murphy. On April 22nd, 2018, my friend's son, my husband's son, and my stepson's brother, Matthew Murphy's life was taken from him, taken by a man who decided to do drugs while behind the wheel. Matthew's life was taken by a man who had no regards for the law and for human life. This man was sentenced to 10 years, serving only 3.5. Negligent manslaughter is often referred to as involuntary lack of intent to cause harm. By making negligent manslaughter a violent crime, we can ensure a stronger deterrent effect, discourage reckless behavior, and provide a more just legal system that respects the value of human life. The justice system only took 3.5 years of the man who killed Matthew, but Matthew's family will forever be mourning Matthew for the rest of their lives. I ask that you support this bill, support the victims, and support their families. Thank you.
Hi, Senators. My name is Monica Murphy. And I'm back in front of you again. Please give your support on this bill. Because this is extremely violent. I know. I was there. I watched my child, a 12-year-old boy, be hit by a 12,000-pound work truck. And if you don't think that is the most violent thing to see, please, I beg of you, please pass this.
My name is Carolyn Gramis. I'm an assistant state's attorney in Anne Arundel County. I know you heard from me last week. I first want to start with one of the top things I'm told: it could happen to anyone. Today, I was at the funeral for Sergeant Eric Trumbauer, the #1 DUI enforcer for 14 years in a row. He shared the passion that I have to fight for the victims in this state who died. He saved many lives. I have just a couple of things that I want to share with you. This is Stuart Johnson and his mother, Mentha Brandon. He was killed by a drug driver on 295 that he was working, changing a tire for a bus. He worked for a tire company. She fled the scene. She was high. She got a 20-year sentence to spend all but 10 years. That was in January of 2020. She received that sentence 7 months later. Mentha Brandon got a letter from parole saying we're considering her for parole, victimizing her again. We went to the parole hearing, We fought. We were able to successfully keep her from being released. We're waiting to do that again after serving just 2.5 years. I show you this photo. It is somewhat graphic, but I think you need to see. This is the injury from a drunk driver. She lost basically the use of her leg, that is her knee, that's been reconstructed by shock trauma. In the hospital for months, in a rehabilitation hospital for months, she is confined to the basement of her home because they cannot afford to fix the house, to get a sufficient wheelchair accessible house. He was sentenced to 2.5 years. 60 days later, a letter saying they're going to put him on house arrest. Again, fighting to keep people accountable. This doesn't happen to anyone. My question to you is, how many times do we have to victimize victims again and again? The sentence, the parole, I ask that you favorably pass this report for Senate Bill 87. Thank you.
Good afternoon. My name is Lauren Bourdon. I'm a senior assistant state's attorney with the Wycomico County State's Attorney's Office. I have the privilege of prosecuting some of the county's most violent crimes, and that includes the manslaughter by automobile cases within the county. Last Wednesday, I had the honor to support my written support for Senate Bill 26, seeking enhanced penalties for these types of cases. And I told you in that written submission about my first encounter with grief and how it has impacted the way that I view these cases. I have also submitted that in support of this bill. On July 12th, 2022, 4 hardworking Haitian immigrants were driving home from working the overnight plant at a local chicken plant in Wycomico County. Those individuals worked that shift to provide the necessities for their families and to provide opportunity for a better life for their children. A Salisbury University student was working at a bar in Ocean City and decided to drink after his shift. And on his way back to Salisbury, driving in excess of 100 miles per hour, He ran into the back of that vehicle carrying those 4 immigrants. He sent that vehicle into a tree, killing 2 of the women, Jocelyn Osias and Neltha Perard. The current state of the law, manslaughter by automobile is treated the equivalent of assault in the 2nd degree, and it is offensive. At sentencing, courts have to consider not only punishment and deterrence, but also what measures need to be placed for public safety and rehabilitation, such as supervised probation with alcohol monitoring for an extended period of time. Due to that, the defendant in this case was sentenced to 20 years, suspend all but the top of the sentencing guidelines, 8 years. When I first explained this to Jocelyn's daughter, she was understanding and satisfied with an 8-year sentence. But as I explained parole eligibility, she was angry. She was angry that it was not considered a violent crime because her mother's death was violent. She had to drop out of college and take care of her toddler sister, and now works at that same chicken plant that her mother worked to give her a better life. She feels as though justice was not served. And justice was not served. Please support the enhanced penalties. Please support this being classified as a violent crime so that the courts can do more with the current structure of the law. Thank you.
Good afternoon, Mr. Vice Chair, distinguished members of the committee. My name is Patrick Gilbert. I'm also a senior assistant state's attorney in Wycomico County, but I'm here this afternoon on behalf of the Maryland State's Attorneys Association to urge a favorable report on this bill. Once again, just as with this committee's consideration of Jamari's law, there's nothing I can add to the testimony you've already heard that could better illustrate the profound grief each and every one of these cases inflicts on families and communities in our state. So I'm going to focus my comments on an issue that Senator West brought up last week about parole eligibility, which is something that this bill deals with head on. The offenses addressed by Senate Bill 87 aren't currently considered violent crimes for the purposes of parole, which as you've heard today means that individuals serving those sentences can and do secure release after having only served 25%. Although individuals engaging in this conduct don't intend to hurt anyone, that doesn't make the outcome any less violent. And adding these offenses to the list of violent crimes in the Correctional Services article isn't intellectually inconsistent when we look at the other offenses that we already treat as violent, offenses like burglary of a storehouse. But even if we look at the more prototypically violent offenses on that list, offenses like arson, the conceptual similarities between those offenses and these offenses warrant this committee's action on this important issue. Arson requires the state of Maryland to prove that an individual knowingly set fire to a dwelling. The individual doesn't have to intend to kill anyone or intend to harm anyone, just setting a fire to a dwelling, boom, violent crime. The difference between these cases and arson is that in these cases, someone is actually dead. Someone has actually been hurt. Someone has been profoundly injured in a way that will impact them for the rest of their life if they're lucky. The difference between these cases and arson is that in these cases, there is someone in the building. Every other person on the road is in the building. And when someone gets behind a wheel, too drunk to drive, intoxicated, impaired, driving in a reckless manner, in a criminally negligent manner, they have intentionally lit that match. I'd welcome the committee's questions about this bill and about these types of cases. These cases, the arson is that in these cases, there is someone in the building. Every other person on the road is in the building. And when someone gets behind a wheel.
Ms. Kirsch, if you could mute yourself. Okay, thank you. Mr. Kroll signed up to testify.
I testified on for the State Attorney's Association.
Understood.
I'd like to invite the lawyers back to the.
Okay, well then let's pause here for questions and see if there's any questions from the committee. All right, seeing no questions, I will say thank you. We really appreciate your being here, both our state's attorneys and the families. Our thoughts and condolences are with you, and we know how much courage it took for you to come here and present this bill publicly. So I appreciate that. Let's move on to the opposition of the bill, the Public Defender's Office, Tamara Stofa.
Good afternoon, everyone. My name is Tamara Stofe, and I'm the District Public Defender here for District 3 on the Upper Eastern Shore. And I'm asking the committee to consider an unfavorable report on this particular bill. And my request comes from the fact, as has been mentioned in language used numerous times that the current crimes that are crimes of violence are specific intent crimes. As the last witness just testified as to the arson, there's a knowing element that someone knowingly did something. The crimes that have been asked to be included in these particular cases are of a negligence standard, meaning an unintentional type crime. And that's where I find the distinction between the crimes of violence that are currently listed and why perhaps we give stronger consideration for not being released on parole because of the specific intent elements. When you're in the courtroom, these are difficult elements that have to be proven by the state, where in these types of cases that they're asking you to include in the crimes of violence, the elements of proof are much less. And so that is where one of the reasons I'm asking for an unfavorable report on this matter. Additionally, I would, as mentioned previously and you heard, these types of cases are cases that are considered under the Maryland sentencing guidelines. Because there is death often involved in these types of cases, there is enhanced penalties, meaning greater consideration for these types of cases. And so that is taken into consideration already. And finally, I would indicate that in these types of cases, there are collateral consequences that even don't happen with the particular crimes of violence with the motor vehicle administration. There's additional consequences that often come from these types of offenses. But primarily, I'm asking for an unfavorable recommendation because of the nature of the elements of proof. Thank you.
Thank you so much for your testimony. Ms. Kirsch, you're up. If you could unmute yourself and whenever you're ready.
Thank you, and I'm glad to be here. I want to speak to you today as a parole advocate and somebody who sees a number of charges that have these kind of unusual carve-outs. First of all, I'd like to say, working with the Parole Commission, that they give these cases a great amount of consideration. They give these cases a higher level of scrutiny. There is an entire victim services and notification component where additional information is requested on these cases. And so the Parole Commission is doing a fantastic job of exercising their discretion. We actually have a Parole Commission with a declining grant rate. And so I believe that our executive branch is fulfilling its mandate, is reviewing these cases, is rendering reasonable decisions, taking all of the circumstances of the crime into account already. So by making an administrative carve out, what is actually done is a lot of administrative difficulty, a lot of administrative error, a lot of things that have to go back and be fixed. And that costs the state a lot of money. And you're really yielding the same result because you're getting a discretionary decision maker. In fact, in these cases where there is loss of life, 2 of the appointed by the governor and confirmed by the Senate parole commissioners are reviewing the case with the individual in person. So this is a very in-depth review that's being provided. And so I would ask, instead of creating a carve out where you're going to have commitment errors, where you're going to have case management issues, where you're going to have parole eligibility issues. And I am often involved in unwinding these kind of errors as a practitioner on a daily basis. So instead of doing that, to let the executive do its job, leave the discretion of the Parole Commission in their hands. Thank you.
Thank you so much, Ms. Kirsch. We'll now take questions for the opposition to the bill. Senator Folden has a question.
Thank you, Mr. Chairman. So let me just start off by saying, first of all, that these occurrences that have happened to these families, I've done fatal crash reconstruction as a police officer for over 20 years. And I can tell you without hesitation, unequivocally, that these are violent deaths. Having said that, I'm curious for PD Stofa. You made a comment about that it didn't meet the legal threat, I guess the legal definition, or that there's a specific intent crime. And I guess my question is, at what point So if we can figure out a way to wordsmith this satisfactorily to you, the specific intent crime versus the violent outcome that is the disposition of that act, is that something that you believe we should have a harsher penalty for? Or you still feel that 2.5 years is enough for the loss of life in a violent vehicle related collision, regardless if they're impaired or not?
I'm sorry, Senator Fulton, is that to the public defender?
Yeah, I said Ms. Stover.
Okay, I
PD Stover.
apologize. Ms. Stover?
Well, thank you for your question. I don't think my personal opinion about how I feel about what a sentence should be. I've personally been involved in these cases. They're very tragic. They're very hard. I feel for every person that testified before you today and for their loss. It's genuine. It's usually genuine on both sides. What I am trying to explain to you is that the current list of crimes are specific intent crimes. And being a defense attorney for the last 26 years, I can tell you with confidence that the specific intent crimes are elements that must be proven in the case. And to break it down, there's a knowing element where these crimes are negligent based. So there's not an intentional knowing act. And I think that that's the distinction that I'm asking you to consider.
Isn't the negligence or the reckless portion of it the intentional act that they're speaking from? When you knowingly take possession of a 3,800-pound projectile and you decide to drive in excess of 80 miles an hour in a 25-mile-an-hour zone, haven't you knowingly and willingly taken that act?
What I would tell you is that the trier of fact, whether a jury or a judge, would never be instructed on the fact that there is a knowing element in that it is enough to find a lower standard of proof as to the negligent behavior. And that is the distinction I'm trying to.
So you're bringing forward the violent crimes guidelines. So what I'm hearing you say then is that you're stuck wholly on the black and white as it's written, instead of looking for a solution for these families that are losing loved ones and not getting justice for their loss of their family. So you would be amenable to figuring out a way to change or give a guideline, appropriate measures to put something in law that would capture that for them?
What I'm indicating to you is you'd almost have to change the whole definition, the penal codes, the standards of proof. So it's not so simple to just change everything. What I'm saying to you is the current crimes that are listed as crimes of violence that you are full eligible at 50% are specific intent crimes where someone knowingly committed, a jury or a trier of fact found that they knowingly intended to commit those crimes. The crime.
Yeah, we understand that.
So what I'm also indicating to you is that these crimes, when we say the sentencing guidelines, those are the guidelines that are presented to the sentencing court at the time of sentencing. And they are points on various sides for the behavior and whether or not there was death involved. And these types of crimes recognize that and would get two extra points in the guidelines, which would increase the Maryland sentencing guidelines. And I also just wanted to let you know that there are additional collateral consequences with the Motor Vehicle Administration, which doesn't often happen even.
Yeah, I was going to get to that. I did hear you say that. And let's be honest, those consequences, they can be, in your estimation, you're going to say they can be severe. I can say they're not far enough, whether they decide to revoke their license. However, having said that, as a PD, I'm sure you can say that you've seen a fair number of cases where people have been stopped and arrested for driving on a revoked license.
Yes.
Is that fair?
Yes.
So it's fair to say that the consequences you're speaking of hold no weight because people are still going to drive because they still need, that's the way that they figure they need to survive. So they're still going to find a way to get there.
Well,
and whether or not that means driving a vehicle in violation of a license doesn't matter.
Potentially under the circumstances where the person's license would still be revoked. If they were found guilty of that driving while revoked, they could be sentenced up to a year or potentially 2 years. And if they were on parole for the offense that we are speaking of, that would be a violation of their parole and they could be taken back into the prison system.
But we know that doesn't happen.
I don't
frequent
know.
basis?
As a matter of fact,
So what my point being
I
is,
practice on the Eastern Shore, so I
okay,
do know people that are sentenced to incarceration and to have parole retakes because my office has to handle, we do handle parole retake hearings. And we also handle those court proceedings.
and I appreciate that. So, and then I guess the last point I have or concern I have is that that's, Ms. Kurtz, you brought up about the review process, that there's a review process. And I find it honestly just patently insulting that you think that the review process that's in place when people are getting a notice of a parole hearing 7 months after they were incarcerated for killing someone, that you feel that that review process is sufficient.
The review process involved in a parole hearing in which there is a loss of life includes victim notification. It includes the ability of the state to enter information into their parole file. And it also includes a 2-commissioner hearing, which is not done in other types of nonviolent cases. The 2-commissioner hearing involves 2 of the appointed parole commissioners. They speak directly with the individual and they render a decision that day rather than being heard by a hearing officer, which is a much lower standard of review. So these cases are far more intensely reviewed, and they are reviewed by 2 people who are appointed by the governor and confirmed by this body.
Yeah, I mean, can you imagine though how shocking to your one's core it would be to bury a loved one and then 4 or 6 months later, after someone took your loved one's life, potentially the father of your children or your own child, and then you're getting a letter that you're now having to be re-victimized because now you're asked to put in a lot of work and re-victimizing yourself, and as you're still trying to heal, and it just doesn't, it seems like a flawed process to me. It seems like it's way too early. Part of the process should be, I agree that there's a due process. I get it. However, part of it should be that there's sentencing guidelines in place. There's penalties associated with it that we have in place that they're never going to meet because we let them out way too early. And I feel that that's irresponsible on our part. So that's really not for you to answer on. That's just me to say that, look, I appreciate your time. I appreciate what y'all do, but thank you.
Excellent. Further questions from the committee? All right, seeing none, thank you all very much. All right, I think with that, that'll end the hearing and the testimony for Senate Bill 87. I see that Senator Watson is here. Senator, we'll now hear from you, Senate Bill 100.
Good afternoon, Chair Smith, Vice Chair Wallstriker, members of the committee. Senator Watson from 23rd Legislative District, here to ask your support for Senate Bill 100. This is a very simple bill aimed at stopping a very real issue that is occurring each and every day. Let's talk about organized retail theft. What is it? It's a commission, either alone or in concert, with one or more persons of a series of thefts of retail merchandise from one or more retail merchants over a 90-day period, with the intent to permanently deprive merchants of merchandise, return the merchandise to the merchant for gain, resale, trade, barter, or in any other way seek gain from that stolen stuff. 4 months ago, 3 suspects were caught, 18, 19, and 26, with over 10,000 worth of stolen merchandise. They were connected to 10 separate thefts that occurred during a 2-week period. 2 shoplifters caught 3 days ago in Leesburg, Virginia, were involved in the theft of merchandise valued at over $158,000. Why am I talking about Leesburg? Because the 29-year-old female and 30-year-old male were both from Laurel, Maryland. Washington, D.C. is said to account for 68% more retail crime than you would expect based on a national average, and that has trickled into the state of Maryland. We have all seen television with the smash and grab and the tactics that are currently being used, where young folks with hoodies, old folks with hoodies, go in, break up everything, take as much as they want. We're not talking about Enfamil and baby formula. We're talking about high-end luxury bags, cologne, perfume, anything that can be resold. And where are they reselling it at? It's being sold on eBay. It's been sold out the back of barbershops. It's been sold on Nextdoor. It's been sold on Facebook. And most times it's just being sold by word of mouth. You need a TV, I'll tell you where to go get it. I have several people here to speak on the benefits of having this bill and why it is important and why it makes sense. But as I said to you before when I met, crime always takes the path of least resistance. And all throughout our region, each jurisdiction is looking at ways to address organized retail theft, and we cannot not take action and make it easier for the criminals to come to Maryland to do what they do. Let me just say, in the fight against organized retail theft, it is essential to recognize that this is not a victimless crime. Every stolen item represents more than just a loss for a business. It impacts the livelihoods of hardworking individuals and jeopardizes the economic health of our communities. You want another food desert? Let this continue. You want more crime in the neighborhoods? Let this continue. This has to stop, and members of this committee know about the broken window theory. If we do not act on this, it'll just get worse and worse and exacerbate. And then we wonder what happened because we didn't take this opportunity to take action at this time. With that, Mr. Chair, I ask this committee for a favorable vote on Senate Bill 100.
Excellent. Thank you very much, Senator. We're going to bring up some of the panelists unless anyone has questions for the senator. So I'd like to hear from, is Micah Newmeyer here? And then Sarabit Suri? Michael Holleran? And is Joyce King here?
Good afternoon, Mr. Chairman. For the record, my name is Mike O'Halloran here today representing MAPTA, which is the Association for Energy Marketers and Convenience Stores here in Maryland. I think the Senate sponsor did a fantastic job of setting up the issue and why this is important. To talk a little bit more about our industry in particular, which is the convenience store industry, as the senator also alluded to, very often in our communities, these operators are not just where you go to get your soft drinks and snacks, but they're also where you go to get your groceries, your milk. If your young one has an earache in the middle of the night, like I'm experiencing right now, you can go there and you can get your children's Tylenol. They are the beacon in the night. They are very often the grocer of last resort. And they are, faced with this crime wave that we're seeing. And in particular, we're going to talk about thefts of ATM machines. We are seeing this more and more and more. And it's not just, one-offs. These are very coordinated efforts. Frankly, it's military style precision. You'll see a team show up to the store, and each of those individuals has their role. So it is organized. Again, it is not just a simple crime of passion, if you will. So with that, I'll wrap up my comments. Again, thank the sponsor for bringing this bill forward and look forward to any questions from the committee. Thank you.
And my apologies, I didn't see the Miss Brave Boy sitting back there. You're hiding behind the podium. I didn't see you back there. So my apologies for not calling you up, and we'll get the state's attorney from Baltimore City up here soon as well. Thanks.
Hi, good afternoon. Thank you for allowing me to testify before you today. My name is Micah Newmeyer, and I am a market leader for 7-Eleven. I've worked for 7-Eleven for 10 years, and my territories include Lower Anne Arundel County, all of Prince George's County, all the Southern Maryland counties, as well as Eastern Shore counties, totaling 129 locations. I am before you today to ask for support of Senate Bill 100 as it relates to organized retail theft, and to ask for your consideration of reclassifying ATM thefts in this bill for many reasons. These types of ATM thefts are one of the costliest retail crimes we have faced. The brazenness of this type of crime is concerning, shocking, and impactful. In recent months, my stores have experienced 76 incidents of these ATM crimes. 51 of these occasions were repeat crimes occurring in the second or third time at a location. In many of these instances, not only was the ATM cash removed, but the store's network was also destroyed, rendering the store without the ability to transact business normally with credit, debit, and EBT. During that time, the customers were not allowed to enjoy the benefits of promotional pricing or the ability to purchase gas. The severity of the damage has often required up to 7 days and beyond to repair, as well as the escalating costs associated with those repairs. 7-Eleven is a multicultural franchise-based business. Many of the stores are owned by single store operators whose income is severely diminished, not only during the network outage, but also in the weeks and months to follow. The absence of a cash-loaded ATM and diminished customer trust causes further obstacles to the restoration of the historical sales trends, as well as the franchisee's income. Not to mention our most valuable resource, the employees who are frightened by these ATM thefts occurrences at their workplace. At 7-Eleven, it is our goal to serve the community by providing groceries, ready-to-eat food, as well as over-the-counter medications and other conveniences. Often we're the only retailer serving an area. We have continued to increase our locations in Prince George's County over recent years. Additionally, our network plan, despite these ATM robberies, will continue to be robust, as 7-Eleven will continue to have a presence in these communities. With respect, we ask that you please consider a reclassification of this crime as part of your deliberation on this bill. ATM machine thefts and related damages need to be addressed with a higher penalty.
Okay, thanks. Thank you very much. Thanks. Sorry, Mike.
Good afternoon, chairs and members. My name is Sarabjit Suri. I'm the franchisee with multiple stores throughout Maryland. We have been hit few times for the ATM robberies in Prince George's County and Charles County. In one of my stores, they drove through the truck and they cut the ATM. We were right away dropped 40% in sales, and now it's been 9 months. I'm still at 22% loss of my business compared to the last year. Very recently, this Tuesday, I was again hit in 2 of the stores in Charles County. And altogether, I've been hit 3 stores up to at this point. In addition to the immediate loss and damage to the merchandise, personal property, equipment, inventory, this incident has significantly impacted the image of the company, where it now seems our stores are not safe and are very common targets for such crimes. This incident has created a fear in my employees for their well-being and safety at the store. Not only that, but it has increased the concern for my employees' safety as well as my personal liability in that matter. As it is, reliable employees are becoming exceedingly hard to find and even harder to retain those employees. There is an environment of fear in our stores. These kind of incidences also reduce the store's foot traffic because local and non-local regular customers are afraid to simply respond to the negative impact of the robberies on the store's image. As a result, sales have severely decreased, creating a problem of high costs and low to negative gross profits. I would request every lawmaker here to please consider this matter very serious and make laws so we can serve our communities better. Thank you.
Good afternoon. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I'm here on behalf of State's Attorney Smith, who's the president of the National District Attorneys Association. While the NDAA cannot formally support, they did want me to relay many sentiments, and I am here in support on behalf of the Maryland State's Attorneys Association. So as a board member of the NDAA, this has been an issue that has been championed nationally because of its, as you've heard from the panel, its grave impact on our communities. Some of the partnerships that we've had with RILA provided great information. This is they estimated nationally $70 billion worth of products stolen through these organized crime thefts. That is a $15 billion loss to taxpayers. There's been an increase in these crimes crimes over the last 2 years from 14% to 23%. The MSAA supports these bills for many reasons. We've discussed this over the many years, and I have personally prosecuted organized theft schemes of baby formulas from establishments. And the difficulty is that it's falling within a gap. We're not able to proceed on multi-jurisdiction. We need this venue spelled out, as well as clarity in distinguishing these from just regular shoplifting. This is not regular shoplifting. There is no penalty increase. It clarifies the clear aggregation of the amounts in multi-jurisdiction, and something that MSA has done in the last year in preparation for a bill like this is that we've reestablished with the Attorney General's office the statewide organized retail theft task force with the AG. So every jurisdiction will have a task force member so that we can coordinate efforts, state, local, and federal with these efforts. So we think that this would be a great tool for prosecutors to really begin to prosecute these effectively. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed members of the Senate Judicial Proceedings Committee. For the record, again, I'm Aisha Braveboy, State's Attorney for Prince George's County, here today to support this very important bill. The Special Prosecutions Unit in my office prosecutes, amongst other things, organized financial and economic crimes. These crimes usually include predatory activities such as identity theft, computer fraud, and Ponzi schemes. The recent spate of events involving systemic looting of our region's retail outlets by identifiable organized crews, often wielding firearms and other deadly weapons, present a danger to our residents, visitors, and retail workers, and threaten the ability for our communities to be adequately served by retailers. Like Senator Watson said, this is not a victimless crime. Retailers make decisions on which stores to close and where to locate new stores based on crime trends. These decisions often deprive the most vulnerable communities with essential goods and services at locations convenient for the residents. The provisions proposed under Senate Bill 100 would provide a powerful tool for prosecutors to use in confronting the emerging challenge by allowing individual instances of retail theft committed in furtherance of an organized criminal scheme to be joined in one prosecution, even if the perpetrator committed such crimes in multiple Maryland jurisdictions. Otherwise, perpetrators are able to hide behind the legal fiction that each of their retail looting schemes somehow stand alone without connection to the organized criminal enterprise for which they are a part of. So thank you so much, and we urge a favorable report. Thank you.
Thank you very much. We have a question from Senator Sidnor for this panel.
For me, okay.
Thank you very much. Actually, I was going to answer it too. Good afternoon.
Okay, good afternoon.
The question that I have is I'm looking at page 2, lines 15 and line 23 and 24. And on line 15, it's the proposed bill speaks to multiple thefts committed by the same person. And on lines 23 and 24, it speaks to a series of thefts of retail merchandise. And I'm just wondering, as a prosecutor, would that cause you all any issues that, I mean, number one, when I look at it, I'm wondering, is there a difference between multiple thefts and a series of thefts, or is it supposed to be the same thing, or should we be using the same type of terminology?
It appears to be the same thing. We can look at this with the bill sponsor to determine whether or not we need to have more consistency in terms of the language, but it's meant to be the same thing.
So I know multiple is more than one.
Right.
What you all are looking for, is 2 enough, or are you talking 3?
Yeah, if it reaches that certain threshold, yes.
And what is the threshold that you all are looking for?
1,500.
No, I'm talking
I'm sorry.
about how many of these thefts have to happen before this bill, or that before someone would be, this particular tool would be used?
More than one, more than one.
More than one. All right, thank you.
All right, thank you both very much. We'll now hear from State Attorney Bates.
Yes.
I want to welcome.
Thank you.
And we'll hear from you first, and then we'll bring up the next panel. I see Ms. Locklear there as well.
Thank you. I'm here today to support Senate Bill 100, to express my support. This will address groups of individuals organized in their attempt at targeting various retail stores with the intent not only to steal, but in many instances, completely shutter establishments that are not equipped for this kind of financial burden that they have now unfortunately had to incur by such significant inventory lost. This is not a new phenomenon, but one in which that has simply grown in sophistication by keeping within the financial framework of the current law to ensure that if caught, perpetrators do not face severe penalties for stealing property under the current $1,500 threshold. They may steal $1,500 worth of items in one jurisdiction, Baltimore City, then go right to Baltimore County and steal $1,500 worth of items as well. This bill outlines the aggregated cost of stolen property in various jurisdictions ultimately far exceeds that amount. I know most people think that organized retail theft is targeting high-end stores and large corporations, but the reality of that these thefts have a pronounced local impact on smaller establishments that have long been staples in the communities they serve and lack the annual revenue to survive such loss. An example in Baltimore is the closure of Black-owned grocery store Apples and Oranges. This was an establishment that was for the sole purpose of servicing an area in East Baltimore that had been a food desert for years. The members of the March family they were owners of this establishment, and it's a well-known funeral home in Baltimore City. They decided to open this grocery store in 2013 to address the lack of affordable, healthy food options of their community. Within 2 years, the business had to close, not because of a lack of sales, but because of what was later found to be organized attempt at stealing high-end retail from this establishment, from costly baby formula and diapers to expensive packaged meat. While establishments such as Apples and Oranges don't fit the popular narrative we may see in nationwide news outlets, they are very much examples of strategic crime ring casualties. Retail theft hurts those stores that can't afford security personnel or expensive surveillance systems, the most prompting many of the crime rings to target our most vulnerable businesses, unfortunately focus on those communities. I support Senate Bill 100 and urge you to do the same for the sake of our local economy. Thank you.
Sorry. All right, we've got a question from Senator Muse.
Thank you very much and welcome. Just one question. When we talk about, I'm trying to make a distinction between those persons who absolutely deserve to be prosecuted and yes, go to jail. Those kinds of crimes and high-end crimes, et cetera. Now, just one question when we talk about grocery stores. In your opinion, just from those that you have prosecuted, I'm just trying to figure out, I know why somebody would steal a roller, watch and sell it. But are these folks stealing because they're hungry? Not that there's no excuse for it. But are they doing that because they're hungry? Are they doing that? And if so, is there something to help make that distinction so that they're not being punished the same way as those who have made pretty much a career out of that? I say that because I was homeless and as a kid, and when I lived on the street, I probably still owe Lexington Market to this day. But it's too late to pay him now, so I can say it. But
statute of limitations.
Because I didn't have food. Right, it's out there now. But because I didn't have food, I had no malintent and no alternative. And had I been caught, some things would have happened to me, that I don't think I would have deserved. And I'm just trying to make sure that we've made some kind of distinction in that manner.
Well, no, I think there's definitely a distinction between individuals that are doing it because they're poor and hungry. Without a doubt, those are individuals that we'd focus on in a different light. But there's also a
Gotcha.
difference between seeing a group time and time again.
That's
the
correct.
same group of individuals, whether they do it in Baltimore City, then they go to Baltimore County, to other jurisdictions, Howard County. Those are the individuals that this type of law is really focused after. It's not focused at the individuals that are poor and just trying to feed themselves.
Right.
Totally different. And as a prosecutor, my job is to make sure I deal with those individuals a lot differently, understanding their needs as individuals.
Thank you very much. And thank you for letting me get clarification on that.
Thank you.
Excellent. All right, we'll now hear from is Ms. Locklear here, Brian Gambernini. Justin Rice. Matt Vendimo.
I think he's going to be on Zoom, Mr.
Oh,
Chair.
he's on Zoom. Okay.
Yeah.
And then Laura.
So good afternoon, Mr. Chair, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance in strong opposition on this piece of legislation. The issue of organized retail crime is not new to many of you. The media attention and the impacts on communities has really ballooned over time. Oh, no, opposition. I'm so used to opposing. Oh, my word. We are here in strong support. I've talked to all of you. You know that.
I looked
Oh,
to
my
your
Lord.
left and to your right, and I was like, oh my
I'm
God.
so not used to saying support. Oh, my Lord. All right. Well, thank you for that. We are
We'll give her a
definitely
couple
here
extra
in
seconds on
support.
that. Yeah. You just restart it.
Oh,
It's
my
fine.
word.
Okay.
And actually organized retail crime has ballooned to an over $100 billion issue in the United States. So why should all of you care? The impacts mean higher prices for American consumers, less sales tax revenue for state and local governments, increased costs to law enforcement and our judiciary system, the financial impact to businesses and loss of anchor stores and communities that provide access to food, pharmacy, and other much needed goods. It feeds other illicit crimes as it is a very easy way to make money quickly. And finally, the health and safety aspect. And I heard baby formula come up here. In many cases, stolen food products, baby formula, pharmaceuticals, and other consumables that are not maintained by thieves under proper conditions or labeled properly become a problem. Because when these criminal operations fence these goods and sell them, they make their way back to unsuspecting consumers, and they may be ineffective or even make people sick. The majority of states, yes, red and blue, have passed aggressive organized retail crime laws, leaving Maryland as one of the last to merely even define it or track what's going on in our state. Criminals easily avoid felony theft by stealing from multiple jurisdictions, and this bill merely allows theft to be aggregated within a 90-day period. This committee and the Senate unanimously, 2 years in a row, passed a very similar bill, and we are going to urge a favorable report on this legislation, and I am glad to answer any questions you all have. Thank you so much.
Excellent. We'll take questions at the end of the panel.
Thank you.
Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Brian Gamberini, and I'm the Senior Manager of State and Local Government Affairs for the Home Depot. On behalf of nearly 10,000 associates at 41 stores and 59 facilities across Maryland, I am here today in support of SB 100, legislation sponsored by Senator Watson, targeting the issue of organized retail crime. SB 100 is a critical step that Maryland can take to stop this brazen theft. Our ORC presents an enormous challenge for retailers and consumers. As a low-risk, high-reward operation that appeals to criminal organizations, ORC poses both a financial and public safety risk. ORC is not petty shoplifting, nor is it victimless. It is a sophisticated operation where career criminals orchestrate the theft of large quantities of merchandise, typically targeting items that can easily be stolen, resold, and monetized. These criminals are savvy and exploit the law, retailers, and the public trust for financial gain while putting the safety of our consumers and associates at risk. Many have asked if retailers and media are overhyping the problem. The fact is that retailers were faced with many challenges over the last couple of years, but ORC is one that has grown over time and that has caused the Home Depot and many of our peers to take measures that we would not have considered years ago. We have been locking up product, employing off-duty police officers and security guards, and putting police cars at the front of our stores with many other tactics. Despite these efforts, the problem continues, and we have tragically even lost associates to these encounters. SB 100 gives prosecutors in Maryland the ability to aggregate crimes across jurisdictions. Criminals do not discriminate between stores, the size of the cities. ORC happens everywhere. We ask this committee to take decisive action to prevent the increase in ORC in Maryland and ask for a favorable report on SB 100.
Good afternoon, Mr. Chairman, members of the board. My name is Justin Ricemore. I am a commercial real estate broker with Coldwell Banker Commercial, and I am also a former law enforcement officer with the Metropolitan Police Department, serving our great city of Washington, D.C., 3rd District and Northwest Corridor. During my time on patrol, I worked midnight, and this was a very trying time as an officer. You're in the middle of the night, and you are experiencing a situation where not only are people trying to protect their families and support their families, but you're also trying to protect and support the community. During my time as a police officer, I actually witnessed ORC firsthand. The J. Crew store on 14th Street Northwest sustained $10,000 worth of retail revenue that was stolen at around 2:30 in the morning. It was unfortunate because that next day, employees could not go to work, which left them not able to support their families. Myth that ORC only targets large established brick and mortar businesses. That is not true. That is false. Small mom and pop shops, startup businesses, we are all affected. Everyone in this room is a consumer, which means we are all victims. Organized retail crime is not just a petty shoplifting. It is coordinated, sophisticated, and targeted retail theft, usually carried out by organized criminal networks, where substantial quantities of high demand products and stolen resale goods. Just last week, Mary Bowser in Washington, D.C. spoke about this in the Columbia Heights corridor of 14th Street Northwest, where consumers are outside of major retailers or Target reselling the same goods that our community needs, and there was no repercussion for that. According to the National Retail Federation, we're looking at still $100 billion in inventory that has been stolen. And with that being said, I would like to say thank you for your support and moving forward with this bill. Thank you.
Good afternoon. My name is Laura Dehoney. I'm an analyst with Anne Arundel County Police. I investigate, initiate, assist, and testify in property crimes, including retail thefts. As a civilian in law enforcement for more than 30 years, I'm not only concerned with the uptick in retail thefts, but the brazenness and aggression too, as well as links to other criminal activity. Even value amounts are increasing exponentially and forcing stores to close. While working on cases, I've watched videos of thefts. I saw entire displays wiped out within seconds. One where suspects used hammers to break glass displays, pushed and knocked over other displays. Customers were running out of the store with look of terror on their faces, and employees were ducking for cover. In addition to terrorizing customers and employees, there's also a correlation between retail thefts and human trafficking, showing that this is not a victimless crime. Loss prevention has reported suspects being forced to do retail thefts just like some are forced into prostitution. It's costly in many ways. A couple of financially costly cases I've worked on myself recently are where an adult male stealing perfume from Ulta beauty stores across the region. In Maryland alone, he committed thefts in 6 jurisdictions for a total of $44,603 just over the past several months. Another adult male stealing tools from Home Depot stores along the East Coast. In Maryland, he's been identified in thefts in 7 counties. Based on information obtained in this investigation, he alone is responsible for the thefts of $582,265 worth of new tools just since 2022. These men are professional thieves, like many others. Due to staffing shortages, however, it's difficult for stores to have representatives attend multiple court hearings for these people. If cases are merged into one county, it would save valuable resources for both loss prevention and law enforcement. For these reasons, I fully support Senate Bill 100 and believe it will benefit in convictions and deter ongoing retail thefts. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you all very much. Thanks. All right, we'll hear from, we have one more witness joining us virtually. Matt Vendimo. Demio, are you here? Is he here? All right, so then with that, that'll conclude the hearing, and no, just for the proponents of the bill, we'll now hear. Hold on, we're checking to see if he's coming in on Zoom. There he is. Matt, you're up. You can hear, if you can hear us, you can unmute yourself and we're ready to go. Welcome.
All right, thank you. Can you hear me now?
We can.
All right, thank you for having me. My name is Detective Matt Vendemio. I'm with Montgomery County, Maryland Police. I work out of the Wheaton District, and I've been involved in organized retail crime and shopliftings for over 10 years, maybe 10 or 12, 14 years. Reference Senate Bill 100. I think this would benefit investigators and prosecutors, so we could just prosecute in one county versus multiple counties. This would help us with, so it wouldn't tie up so many resources where you would need multiple different attorneys looking into this, multiple detectives. What I would think this would be good is get the detectives to build our cases up, establish probable cause, then pitch this to one attorney in one of the counties that we would have this prosecuted in, as opposed to multiple different county attorneys on different levels in the district level and on circuit court. Looks like we'd be able to agree on where the jurisdiction would be, and this would make it a lot easier. This would help with also with a global plea or even just a one trial as opposed to having multiple trials in different jurisdictions. We're in the DC metro area, so we get a lot of cases with Montgomery, PG, Howard County. I just worked a case recently with a prolific shoplifter who's been hidden for about a year. He's upped his game with some other stuff, but we were looking for this guy for a year. We couldn't find him. And now I'm getting calls from different attorneys, emails from different counties, seeing if we can, try to do different things. But without this bill passing or this law passing, this is what we would really need to help this. So I think this would benefit a lot. I'm seeing a lot of these types of guys that are just crossing different jurisdictions in national cases, but a lot in the Maryland cases. It doesn't have to be somebody from out of town. But sometimes it is, or from a different country, but we're seeing them hit one jurisdiction and another, and I think this would help a lot.
So thank you very much. Questions from the committee? All right, seeing none, thank you very much. Thank you for your patience. All right, that'll conclude the testimony for the proponents of the bill. We have one person signed up in opposition. Is Mr. Rydlick here, the Office of Public Defender?
Good afternoon. My name is Richard Rydelick. I'm a public defender in Prince George's County. I've heard the arguments that were put forward by an array of corporate interests and law enforcement. And I've heard with particular interest the indication that the state's attorney in my county would enforce felony prosecutions for as little as 2 occurrences by a single individual against a single store. The concern I have is that we're already a nation that incarcerates a larger population, a percentage of our population than any other country, I think, except China. And this is going to add to that by amplifying what in many cases are simple petty larcenies and creating a felony where before none existed. And they're occurring by aggregating various offenses within and without various jurisdictions. And it's important to note, and this is what I was afraid would not be understood, that that violates some very fundamental principles of evidence and fairness at trial that cannot be cured if all of the individual instances are being tried in a single prosecution in a single jurisdiction. It's a longstanding and well-founded law that very wisely precludes the introduction of evidence in individual cases from individual instances in a single case. My concern is that this statute could very easily be misapplied to individuals who commit repeated offenses, who include the mentally ill, the homeless.
Mr. Ridelet, if you could just.
Thank you.
Thank you very much. Thank you. I think there are a couple questions for you. Senator Folden.
Thank you for coming, Mr. Ridelet. Thank you, Mr. Chairman. So my questions are pretty succinct. If any one person goes into any single jurisdiction and they go to Home Depot, they go to J. Crew, they go to any store within the jurisdiction and they steal over $1,500 worth of items that are not theirs, what is the, you know what the penalty is for that? Associated consequence. It's a felony or a misdemeanor.
It's all directly tied to the total value of the merchandise stolen, and there are various levels by statute that establish where the dividing line is between the misdemeanor and the felony.
That's what I asked. So if you go to any store in any single jurisdiction and steal more than $1,500 of items that are not yours or worth of items, it is a felony?
Yes, that's correct.
Anything less than that is a misdemeanor, right?
Correct.
Okay, so are you aware that there are certain areas in this state that will have, such as 4 counties come together at Montgomery, Howard, Frederick, and Carroll in one little tight nexus of an area? You understand?
Yes.
And are you familiar that all those areas relatively close to that intersect have Walmarts, Home Depots, and the like?
Sure.
And if somebody went to each of those locations and stole $1,499 in each one, you could get basically $6,000 worth of items within a very short period of time, right?
This is an interesting hypothetical, but go ahead.
It's actually real. It's happening in the state, sir. They're jurisdictional jumping. They're going and stealing things from one jurisdiction to the next, rising to the level far above the minimum amount necessary for a felony. But because even though it occurs in our state and all the charges come from the state, we have jurisdictions individually, each county, that create or are prohibitive from charging them with a felony, even though it's that amount. Is that true or not?
It's the state of the law, and it's correct.
Correct. So we can't charge them with a felony, even though in a short period of time, if they jurisdictionally jump, you could be well over the minimum amount and steal a felonious amount of goods.
Theoretically, this sounds like a Fox News segment to me.
Does it?
Yes.
It's not. It's me. I'm just asking the question,
Okay.
sir. Can we answer it?
Well, what I'm saying is that that's a hypothetical, and the state of the law is set up to deal with individual offenses, aggregating offenses, to create a phony felony, super felony from multiple instances violates very fundamental jurisprudential principles that is going to affect directly the rights of individual defendants. And as I've indicated, my concern is that many of those people will be the most vulnerable in society.
So again, thank you for your additional info. Your feeling is that repeated petty theft to the value of $1,500 in multiple jurisdictions in a short period of time does not rise to the level of
Well-
felonious act or a theft scheme that should rise to a felonious act?
I have serious questions about how short period of time, the number of offenses, what constitutes organized retail theft when it doesn't even have to be an organized unit of individuals. It can be a single person.
And they have organized a way to manipulate the system so that they do not have any charges more than a
Well,
misdemeanor.
the system can be manipulated in both directions. And my concern is that a law like this is going to allow elements of state's attorney's offices to use a constructed felony against individuals in a disproportionate way. And proportionality has everything to do with it. If an individual offense is prosecuted, the laws that are set up and exist already to handle each individual instance need to be applied. And if it's burdensome for the courts to deal with them individually, that's the price of doing business for government, and it's the price of doing business, frankly, for these retailers.
Actually, it's not. That's what this body's for.
Well,
to change the laws when we have new criminal activity afoot. It's exactly what this body's for. So I thank you for your time, sir.
Okay.
Senator Sidnor.
Thank you very much.
Sir, if you could come back on.
Good afternoon.
Sorry.
I was just looking through the testimony to see if there was anything in writing and didn't see anything from the office. So I'm curious if you may mention that this type of legislation may have constitutional issues. Would you mind going into that a little?
Yes. There's a important principle that in terms of evidentiary questions, an individual who is charged with multiple offenses, even when the state's attorney's office attempts to create some connection between the behavior, and even when sometimes the incidences themselves are close together in time, that evidence is kept out from the separate prosecutions for very good legal reasons.
Is there is there a citation that you might be, and I'm not,
well,
that you might be able to point us
it's
to?
the idea of the severance statute that says multiple incidences should not and must not be prosecuted together in the same prosecution, where there's a danger that bringing in evidence of these multiple incidences, which would not be admissible in the individual trials, must be kept separate to prevent juries from, number one, hearing evidence from a separate incident and risk applying that evidence or inferences that they could take from that in the other incidences. So the idea that aggregating these offenses, not only from within, but from separate jurisdictions, is offensive to this really fundamental notion that helps individuals get a fair trial.
And is that case law, is that statute, is that rule? I'm just trying to figure out where I would look just to help me to better understand what you're arguing.
Well, the rules of evidence in the criminal law and the rules regarding severance for criminal trials are really the fundamental place to start with that. And I can, if you would like, I would be happy to provide you with more information regarding those principles.
That would be great. I mean, because I know we have testimony from the Attorney General's office in support of this. And so Your argument is the first that I've seen, so I'd like to read for myself, so thank you.
I would be very happy to.
Thank you, sir.
We're not, sorry, sir. I wish it was that easy, but we've got a couple more questions. But also whether it's a statute or a rule, I'd like to see that as well, as you wanted, just for our own reference. But if you could, get back to council and I can distribute that to the rest of the committee when appropriate. Senator West and then Senator Folden.
Thank you, Mr. Chair. I must admit I'm befuddled by that argument that you made. It seems to me our anti-crime, our not anti-crime, I've lost my track. Our laws about organized crime have all been at the federal level and the state level have been premised on the fact that organized crime engages in multiple criminal acts. And when you're going to try to convict someone for engaging in organized crime, you necessarily have to introduce at the trial evidence of the various criminal acts that constitute the organized crime. Are you claiming that our laws about organized crime are all unconstitutional?
Possibly.
Okay, well, thank you very much.
Last bite at it, Mr. Chairman. So I will say that there was a under the 2010 there was a legislation that was passed that was brought forward, and it actually talks about that notwithstanding any other provision of the law, and it kind of goes to what my good friend Senator Sidnor was saying about and why the state's attorney or the AG may be in support of this, which says notwithstanding any provision of law and circumstances in which violations of this section are alleged to have been committed and more, and this goes back to the criminal that in more than one county, the respective state's attorney of each county or the attorney general may join the causes of action in a single complaint with the consent of each state's attorney of having jurisdiction over an offense sought to be joined. So your interpretation of that is that you're telling me that it's earlier that they legally by constitution or whatever you're saying, but there's measures like this in red states, blue states across the country because of the increase we're seeing in these type of thefts occurring. It's still your opinion that even those that have passed it and already have measures in place, as well as the language that was just read to you, is inconsistent with constitutional law?
Yes, I mean, I am representing the rights of the individuals who are charged in these instances, and the evidentiary principles that I try to protect on a daily basis are well established, and the courts are vigilant. They understand how important it is to prevent a jury from hearing evidence regarding one individual action that is not appropriate for the judgment of the jury on that action, particularly when there's an attempt to join other separate incidences. It's important that these things be tried separately in order for anybody who stands accused of getting a fair trial.
But your opinion goes contrary to what is actually acceptable under organized crime issues and statutes. And in keeping with the Attorney General's responsibility to safeguard, the businesses and the state of Maryland's, to prosecute those that are preying on the state of Maryland and their businesses and the business climate that we have. We're going to agree to disagree.
No, but
I appreciate.
I will certainly agree that when it comes to organized professional outfits.
I didn't realize there was a training program that got you that level.
Well,
it
certainly isn't required in this proposed bill.
So you'd be willing to work with some language that would meet the goal of this? That would be satisfactory.
Sure, of course.
Okay. Yes. Well, good. Well, I look forward to that conversation. Thank you. I appreciate it.
No, thank you. I appreciate it.
Thank you very much, Mr. Reddle. I know that we had a good exchange on a couple of interesting theories and interpretations, but I would really like concrete examples or, a crisp interpretation of either, a rule or a statute would be helpful, or a case that exemplified some of
I
the.
fully intend to follow up.
Excellent.
And I'll provide everything that I can.
I appreciate it. Thank you
All
very
right,
much.
Thank you very much.
Thank you very much. Thank you. All right, we have one more witness joining us virtually. Ms. Ryder from the Prince George's County Office of the Public Defender. Welcome. Thank you for being patient with us.
Welcome. Thank you very much. My name is Kimberly Ryder. I'm with the Office of the Public Defender in Prince George's County. I strongly oppose this bill, and my focus is on fairness within the trials. Theft schemes can already be prosecuted. Thefts can be prosecuted. Right now, I'm concerned about how the juries are going to be reaching convictions under these changes in the legislation. I'm concerned about juries focusing on the reputation of counties, or even the canvas of criminal activity created by the prosecution from a broadened definition of what constitutes a quote, continuing course of conduct, unquote. Also, that initial impression offered to a jury that when a defendant is charged with a bunch of crimes beyond a single jurisdiction. When I first started, I wasn't in Prince George's County, I was in Charles County, and a frequent refrain that I heard is, our county, Charles County, is harder on crime than Prince George's, a concern that rural police departments take small crimes more seriously. So let's say that in a case, there's weak evidence in a case in Prince George's County, weak evidence in a case in Baltimore, and you have a smaller county where maybe Culver County, for example, there's video evidence against a person's caught on the scene. A case that spans across different jurisdictions, across different counties, we can look at jurors actually questioning the rigor of the law enforcement in Prince George's County. That can work both ways. There are lots of TV shows, lots of misperceptions where you see bumbling small town police officers, and that people can go ahead and take that judgment and end up looking at those police investigations, the adequacy of the evidence, and taking a look at the evidence in their county and thinking that it's worthwhile. You have a layering of police officers, a layering of investigations. I also very quickly just want to note that McKnight v. State, in addressing a question that was asked to Mr. Rydelic, I realize my time is up, but if I may just give you the citation of McKnight v. State.
No, that's great. Thank you.
Sure.
Actually, that was a question I was going to ask you as well. So thank you. McKnight v.
Thank
State.
you.
We're gonna have counsel look at that.
There's a lot that ends up being, I love the wording of McKnight v. State. When I have been arguing severance in cases, I've quoted this case over and over again. Their Supreme Court case is also on point. But it goes to how reputation of the client can be a huge concern. Confusion of the defense can be a huge concern. And we also are looking at the tendency sometimes of the jury to look at the cumulative effect or aggregate evidence. So McKnight v. State, 280 Maryland, 604, it's a 1977 case, still good law, states that, quote, first, the defense may become embarrassed or confounded in presenting separate defenses. Secondly, the jury may accumulate the evidence of the various crimes charged and find guilt when, if the offenses are considered separately, it would not do so. At the very least, the joinder of multiple offenses may produce latent hostility, which by itself may cause prejudice to the defendant's case. Thirdly, the jury may use the evidence of one of the crimes charged or a connected group of them to infer criminal disposition on the part of the defendant from which he may also be found guilty of the crimes charged, unquote. And there's
Thank you for that. Thank you for the citation and thank you for that, the recitation. We're going to just ask the committee if there are additional questions.
Thank you.
Excellent. Thank you. We've got that with counsel and we will fold that into the bill file. Thank you.
Thank you.
All right, seeing no further questions, that'll conclude the testimony in the hearing for Senate Bill 100. All right. All right, we're going to hear Senate Bill 39 next. Senator Reedy is here.
Mr. Chairman, I have
Sure.
Sheriff Jim DeWeese here with me. If I could bring him up.
Yes,
as part of the
absolutely.
Panel. Thank you, Mr. Chairman and members of the Judicial Proceedings Committee. It's great to be back before you. I miss this committee room at times. Other times I don't miss it as much, depending on what time of the day it is. But it's always fun to be here and listen to the questions and get a little bit of flavor before coming up here. And it's interesting, we were talking, of course, you're talking about retail theft and the theft statute. Senate Bill 39 is really common sense legislation, and this committee has moved at least part of this a couple different times as parts of other bills. But Senate Bill 39 would make the theft of a firearm, it would classify that as a felony offense. It would remove it from the theft statute and make it a felony offense. The first conviction would impose a 5-year prison sentence and or $1,000 fine. I think everybody on this committee is pretty familiar with the issue, because we look at how things are valued in the theft statute. Quite often, someone could steal a firearm and it be treated no differently than if they stole a piece of inexpensive furniture or some clothing. And that's really unacceptable when you consider that stolen firearms are very, very often the source of additional crime and particularly violent crime. In all of the discussion that we hear here in Annapolis year after year about gun violence, and we all agree that violence and crime are things we take very seriously and are concerned about, it's really time for the General Assembly to take action to treat theft of a firearm the way it should be treated, which is a very serious and felonious act. I do know, of course, that the issue has not always been here in this body. But I do ask for your support for this legislation. The most recent statistics we have on stolen firearms was that between 2017 and 2021, there were nearly 5,000 stolen firearms. If you consider how sort of low activity people were having in 2020 and 2021, I think the numbers, it's safe to say, were probably worse since then. Finally, or additionally, the Gonzalez poll that just came out shows 89% of Marylanders think it should be a felony to possess a stolen firearm. And so that ties into the fact that it should certainly be a felony to steal a firearm. And so we want to be sure that we have real serious penalties for this very serious crime. Nearly all of a large percentage, you all know, of the murders that are committed usually with handguns and most of the time, almost all of the time, with handguns that have been obtained illegally, sometimes stolen, sometimes trafficked, but obtained illegally. And so I asked for the committee to give a favorable report to Senate Bill 39, and I'm happy to answer any questions, or I could turn it over to my witness who's with me here today. Oh.
Thank you, Chairman Smith, Vice Chair, members of the Senate Judicial Proceedings Committee. I'm Carroll County Sheriff Jim DeWeese. I appreciate you giving me a couple of minutes to speak in favor of Senate Bill 39. I'm the elected sheriff in Carroll County. I'm in my third term. As sheriff, I oversee both law enforcement and corrections in my county. And for the record, I'm also a retired captain with the Maryland State Police, having served 25 years as a state trooper, honorably retiring in December of 2014. In support of Senate Bill 39, it's no secret that firearm sales in the state of Maryland and across the United States have surged over the past several years. In Maryland, the right to obtain a concealed carry permit was made easier for law-abiding citizens, meaning more firearms, especially handguns and motor vehicles, increasing the likelihood of thefts of those firearms from those vehicles. According to the ATF, more than 1 million firearms were reported stolen to law enforcement in the United States between 2017 and 2021. It's an awful lot of firearms. Most of these firearms were stolen during burglaries and thefts from motor vehicles. In most cases, guns that are stolen are first sold on the black market before they are used in the commission of a crime, meaning that many thieves that steal from homes or cars have no specific use for the gun other than to sell it for profit on the black market to those that do have a specific use for that firearm. Semi-automatic pistols are by far the most common stolen firearm, accounting for over 70% of all reported firearm thefts in the United States in the past 5 years. ATF records show, as the senator said, that an average of 1,130 firearms were reported stolen from private citizens in the state of Maryland each year between 2017 and 2021, with only a quarter of those firearms being recovered. CBS, the Baltimore Sun, Gonzalez polling, all of these outlets have reported that there is an overwhelming amount of citizen support to have stricter laws for individuals possessing guns illegally, including individuals that are in possession of firearms that are stolen. It seems counterintuitive that a state that has some of the strictest firearms laws in the country looks at possessing a stolen firearm as simply a misdemeanor. I ask that you report in favor of Senate Bill 39. Thank you.
Excellent. Thank you very much. Questions from the committee? I know Mr. Penick is up next. Excellent. So come on up, and then if you want to hear from Mr. Penick, then we can do questions and we can have all three. I think this is the last witness, so then we can do that.
Thank you, Mr. Chairman. Mark Penick, President of Maryland Show Issue. We join with the sponsor in supporting this bill vigorously. We've supported it in the past. We know that the committee has passed similar legislation. In particular, the problem of theft has gotten worse because so many of the gun laws now permit you to carry with a permit, but Maryland law encourages you to store your firearm in places where you can't carry it, thereby exposing that firearm to theft from a vehicle. An untold and unintended result, but still a real risk. I note in passing that it's odd to me that theft of a firearm is punished for less than $1,500, is punished as a minor misdemeanor for which no jail time is ever imposed, while possession of a stolen firearm is punished with 5 years under 5-138 of the public safety article. Now, that's really odd. You would think that 5 years would be equally applicable to the crime that led to the possession. But the way it works is you steal and then you flip these guns and they become crime guns. Nobody wants that. So we would support taking a paragraph out of SB 404, which is the chair's most recent bill, which makes it a felony to possess a stolen firearm, and importing the same underlying principles into this statute, this bill, and making it a felony and punishable by 5 years for the theft of a firearm, thereby punishing both ends of the supply line. It just makes sense. I'm happy to take any questions. Thank you.
Thank you, Mr. Chair. Senator, so look, we've had these discussions, and I know we've had discussions even with the chairman, and I mean, wouldn't you say that it's kind of like the bill we just heard about a little bit ago with the violent deaths that people are sustaining and having not measurable, really being accountable sentences consistent with the violence of the death that they suffered. They're dealing with misdemeanor and it's not a crime of violence. Whereas ironically, this bill looks to we have a handgun or a weapon that is stolen, and because the value itself is not exceeding of $1,500, yet that weapon itself has the high potential of creating much violence across the state. Not one incident like the car that we spoke about earlier, but could be used multiple locations and multiple rounds. So, I mean, I think it's really good time, and I'm glad you brought this bill forward, that the theft of a firearm, it should and can no longer be only considered by the value of the weapon itself, but we must now consider the threat that it poses to our communities in our state. Would you agree with that?
I would agree, yes.
Thank you.
And when you think about the theft statute, someone steals an articles of clothing or food, they're going to either consume and wear that themselves or perhaps flip products for money. They may flip a gun for money, but the person they're selling it to, it usually doesn't have, somebody's not stealing a handgun to put it on their mantle as a collector's item. And so I think it's really important that we try to treat that as seriously as we should. So yes, I agree.
Thank you for bringing the bill forward.
All right. Additional questions for the committee? All right. Seeing none, thank you both very much.
Thank you, Chairman.
Mr. Penick, maybe you know this. So right now, under current law, theft of possession of a stolen firearm is the 5-year misdemeanor, which makes it a prohibiting offense from prohibiting firearms in the future. But if you are also the one that stole that firearm under current law, would that merge, or can you be charged with both?
They wouldn't merge because they are separate offenses. One has a mens rea requirement, the 5-138, so it's a knowing possession of a firearm. Can't merge that with the simple theft statute, which is now punishable by reference to the amount of money that the value of the item. So I don't think those are mergeable.
You don't have to have another. Thank you very much.
And it's odd to me that one would be disqualifying and
one's not disqualifying.
One's not.
That's yep. Thank you very much for that. Okay, that then will conclude the hearing for Senate Bill 39. We'll now hear from Senator West with Senate Bill 379.
Thank you, Mr. Chair. It's a pleasure to be before you today to present Senate Bill 378, which is virtually identical to the bill we just heard, except there's one significant difference, and I'm not sure why it exists. I think the DLS drafted Senator Reedy's bill to refer to theft of a firearm and drafted my bill to refer to theft of a handgun. They're each separately defined in the criminal code. So I'll have to work with committee staff once these two hearings are concluded to find out which is the better definition to use in the bill. With that exception, I think the two bills are virtually identical. So let me present mine, and I don't think I need any witnesses here because you've already heard the witnesses, and there's no opposition to my bill. So I'm going to be fairly brief in the description. So under existing law, the penalty for the theft of a firearm is covered by our general law against theft of property. In such cases, the penalty imposed upon someone convicted of theft is based on the value of the property stolen. So the theft of a handgun worth $250 is merely a misdemeanor and carries with it a penalty of $500 or 6 months in jail, or both for the first offense. And for the second offense, the offense is once again a misdemeanor and the penalty is $500 or 1 year in jail, or both. The theft of a $250 handgun under Maryland law is thus treated identically to the theft of a $250 vase. Both are misdemeanors. Both result in de minimis fines or modest time behind bars. Of course, the stolen firearm is far more lethal and far more dangerous than the stolen vase. But under our current law, both crimes are treated identically. Over the past several years, the Judicial Proceedings Committee has repeatedly considered legislation to prevent firearms from falling into the wrong hands. And most of these bills have targeted citizens exercising their Second Amendment rights who own guns and who transfer the guns, either lend them or sell them to other people, most of whom are honest, most of whom are not criminals. By contrast, this bill focuses exclusively on criminals, and worse yet, criminals who steal guns. The problem of stolen guns on our streets is a serious one. Any attempt to reduce shooting deaths has to start with the fact that many criminals who use guns to commit crimes and kill people are doing it with stolen weapons. Bureau of Alcohol, Tobacco, and Firearms has found that stolen firearms are, I'm quoting now, a threat to community safety as well as law enforcement, close quotes, and that stolen firearms are crime guns. They fuel illicit trafficking and are used by violent criminals to terrorize our communities. Given these facts, Maryland's law dealing with the theft of a weapon with little more than a slap on the wrist is absurd. Now, let me briefly explain the bill. It removes the theft from the theft statute, the stealing of a handgun, and creates the new crime of theft of a handgun. Such a theft is branded a felony. For a first conviction, the penalty for theft of a handgun is a fine of up to $1,000 or 5 years in prison or both. For a second conviction, the penalty rises up to $2,500 or up to 10 years in jail or both. And because the theft of a handgun now becomes a felony, a person convicted of theft of a handgun will fall into the category of a disqualified person or persons under federal and state law who are prohibited from ever illegally owning a firearm. There's another benefit that hasn't been discussed previously that will arise due to this bill. Far too often, firearm thefts are currently never prosecuted by our state's attorneys because they're merely misdemeanors. Once we elevate thefts of firearms to felonies and place the focus on the criminal and the criminal behavior instead of the value of the item taken, our state's attorneys can be expected to give these cases the serious attention that they deserve. So in the past, this bill has been introduced and it's had a mandatory minimum associated with it. I've talked to the members of the Maryland Judiciary. They always oppose mandatory minimums. So you'll find that this year's bill does not contain mandatory minimum language. There is no opposition to this bill. And with that, I'm happy to submit to questions and would hope that the committee would favorably pass this bill. Thank you.
Excellent. Thank you very much, Senator. Questions from the committee? Seeing none, thank you very much.
Thank you.
Did you want to bring the witnesses up, or you've heard the same testimony, so it's fine, right? We're good to go?
Be the same witnesses unless they want to testify, Ken.
I think that's just fine. All right, thanks a lot. All right, with that, that'll conclude the testimony in the hearing for Senate Bill 378. We'll now hear from Senator Sidnor if he's ready with Senate Bill 111. And if the panel would like to come up, let's see, Ms. Jordan, Ms. Feinstein, and Mr. Schellenberger. There's a space for you there as well. Done. How you going? All right.
That's it. All right. Good afternoon, Mr. Chair and colleagues. Senate Bill 111 strengthens Maryland's current law by providing just two simple things. First, Senate Bill 111 requires a party or non-party redact any identifying information, which is a defined term within this legislation, regarding a minor victim, another defined term under the legislation, in electronic or paper court filings, unless a court finds by clear and convincing evidence that there's good cause to order its release. Number two, Senate Bill 111 permits the Supreme Court of Maryland to adopt rules requiring or authorizing the person making this particular request under the 11301B2 redacted filing to also file an unredacted copy under seal from the general public's view, but available to those persons necessary or related to the cause subject to the court's authorization. The National Crime Victims Law Institute explained the importance of privacy for child victims as follows. Privacy is like oxygen. It is a pervasive, consistent need at every step of recovery. Within the context of the legal system, if a victim is without privacy, all other remedies are moot. Whether one is discussing a child victim's counseling records, Facebook, emails, or cell phone records, compelled disclosure of the child victim's private information may cause the child to feel vulnerable and unsafe. The general rule is that the defendants have no constitutional right to pretrial discovery and that victims have rights that protect against disclosure of personal or private information. Child victims have often felt that justice re-victimizes them. Thus, special protections are essential to prevent future trauma. Children, like adults, have a right to privacy. Without protections, identifying information is available for public disclosure. The release of sensitive information without procedural safeguards may, one, endanger the child and cause the child shame and humiliation, discourage the child and future children from coming forward and disclosing information, leading to stigmatization and undermine the child's trust. SB 111 is not some sort of bold and original piece of legislation that courts do not know how to handle. and I know one of my witnesses within their testimony talks about this. When implementing such policies, most courts utilize standing orders and procedures to implement the policy and protection. For example, in the federal court system, all court filings disclosing the name or other information concerning a child, whether a victim or witness, quote, shall be filed under seal without necessity of obtaining a court order. With the policy choice made by the General Assembly to protect child victims of crime from being further traumatized and victimized, the narrow protections intended by Senate Bill 111 can be implemented by the Maryland judiciary through standard rules and standing orders, which is common practice in the judicial system. The system noted by the judicial conferences speaks, and I'm talking about their testimony, it speaks to a system where a victim may request shielding or shielding of their information. And I have been told by a witness who you will hear from how cumbersome that process is, and nearly impossible for someone with or even without a law degree to use. While the rights of accused individuals are paramount, the existence of federal law demonstrates Senate Bill 111 does not jeopardize these rights. Indeed, Senate Bill 111 aligns Maryland with federal law and bolsters protections of child victims by immediately redacting information that could reasonably identify the minor from public view, which could or should be standard policy and not a discretionary policy on a case-by-case basis. And notice I am using the word redaction. I'm not using the word shield, which is noted in the judicial conference's testimony. Finally, it should also be noted that such limited restraints to protect the identities of child victims in the judicial system have been found to be constitutionally allowed. And if you look to my written testimony, there are at least 2 cases that are cited. Therefore, as such, I respectfully request a favorable report on Senate Bill 111. Thank you all very much for your time.
Go ahead. Mr. Chairman, Mr. Vice Chairman, members of the committee, thank you very much for the opportunity to speak in favor of SB 111. My name is Michael Padone. I'm a Maryland attorney. Views I express today are solely my own, not my firm's or any of its clients. I want to begin by thanking Senator Sidnor for his leadership bringing this important bill forward. And it's important because there's nothing in Maryland law that requires the redaction of the names of minor victims in court filings. Even worse, under the most egregious circumstances, when a child is a victim of a sex crime, Maryland law requires the inclusion of their name in the indictment, Criminal Law 3317. I was involved in a case where a 15-year-old girl was repeatedly raped by a 34-year-old man who was the manager at her first part-time job. And that girl said to me, "I don't want everyone at school knowing about this. I'm not pressing charges if people can find out who I am." She did press charges. And when the indictment was returned in that case, her name was all over it. She was shocked. Using common sense, she reasoned that the law couldn't possibly now allow the name of a child rape victim to be plastered all over publicly available documents. And had her case been in federal court, she would have been right. The risk of stating the obvious, our kids are growing up today in a world where information is more easily accessible and spreads more rapidly. Kids today know how to use case search, and they know where the MDEC public kiosks are. As a result, when a kid is a victim of a crime, they run a very real risk of being outed and shamed, and that's a deterrent to kids reporting crimes. And that's something we need to fix. And I would, just to address the judiciary's opposition on this idea that there is a rule that allows the shielding. So I was the attorney that Senator Sidnor was referring to. And I have tried to use this procedure. 2 of us lawyers of average intelligence plus a judge, we're struggling to figure out exactly how to do this. And I assure you that normal folks without law degrees have no idea how to take advantage of that rule that the judiciary thinks makes this bill unnecessary. So with that, thank you for your time, and I urge a favorable report on the bill. Happy to take any questions.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 111. Thank you, Senator Sidner, for your leadership. Thank you, Mr. Perdone, for bringing forth your client's story. It's really so important. Senator Sidner, as usual, is a fabulous advocate for his bill, so I'm not going to repeat what he's already said about the effect on victims, but I do want to make just a couple of really quick points. You have in my written testimony the federal rule. This is nowhere near as strong as the federal rule. The federal rule covers all kids who are witnesses and that sort of thing. So this is really a modest step. Senate Bill 111 is necessary because, again, in sex crimes cases, our statute 3317 requires the name of the victim. So we need to do something to address that. This is not simply something that people can do on a discretionary basis. However, I would point out on a discretionary basis, the appellate courts in Maryland have decided never to publish victims' names. So the appellate courts are taking the names out. No reason we shouldn't do this at the trial level. Finally, I'd also say that I've handled civil cases where we've done this. I've handled them in federal court. I've handled them in civil court. In federal court, it was a disabilities case with disabled kids. We would refer to an attachment. The attachment would be sealed. All the kids' names were there. They were not in the publicly available file. In state court, we did the same sort of thing. We had two documents. One had just redacted, and then the other one had everybody's names. The redacted version was filed under seal, available to opposing counsel and anyone else who needed it. The publicly available document did not have those names, but the rest of the information was there. So the case remained transparent. For these reasons, we ask that you take this very, very modest step and report favorably on Senate Bill 111.
Good afternoon. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm testifying on behalf of my office and as well as the Maryland State's Attorneys Association. I'm testifying in support of this bill because we need it now more than ever. A recent rule went into effect that allows the media to grab audio from trials and publish it on the news, play it on the news. Without this safeguard, we would not have an automatic redaction of those names. So I'll tell you what my division is doing. We're now at the beginning of every trial, essentially asking to seal the trial. That's not a good solution either, because the public is entitled to have access to that information. But there's really not a whole lot of choice right now because we have, by the very nature of the cases that we're trying on sexual child abuse, the victim's name is going to be included at the trial. We've worked hard in Montgomery County to shield children's names out of charging documents and out of pleadings. We typically write initials, which has been found to be satisfactory. But frankly, it's not enough because most of the sexual child abuse cases are familial relationships. And when they're familial relationships, putting the initials of a child really doesn't go far enough. This bill is needed and it's needed now, and I would urge the support of Senate Bill 111. Thank you.
Chairman Smith, Scott members of the committee. I'm very nervous, Scott Schellenberger, State's Attorney for Baltimore County, being up here. I mean, when was it that Senator Sidnor and Scott Schellenberger were on the same side? So this should be a no-brainer, right? It should absolutely be a no-brainer. This is extremely important, Bill, because nowadays all it takes is a few clicks at a kiosk in the courthouse, and the next thing you know, a few clicks on social media, and the name of a victim can go out to thousands and thousands of people with just a few clicks. The paperwork is very easily accessible by the kiosks. It's more important now than ever to protect the minor victim because of the social media that's out there. Redacting and shielding names of addresses of the personal information does not interfere with the rights of a defendant. I will still be obliged under the rules of discovery to turn over every piece of paper that I have that will also contain the name of the victim. And while I agree there is a way to do this, it's very difficult. And by the statute creating almost, in a sense, a presumption and then the ability to object to it by proving it by clear and convincing evidence, I think builds in enough protections. So I attached to my written testimony the original charging document in the case involving a Gilman coach who was accused of sexually assaulting some students. In that document, we were able to say victim 1, victim 2, victim 3. But when we indicted, we couldn't. And in the indictment, we had to put their names. And there should be an automatic way to redact those names or shield those names from the public so that a couple of clicks doesn't put it on social media. Therefore, I urge a favorable report, particularly in light of my friend, Senator Sidnar.
Excellent. Well, we've got one more bill that Senator Sidner that I really like. We'd be great to get you all together, work that one out as well. But Senator West.
Thank you, Mr. Chair. And as long as you're up there, Mr. Schellenberg, let me ask you this. So the judiciary has opposed this bill. One of the grounds of their opposition is that if the victim's information is entirely redacted from a charging document, the individual charged would not be adequately informed of the charge and able to prepare a defense. I think you answered that by saying you, in your discovery, have to provide them with the detailed information. So isn't that an adequate response to what the judiciary says?
Absolutely. I mean, under the rules of discovery, I'd be required to turn all that over. I'd be required to turn over the original police report, the original reports that indicate the name. If there's a medical record, it's going to have the names in there also. This is just a method to protect this one document from going out there and being used and abused, and so that we can protect young children. And that's what's important, but it does not change my obligations under discovery to turn all that information over to the defense lawyer.
But then let me continue, because one of your fellow witnesses started talking about at trial. If the trial is streamed or somehow made available at the trial, the name of the person, the victim, comes out. So what do you do to protect the victim's name in your case when the Gilman teacher ends up going to trial?
Right. So what you're talking about is something that I've been fighting for 3 years on the Rules Committee, and that was the change in the broadcast ban. So that last year, we finally came up with a rule to deal with the broadcast ban. And the way that the Baltimore County State's Attorney's Office is approaching it is we have a motion to shield the information of when a sexual assault victim, either a minor or an adult, is testifying, so that can't be grabbed by the media and played on the nightly news. Now, I can tell you the media has said to me, we all have rules out there about whether this happens or not. But again, that doesn't change somebody else from trying to get it and putting it on Facebook or social media. And so because of the change in the broadcast ban, the rule does allow for shielding of that information, and we intend to, in Baltimore County, and I've shared this with the other state's attorneys in the state, intend to, on a regular basis, file a motion to shield the testimony of the victim in a sexual assault case.
Right. So we need another bill to address the issue of the disclosure of this information during the course of a trial. This bill doesn't do that.
What I'll do is I'll send you the Maryland rule, because there are provisions in there for how to do this. And then you and I can decide if that's enough or not.
Yeah, because merely shielding the testimony of the victim when that person is on the stand probably is not sufficient, because during opening statements, the name is going to come up. During closing statements, the name will come up. Perhaps in other testimony, the name will come up.
Sure, especially if you have a medical professional or a police officer who got to the scene, and first thing a police officer asks you when you get to the scene is what's your name, address, and telephone number. So, I mean, it will be very difficult. And I've actually approached the clerks in the state and told them that this is going to be a problem, because, they're going to have to be, the way the rules drafted is they have to keep notes as to what needs to be shielded and what doesn't. And the problem is you might think today, what case the press is interested in, but you might find out that if you're someone named, say, Jason Billingsley, who suddenly did a couple of sexual assaults in the state of Maryland, and you had done one 10 years ago, Well, then all of a sudden, the press is asking for what happened 10 years ago and trying to get a copy of it. And if we don't be very careful about how we're doing this, that information can get out there. And that is not a hypothetical. That actually happened.
Okay. So thank you for your testimony. And it sounds to me as if we need a bill next year to deal with this other issue, which is not covered by this bill.
We'll take a look at it.
Thanks.
What about the in-person aspect? I mean, so like this is for the broadcasting, but and Senator Carter can help me with this, but like for delinquent, what other type of proceedings is it closed? Like are delinquency proceedings closed?
So delinquency would be closed.
Yeah.
You know, no, you can't go into a juvenile courtroom just being anybody.
So, but the press could be there at one of these proceedings and
Sure, you could, I mean, years ago,
yeah,
I put, 7-year-old victims on the stand and, and you ask them their name and then they testify and they testify about some very terrible things. And right now, the way that the laws are written, the press could, with the taking away the broadcast ban, the press could get a copy of that and play it, which is why the rule does have provisions in it for how you can protect that. But you got to do it right during the trial or once the request is made. So in the case where they asked for something that happened 10 years ago, you can do that protection now, but backdate. But going forward, it certainly makes sense in every child abuse case to ask for that protection. But yeah, you could come sit in a courtroom and you would hear that person's name.
Yeah. Could you send us the rule to council so I can redistribute it?
Absolutely.
That'd be great. Thanks.
Yep.
I sit on the rules committee, but I must have missed it that day.
Oh,
All right.
you do?
Yeah. That private practice gets in the way, you just meet for the entire day. It's hard. All right, Senator Sidor.
I guess this isn't uncommon that someone asks their own witness. I can ask my witness a question, right? All right.
Now I'm really scared.
No, and just to buttress what you were saying, I wanted to know if Maryland has this rule. I was watching a case where I think it involved a school shooting. I think it was up in Wisconsin where a parent was being prosecuted for her son's murder of these students. And there was a clip that was played on television because there was a discussion about, I think it must have been a motion made that you could only refer to him not by his name, but by some other nomenclature. Is that type of rule available for juveniles in these types of cases where you can put a motion in place during the trial that you can only refer to that juvenile by some sort of pseudonym?
You could ask the court to do that and try to do that, and that would certainly be discretionary. But again, now you're talking about having to instruct all the witnesses to refer to the person that way. But at some point, that real name is going to have to be somewhere.
Gotcha.
So yeah, but I did see that clip also.
Thank you.
Yeah. Thank you all so much.
Thank you. Seeing no further questions, thank you very much, Senator Sidor. Thank you to the panel. This is great. So that'll conclude the hearing for Senate Bill 111. We'll now move on to Senator Folden with Senate Bill 398. Good to go? Awesome. All right. And we can bring up your panel. I think Ms. Feinstein, you can come back on up. Is Ms. Shapiro here? Here we go. Come on up. Ms. Tucci and Berkowitz. Ms. Berkowitz. Did Debbie leave? Did she come back? Ms. Feinstein. She's talking to Senator.
Yeah, no worries.
That's fine. You can start whenever you're ready.
Mr. Chairman, remaining members of the JPR, for the record, Senator William Folden, District 4. So before you today is bill number SB 398, Criminal Injuries Compensation Board Victims of Non-Fatal Strangulation. I'm just going to do a brief lead in and turn it over to my panel. But in short, strangulation includes strangulation. This bill seeks to change where strangulation would include strangulation that is not related to rape, sexual offense, or sexual abuse. Instead, it would recognize that strangulation is also utilized in a manner of continued control and fear. When law enforcement respond to victims of strangulation and they begin to assess and they begin to interview, many of the victims of strangulation say, no, he didn't strangle me, he choked me. They don't equate it the same. They think that strangulation means that they have died, they were killed. So allowing this and it just kind of takes this and reinforces the idea and the need for this continued expansion to allow the Victim Services Unit of the Governor's Office of Crime Prevention, Youth and Victim Services to add non-fatal strangulation for forensic examinations as a part of the Criminal Injuries Compensation Board. So with that, I would ask for a favorable report on SB 398 and thank you.
Hello, my name is Susan and I'm a survivor of intimate partner violence. I'd like to tell you a little bit about my experience the night that I drove myself to the hospital after being severely beaten and strangled. During that particular altercation, I was punched in the face several times. I was thrown against the wall so hard that when my head hit the light switch, my head split open and there was blood everywhere. When I tried to escape, he put both of his hands around my throat and lifted me off the ground. Not only was he strangling me, he was pounding my head against the wall. I couldn't breathe. I eventually couldn't see. And I only remember getting up off the floor to try to escape through the front door. As I drove myself to the hospital that night, I literally thought that I was going to die. I had a 4 to 5 hour exam at the hospital that showed I had a lung contusion, a severe concussion. I needed staples in my head, and the nurse took 72 photos of my bruised and battered body. I remember answering dozens and dozens of questions, but I was so tired and my body just hurt everywhere. It hurt to keep my eyes open. I remember being there for what felt like forever. I hadn't slept a single minute in over 24 hours, and I just wanted to go home. But I realized they kept me at the hospital for so long to make sure that I didn't die. And I'm going to say that again, to make sure I didn't die. Why was I going to die? I was living, I was breathing. And there was so much about strangulation that I didn't know at that point how you can die later. And I had just survived a whole nother episode of strangulation. And you know what happened? I received a medical bill, a really hefty medical bill. So now on top of trying to not die, I had a medical bill to pay. A medical bill that I was responsible for because someone else violated me. How does this even make sense? Someone almost killed me and now I have to pay money because he broke the law, because he decided to strangle me. And no person should ever have to wonder if they can afford to live. I am in full support of this bill, and I hope that you are too. Thank you.
Thank you very much for your willingness to testify and for sharing your story. I know that's always tough when we hear from folks, and it means a lot. So thank you for sharing your story.
Good afternoon again, Chair Smith, Vice Chair Waldstreicher, and members of the committee. Again, my name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm testifying in support today on behalf of my office and the Maryland State's Attorneys Association. This bill is needed because victims of non-fatal strangulation are, as our very brave witness today said, they're getting saddled with the bill. And that's not fair and it's not appropriate. And there is no difference in a sexual assault survivor not receiving a bill versus a victim of non-fatal strangulation. In 2020, this legislature made non-fatal strangulation a felony. It had not been before, and we now have the ability to prosecute these cases in a much straighter line than we were able to do it before. But I will tell you, and I will echo what was already said, that the vast majority of the injuries of non-fatal strangulation, they are not visible, but it doesn't make them any less deadly. Victims are at risk for up to a year, 2 years later for stroke, for seizure, and for other issues, other medical and health issues. So it's not even those first few days afterwards. It could be months or a year later, and there could not be a single mark on the outside. There was a study in San Diego that said 50% of victims had no visible injuries. 35% of victims' visible injuries after a non-fatal strangulation were so faint that they weren't able to be captured by a photograph. And only 15% of victims of non-fatal strangulation had visible photographable injuries. What's really needed is for that victim to get a forensic exam by specialists that know how to perform a non-fatal strangulation examination, which often includes a CTA, which allows them to see beneath the skin to see what type of injuries are lying below. And that's the way that we're going to prevent those significant problems coming down the line, by having this full exam, by having victims feel comfortable getting these exams without being saddled with a bill. I urge this committee to support Senate Bill and to vote favorably on Senate Bill 398. Thank you so much.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Rosalind Berkowitz, and I am Vice Chair of the Baltimore County Commission for Women. I have attended the Advanced Strangulation Training and the master's level training at the Training Institute for Strangulation Prevention in San Diego. I retired as a forensic nurse examiner from Greater Baltimore Medical Center about a year ago. I still testify for strangulation in 3 counties in Maryland. Since I started working with these 3 counties, I have noted that there are many victims of strangulation who have not gone for medical evaluation after their assault. Often it's because of a lack of knowledge about the lethality of strangulation, but in many cases, it is because the lack of insurance or simply the inability to pay for an emergency room visit, or they may be undocumented and afraid to go. It is a well-documented fact that survivors of a strangulation assault can have life-threatening injuries without visible signs. They could have traumatic brain injuries, which could greatly impact their quality of life or their ability to hold a job. They can have vascular injuries that could lead to a stroke even as much as a year or 2 later. This could be life-changing for victims, especially since many of them may be in their 20s or 30s. I attended a webinar from the Training Institute yesterday and heard about a study that was in the process of being published. This study identified that 10% of strangulation victims have vascular injuries. The cost of providing medical care for a victim of strangulation is very low compared to caring for a victim for years after they have had their stroke that could have been prevented had they gotten medical treatment. I want to thank you for listening to me, and I encourage a favorable report on a Senate Bill 398. Thank you.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee, Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence. We are the federally recognized state domestic violence coalition here in support of Senate Bill 398. And this happens to be my first time testifying before all of you this session, so nice to see all of you. We've talked a lot about the need for this bill. I'll talk to you a little bit about the mechanics of how the sexual assault reimbursement unit differs from criminal injuries compensation. It is a direct payment made to the medical provider. So if this bill and this unit operates separately from CICB, there's legislation regarding CICB, very important legislation, which we support. But this is separate and distinct because this goes direct payment to the medical provider. It avoids a victim having to go through their medical insurance. And if they don't have medical insurance, figuring that out and getting the bill sent to their house. Now, if you're a victim of domestic violence and you are still living with your abuser and you go get medical care and you do have health insurance, where's that bill going? That abuser is going to get something in the mail. Something's going to come in the mail. The bills are going to come and they're going to see that a victim sought medical treatment. Going to the hospital is also connection to services for a victim of domestic violence, a victim of strangulation. I would also add that survivors of strangulation are at 750% more likely to become a victim of domestic violence homicide. So getting them that connection to a medical provider not only will prevent death in the immediacy from the non-fatal strangulation, but in the long term from connecting them to services and preventing them from becoming another victim of domestic violence homicide. So for all of those reasons, we urge a favorable report on Senate Bill 398.
Thank you all very much. Questions from the committee? The only challenge of the bill is a fiscal one, just given our environment and so. But I think making the argument of how there are downstream savings obviously associated with this will be compelling. So look forward to working with you all on this and appreciate it. Thank you very much for coming out. All right. Thank you, Senator. All right, with that, that'll conclude the hearing for Senate Bill 398. We'll now move on to Senator West, if you're ready, with Senate Bill 17.
Thank you, Mr. Chair. It is indeed a pleasure to be here for the second time this afternoon to present Senate Bill 17. Under current Maryland law, a person who serially abuses multiple dogs, cats, horses, or any other animals in violation of the laws prohibiting animal cruelty is only charged once, regardless of how many animals have been abused. So a person keeping multiple dogs, for example, in unspeakably cruel confinement can only be convicted of a single crime of animal abuse. My wife and I, we have a very pet-friendly family, animal-friendly family. She served on the SPCA board of Baltimore for many years. And it's hard for us to contemplate how a human being could possibly set about to subject any living creature to actionable abuse. But the newspapers periodically report situations in which literally dozens of innocent animals have been horrifically treated. When we catch people engaging in such reprehensible conduct, we need to impose appropriate punishments. Abusing a single animal is bad enough, but abusing multiple animals represents a pattern of such cruelty that a much stiffer punishment is warranted. According to the Calvert County State's Attorney's Office, the standard defendant in these animal abuse cases harms multiple animals in multiple instances rather than one-off occurrences. As awful as it sounds, this is what's happening. So Senate Bill 17 allows for each instance of abuse and each animal abused to be the basis of separate charges. It states that each animal harmed in a violation of the crimes relating to animals subtitle of the criminal law article will be a separate offense, and that a conviction under subtitle 6 will not merge with a conviction for any other crime based on the establishing violation. In this way, Senate Bill 17 will help to better prosecute individuals involved in the most depraved forms of animal abuse. There is no opposition to this bill. And I note for my witnesses, there is no opposition to the bill. So with that, I will stop talking and turn the proceedings over to my four witnesses and then have questions at the end of our collective testimony. Thank you.
Good afternoon, ladies and gentlemen. My name is Bob Harvey. I'm the state's attorney in Calvert County. Along with Senator West and Senator Sidnor, I'm also a member of the Maryland Commission on Criminal Sentencing Policy. I hope by my remarks I don't create any opposition to this bill. That's not my intent. I'm here to support it. This bill, Senate Bill 17, addresses a problem that currently exists within the Maryland sentencing guidelines. Aggravated animal cruelty is a felony that is prosecuted in the circuit courts of this state, and as such, the sentencing guidelines come into play. The problem is that the Maryland sentencing guidelines do not recognize animals as victims. Only humans can be victims. When you have a conviction for a crime such as robbery, and there are 2 or more human victims, the recommended sentences under the guidelines stack. So if the guideline range is 3 to 6 years for one victim, it would be 3 to 12 for 2 victims, and so on. The same rule does not apply when the crime involves animals. Since for guidelines purposes, animals are not victims, the sentences do not stack no matter how many animals are involved in the particular crime. The guidelines are the same regardless of whether one animal is abused or 20 animals are abused. And as you can understand, this is particularly troublesome when you have a case such as we have had in Calvert County on several occasions of an individual who has abused multiple animals in a dog or cockfighting ring. This bill makes it clear that the court may, not required to, but may impose a consecutive sentence for each act of animal cruelty when multiple animals are the victims of mistreatment. It merely reflects the intent of the General Assembly as currently stated in Section 10-602 of the Code that each animal in the state of Maryland is to be protected from intentional cruelty. Thank you.
Good afternoon. My name is Chris Monty. I'm an assistant state's attorney in Calvert County. I prosecute violent crimes as well as animal abuse and neglect crimes. I believe that the bill that is proposed, as State's Attorney Harvey alluded to, really embodies the purposes of the animal cruelty statute as it is presently stated to protect each animal in the county. And we have encountered multiple situations of dogfighting operations in Calvert County. And candidly, and speaking with my colleagues across the state, these are operations that today are happening in every county, in every city, whether in a townhouse in Baltimore City or a garage in Dundalk or the basement of a property in Montgomery County. And these properties often involve the mistreatment of nearly 50, sometimes 100 animals that are attached to stands by chains and forcibly raped. They're pumped full of steroids and other medications. And then, of course, they're actively fought. Those fights can last for hours until the other animal dies. And then those animals are disposed of, or any other animals that are not deemed suitable for fighting are then brutally killed, often with electrocution. So when we're looking at the punishment prong of any sentencing, it's appropriate to make sure that the crime in the sentence imposed reflects the nature of the crime. And we're talking about living, breathing animals that should be reflected in these sentences. It also serves a deterrence prong, because a lot of times these operations, you're talking about money exchanging hands in the hundreds of thousands of dollars. Right now, the maximum penalty for a felony animal cruelty is 3 years incarceration. Like the vehicular manslaughter crimes talked about today, it's not a crime of violence. So you're talking about merely months. Months of incarceration is not going to deter this behavior. So I believe that it is in the essence of deterring the behavior, protecting the community, protecting all these animals, that you look favorably upon this bill. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Crystal Dowd. I am the Deputy Director for Public Safety for Calvert County. Our department oversees our Animal Control Division. I want to point out that there's very few cases investigated by Animal Control that rise to the level of felony charges. To my knowledge, there's only been one case involving one animal that has been charged in Calvert. The majority of our other cases that are charged to this level involve multiple animals. 2 cases in particular that we've investigated and charged recently have been with dog fighting. The dogs in these cases have had disfiguring lacerations, untreated broken bones, were forced to tear each other apart for the owner's monetary gain and purely for entertainment. They also use exhaustive techniques in order to condition these animals, causing emaciation. These animals are suffering from the moment they're with these individuals until, unfortunately, they can be forced, to die. The the charges of the felony charges for animal cruelty are strictly reserved for situations where there is intent involved with affecting physical abuse, mutilation, torture, and or death on an animal. Removing the ability for our judges to sentence offenders for the abuse they inflict on each animal when more than one animal is involved significantly lessens the accountability in these egregious cases. It also sends a message that only one of the animals abused is worthy of justice. I ask that the committee see this Senate Bill 17 favorably. Thank you.
Good afternoon. Thank you, Chairman, Vice Chair, and Committee for having me here today. My name is Patty Crankshaw-Quimby, and I'm the Executive Director of Animal Control and the Humane Society in Talbot County, as well as the President of Professional Animal Workers of Maryland. We are the organization of animal control and humane societies of the state. You've heard from my colleagues about these cases and how they involve the most egregious acts towards animals in our state. We've also heard that the current law stands whether a defendant harms one animal or 100 animals under this felony statute, the charges and hence sentencing would be the same. We also understand the legislature's work to decrease incarceration in our state. These cases are not frequent occurrences. However, when they do occur, they are truly horrific crimes. Humane law enforcement across the state who care about these animals and who must deal with and witness these heinous crimes cannot do our jobs daily without knowing that these worst of abusers will be held accountable. Animals in our state are caught in a legal dilemma. They're not technically property, but these crimes are violent and often result in death of a living creature. It's insufficient, excuse me, to limit felony charges in the same manner we would a vehicle, a television, a piece of jewelry. Professional Workers of Maryland believe passing Senate Bill 17 is a crucial tool in protecting the animals and the people of our state, and we ask for a favorable report. Thank you for your time.
Mr. Chair, I was remiss in forgetting that Ms. Bevan Dangle is also with us. So if you could hear her too.
Thank you, Senator. Thank you, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the State Director for the Humane Society of the United States here in Maryland. In recognition of the fact that you do not have opposition, I simply want to reiterate that what we are seeking here today is not a new tool in our toolbox, but simply to restore a previously existing tool, a tool that was taken away because of a legal interpretation. But as Ms. Crankshaw-Quimby said, animals exist in this gray area. So we do understand that the decision that came down in May that took away this tool, this ability to hold each life to bring its charges in court, we understand that legally that was appropriate, but it's the policy decision before this committee of whether these living creatures that are, as has been expressed, suffering in the most sort of egregious situations deserve to each have their own sort of day in court as a result of the loss of life. So that's the policy question before this committee. And we thank you for your consideration and we urge your favorable report.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this bill. So one of the offenses, and I'm getting this from the fiscal note, 10-623, leaving a dog outside and unattended by the use of restraints.
I think that's the bill that I passed last year or the year before.
So I just have a question. So that is, it's a misdemeanor, 90 days imprisonment or $1,000 fine. So if I had 50 dogs and I was doing that, are we saying that this defendant is going to be charged 50 times this and or $1,000? So it'd be $50,000 up to $50,000 and 50 times the 90 days.
Your formulation of the question uses the words "is going to be." So it's discretionary with the state's attorney as to what charges the state's attorney brings. And it's also discretionary with the court, what penalties imposed. So yeah, if there, how many you said, 50 dogs?
I just said $50.
50 dogs, okay, 50 dogs. It would be possible for the state's attorney to charge 50 different crimes, and it would be possible for the judge to impose the penalty stack it 50 times, but it's not mandatory. The judge can use the judge's discretion, as is always the case in cases like this.
As you know, that I am not an attorney, so are we stackable for humans that way as well?
Ooh. I think in certain cases, do we have yeah, let's let somebody better than me answer that.
Yes, actually, so if there's a victim crime, so in this case, a human, it's stackable. Also, this is also utilized in property crimes as well. So if after a particularly brutal Ravens loss, I go down, grab a baseball bat and go to my neighbors and smash everybody's mailboxes, by statute, those do not merge. So these are actual stacked as well. So if, to take your example, if I broke 50 mailboxes, I could have an exceedingly high penalty as well. And in that case, this is not even mandating that they not merge. It's just discretionary. So actually the mailbox example is a little bit more punitive on the effect that it has.
Yeah, the only thing that it brings up to me is that, you know, look, we've got, I believe, people that will hoard animals. They start off thinking that they're loving and taken care of, and they hoard them. So, you know, in Allegheny County, we've had as much as 100 cats in somebody's house.
Yeah.
So first of all, that person probably doesn't have the financial whereabouts. Second of all, it certainly doesn't have the mental capacity. And I know that it is possible, or I guess, is there any limit? I mean,
well, and I think the limit would be
the person could be the most despicable person in the world, and we want to charge everything with them, but there's a reality that I just didn't know if there was a limit. That's all.
Sure. So I think it's limited to the court's discretion. So we've had a case recently where there are about 100 animals at a property. Now, in that case, it was related to some kind of mental health issues that were going on, which afforded that person to become overwhelmed by the situation. So what the court said is that I understand that, you know, I'm not going to sentence you to all this time of imprisonment for each animal. We didn't charge that way. But the court also recognized that I need to have a certain amount of penalty here to account for these animals, but also suspended time to make sure that that person goes through the mental health treatment and everything that we really think was the core of that issue. Because of course, we want to make sure that there's a penalty there so that we don't find that ourselves in that position again, 3 years, 5 years down the road, which actually was the situation there.
It sounds like there's an off ramp. Thank you.
Yes, thank you.
Thank you.
All right, thank you very much. Thank you all. Good to see you all. Thank you, Senator. All right, with that, that'll conclude the hearing for Senate Bill 17. We'll now move on to Senate Bill 379, Senator West.
Thank you, Mr. Chair. I'm trying not to lose my voice. This is my third bill this afternoon. So it's a pleasure to be here to present Senate Bill 79. This one is yet another bill. I think 4 of the 5 bills this afternoon have no opposition. So this bill has no opposition. So last year, the General Assembly passed Senate Bill 209, which established a task force to study crime classification. The reason for the task force was to try to address the fact that most of the state's criminal laws were passed by the General Assembly on a one-off basis, without regard for offenses already in the criminal code or for the penalties associated with other similar offenses. So in many cases, crimes which, viewed objectively, would be considered similar have quite disparate penalties associated with them. Some misdemeanors are punishable by up to 20 years in prison, while some felonies are punishable by far less time. There are still civil offenses in Maryland dating from British common law, uncodified by any statute. The task force met frequently this past summer and fall and issued a report shortly before the end of the year, making recommendations suggesting how a follow-up task force could best try to categorize crimes and civil offenses within current state laws so that, to draw an analogy, apples would be treated in a similar fashion, while peaches would be treated consistently but differently from apples. Senate Bill 379 represents an attempt to respond to the recommendations of the task force. It would establish a continuation of the task force, but in slightly altered form. First, it would rename the task force to be the Task Force to Study Crime Classifications and Penalties. Second, the bill would slightly alter the membership of the task force. It would add to the task force the executive director of the Maryland Sentencing Commission, who was enormously helpful in his testimony this past year to the task force. We concluded he should be a member of the task force. And also a designee of the governor's Office of Crime Prevention, Youth, and Victim Services. And then third, the bill redefines the duties of the task force. It limits the task force scrutiny to criminal and civil violations in 3 articles of the code: the criminal law article, the criminal procedure article, the public safety article, and then adds the Maryland sentencing guidelines. And it assigns the task force to make recommendations as to whether violations should be categorized by classes of misdemeanor and felony to correspond with the severity of offenses. The task force is further assigned the job of determining whether there are penalties that should be altered because they're disproportionately lenient or severe, and whether the remaining common law offenses in Maryland should be codified. Finally, because the work of the task force is expected to be quite time-consuming, the task force is given 2 years to complete the work assigned to it. Senate Bill 379 is simply the natural progression to build upon what we learned and accomplished from last year's task force. It will help to ensure that the state's punishments best fit the crimes. So there's no opposition to this bill. There are several amendments suggested, one by the Maryland Coalition Against Sexual Assault. They want to be added to the task force. I'm happy to agree to that amendment. Also, the Attorney General has a proposed amendment. He suggests an amendment to the bill that adds uncodified language providing funding for the task force to contract with a public research institution to provide staff and conduct research for the task force. I'm also happy to accede to that amendment. And finally, I think Megan Coleman is with me, or maybe online. She was the chair of the task force this past summer. Maybe it's been a long afternoon. Maybe she's not with us. She is online? Great. So I'm going to let her speak and then we'll take questions.
I think Ms. Jordan is here as well for her piece. We'll do the in-person and then we'll do the
She's here.
yes. Okay.
Why don't we
Actually,
hear
no,
from
I'm sorry. Let's do
proponents and witnesses and then we'll take questions.
You're absolutely right. Yes. So we'll do the virtual first, then we'll hear from Ms. Jordan. So we're going to do the virtual first. Sorry.
okay.
Yep. All right, Ms. Coleman, you are up.
Thank you. Good afternoon, Mr. Chairman, Vice Chair, and members of the committee. My name is Megan Coleman, and I was named the chair of the task force to study crime classification in September of 2023 pursuant to Senate Bill 209. I worked closely with Senator West and members of the task force to try to accomplish that bill's task, which was to study and make recommendations regarding a method for classifying all crimes and civil offenses under state law by December 31st of 2023. It became apparent that the task was too broad, the timeline too short, and the resources too thin. For example, when searching on Westlaw, I took out of my search any articles in criminal law or public safety or criminal procedure, and also including the transportation article. Notwithstanding my removal of those 4 articles, when searching entries such as penalties and fines, I came up with over 1,400 offenses. Similarly, for just the term penalty, there were over 3,800. We let Senator West know early on that we thought that it would be better use of the task force's time to try to narrow in and focus on the criminal law article, the public safety article, and the transportation article, as we learned from David Soule that those are the most common articles that come under the sentencing guidelines and offenses that are sentenced in circuit court. Therefore, by adding more members of the task force, additional resources for the funding of a contractual attorney and paralegal, and limiting the scope of the task force, we believe that Senate Bill 379 can accomplish what was originally intended to be accomplished in last year's Senate Bill 209. The task force believes that this is a laudable mission, one that would benefit various stakeholders in Maryland, and therefore I have a favorable recommendation for its passing, and I hope that you take that into consideration. Thank you.
So questions for Ms. Coleman? Sorry. Okay, Ms. Coleman, if you could just hang around until the end of the hearing. I think we may have some questions after Ms. Jordan's testimony.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee, I'm Lisa Jordan from the Maryland Coalition Against Sexual Assault in support of Senate Bill 379. Thank you, Senator West, for agreeing to add us to this important undertaking. I really have nothing to add to the substantive testimony, but I'm happy to answer questions.
All right. Just for the Attorney General's recommendation of like an outside entity that would be contracted to help in this endeavor, who would do we have any idea as to who might be what type of entity would do that? I just don't.
No, the Attorney General didn't make a recommendation as to what, it's just a public research institution. My guess is University of Maryland, one of the professors there possibly.
Does Ms. Coleman have any insight into that?
So there were discussions with both David Soulé and David Jaros. They are professors at University of Maryland and University of Baltimore. And they had suggested that they could find, research assistants, either students or other people in academia. I know also the Attorney General's office, they were in charge of staffing the task force. They indicated early on in the mission that they didn't have any warm bodies at their office that could step in, but with proper funding like what is recommended in this new bill, I think that they might take the lead and perhaps find a contractual attorney through their office that they could put on this task force. So those were the various possibilities that we discussed this past fall.
All right, no further questions. Thank you.
Thank you.
Good to see you all. All right. With that, that'll conclude the hearing for Senate Bill 379. We'll now move on to Senator Carter, if you're ready. We have Senate Bill 11, 123, and Senate Bill 11 and 123. Which one would you like to take first? Okay, so Senate Bill 11, Senator Carter. And then would you like to bring up Mr. Dews, George Towson, Charlotte Ahern, yep, and Mary Denise Davis. Hey, how are you?
Thank you, Chairman Smith, and thank you, members of the committee, for enduring a long afternoon that's still not over. I really I don't like the fact that I have to bring this bill because I first brought it 20 years ago, but I love it, and I think that this body has moved in such a direction in favor of it that I'm fairly certain we are going to get it done this year. At least I hope so. And so if you'll just indulge me for a minute, I chose to look this up. And in 2004, when I was a new delegate, I came into the General Assembly having been an attorney for a few years. I had first worked at the Legal Aid Bureau, and then I worked in the Public Defender's Office. And by the time I got here, I was in private practice. But in my brief experience in the Public Defender's Office, every time we would have a client, I would look up the record, and inevitably, all of the clients would have these mass numbers of charges. This is actually before case search, and just charges. And so the optics of that were that, my goodness, what kind of person is this? All these charges, but the convictions would be few. Because even though it's been largely opposed and denied by our prosecutors throughout Maryland, there is a tendency to throw all of the potential charges that can possibly be charged for offenses. And then when and if there is a conviction on any one of the charges, those unconvicted, non-convicted charges remain on the record, ineligible for expungement simply because they were all charged and either not proven beyond a reasonable doubt, or a prosecutor made a decision not to go forward on them for whatever reason. Maybe it was a jury trial and the jury found them not guilty of those charges. For whatever reason, they can't expunge it. And so I chose to look something up that I thought it was very interesting. So in 2004, House Bill 142, coupled with another bill, 562, I had two different bills. They were characterized as expungement other charges. They were then supported by, one of the bills actually passed, but can anybody here relate to this? Heavily amended to the point where it no longer represented its intended purpose, but I was happy because I was new and I got a bill passed. But it was modified, but it was initially co-sponsored by Delegate Anthony Brown, Delegate Adrian Jones, and the bill that ultimately passed was a bipartisan passage. I don't recognize, and many of you were like in the 5th grade or something, you won't remember these names, but some that stand out to me that voted in favor of the bill back in 2004, Carmen Amandori, Jeannie Hadaway, quite a few others. And so I'm going to spend not much time talking about the mechanics of the bill for the reason that I fully believe that when I came into this body, rather naive, and it's interesting to note that my initial sponsorship of this bill was based on my experience as a public defender and seeing all those crazy charges for people that couldn't be expunged. And I thought, now that I'm elected, I'll just go and I'll show people, hey, these aren't convictions. Nobody's going to want them to be held against them. Everybody's going to agree. We're going to get it done. I thought it was a no-brainer in 2004. Okay. I remember that there was no strong advocacy and that the people that came in support of the bill were the Legal Aid Bureau, the Homeless Persons Representation Project, and I actually believe that may be it. I don't even know if Job Opportunities Task Force existed then, or maybe they weren't as organized, but I don't remember them being part of the equation. So over the years, Job Opportunities Task Force and other advocates began to advocate for this bill. Members of this body began to know this bill as the unit rule. We have to fix the unit rule. Well, 20 years later, 2 different dedicated task force and work groups later, multiple chipping away at the bill, removing some things from case search, which doesn't really expunge something. Here we are. And the ask is, in 2024, can we please finally allow non-convictions to be expunged in a state where we now allow certain felony actual convictions to be expunged? It is completely unfair to sacrifice fairness for expediency, and in so doing, we have literally deprived persons affected by this of justice for at least the last 20 years. So thank you. I will tell you that technically there was a drafting error. Email to all of you and to committee counsel should be the correct version of the bill. And briefly, all the correct version of the bill does is allow for the partial expungement of the non-convictions, regardless of anything else. Expungement, not shielding. Thank you very much.
Excellent. Thank you very much, Senator. We'll take questions at the end of your first panel. And I think I was in college when you first started that. I wasn't 5, but I was in college when you first started that, right?
Christopher Dews with the Center for Urban Families, representing Center for Urban Families. It's hard to follow Senator Carter on anything that she ever speaks on. Just want to talk about the impact this has on workforce. As you all know, I've said it 1,001 times in this committee in the past, having a criminal record is incredibly harmful when it comes to trying to secure housing. I know there's legislation to address that, employment, occupational licensing, business loans, financial aid, and so much more. What's, the purpose of this piece of legislation, which is why we've been pushing it for so many years and supporting this initiative, is that we're talking about stuff primarily that were non-convictions. We know that state's attorney's offices have used a variety of different tactics when trying to secure a conviction. We're not even trying to directly fault them for that with this piece of legislation. What we're simply saying is, in that gigantic unit of charges, those specific non-convictions should be eligible for expungement if they are currently eligible. This bill does not address or even touch the state's attorney's office's ability to object to the expungement. Nothing else changes. All we're simply saying is that within that unit of charges, the individual should be able to apply for a partial expungement. Just want to quickly highlight that on the House side, we have basically a bipartisan situation where a Republican sponsor reached out to my office to say he wants to work on this expungement bill because he himself had a situation where he was hit with a second-degree assault charge and an attempted murder charge because he was being bullied by a police commissioner's son. So they kind of just jacked him there. He beat the murder charge because, of course, he didn't try to murder this individual, but for the rest of his life, that charge cannot be expunged. And he still talks about it to this day when the incident happened over 30 years ago. So we just say that, I say that to say this is a bipartisan issue. The only thing we're trying to say is that if an individual was not found guilty, they should have the ability to petition, even if it was a part of a unit, for the sole purpose that these non-convictions do not get in the way of somebody trying to secure employment, housing, and all the rest. And I thank you guys for your time. Urge a favorable report.
Hello. Good afternoon, everyone, members of the committee. Thank you, first of all, and thank you to Senator Carter for providing this opportunity to testify on this important bill today. My name is Charlotte Ahern. I'm a staff attorney with Maryland Legal Aid, and Maryland Legal Aid strongly urges a favorable report and the passing of this bill. Myself specifically, I've been practicing expungements probably about 7 years now, and I can say wholeheartedly, without a doubt, the most detrimental aspect of the expungement process is the unit rule. It prevents otherwise eligible charges from being expunged just because they are a part of a unit. This often will leave your constituents, the people that voted for you, with very long, lengthy records, okay, that are very difficult to decipher. You need to have a law degree ultimately to be able to decipher them. There is Latin terminology. There are words that are just not used in everyday vernacular. So your average employer, your average landlord, they're not going to understand what those charges actually mean. I think it was the bill that was just previously, we were discussing stacking and overcharging, and how the state's attorney has the discretion basically to charge with however they deem appropriate. This is not a new issue. This is something that has actually been admitted by the state's attorney of Baltimore City, that there is a pattern of overcharging. This has also been studied by the University of Harvard. It's been studied by Maryland University. There is a pattern of overcharging. If that is the case, and there's nothing that we can do about it, on the back end in post-conviction, we need to provide a remedy so that we can correct that overcharging or that stacking. This rule ultimately, in my opinion, just perpetuates cycles of injustice, and we highly urge a favorable report. Thank you.
Members of the committee, good afternoon. My name is George Townsend, and I am a workforce development attorney at Maryland Volunteer Lawyer Service. My colleagues and I at MVLS perform hundreds of expungement analyses per year, typically for people who are participating in workforce training programs. Most of the case records that we analyze have some cases that are eligible for expungement under Maryland law, but it is very rare for a person with a long criminal record to have every single one of their charges expunged. One of the prime reasons that a case will be excluded from eligibility for expungement is the unit rule. And my fellow panelists and Senator Carter have spoken very well about the problems with having a case that a person was never convicted of. The case was never proved. They never pled to it. Oftentimes we'll see a case where there's a null prosecco on a case. It was not even prosecuted by the state, but because it's part of a unit with a different charge, it sticks around for years and can never come off of a person's record. And it is extremely difficult to explain to a person who is trying to turn their life around, who is trying to get a new job or apply for housing, that this case would be eligible for expungement if not for something called the unit rule that groups it together with a separate charge that happens to not be eligible. One thing I would add is that as a practical matter, as far as the steps that would have to be taken by the state to expunge a case out of a unit, this is something that's already going on because cannabis cases can be expunged out of a unit. So there is already a process. There are steps that are being developed for cases that are a part of a unit that are eligible for expungement in the cannabis context to be taken out of that unit and expunged. All this bill would do would be to extend that to other eligible cases as well. For this reason, we request a favorable report on this bill. Thank you.
Hello and good afternoon, Chairman and members. My name is Mary Denise Davis and I'm with the Office of the Public Defender, and we are here today to support Senate Bill 11. I would like to thank Senator Carter for her perseverance in introducing these bills to repeal 10107 of the Criminal Procedure Article, known as the unit rule. And I hope this year it actually happens. I will let you know, Senator Carter, I was here way back then. So I think it is time. It's needed, I think, to reflect what expungement means today, given all the changes that have happened with the statute since it was enacted in the 70s. When I first started helping clients with expungement, most favorable dispositions couldn't be expunged, and certainly no conviction could be expunged except for a handful of convictions that received a pardon. Now, favorable dispositions and eligible convictions can be expunged, but barred for the unit rule. And what I would say, there's some people that would say that this bill's not needed. But it's important to remember that this bill is about expungement. This isn't a bill about disclosure or shielding. Case search does not disclose favorable dispositions, not passes, not guilties, dismissals. That is true. But MDAC, which is a new public database in Maryland, that public database, I did a test run and I looked up comparable cases both on Maryland Judiciary Case Search and what was available to the public on MDAC. And while Maryland Judiciary Case Search doesn't show the favorable disposition, MDAC does. And that is a problem. And also, obviously, eligible convictions are not shielded with that law that was passed, I guess, about 3 years ago. Someone might also say that expungement of there's already an ineligible conviction, so why bother? But I think what everyone talked about is why it's so important to have the record as clear as possible. And for all those reasons, I would ask a favorable report, and if anybody has questions, more than happy to answer.
Thank you, Mr. Chair. So just as Senator Carter indicated, this bill has been presented before. I remember it from before. And I remember the problem with the bill was a logistical problem. And I've been reviewing the testimony, including the testimony in opposition today, and it appears the logistical problem remains. So let me ask you to address some of the issues that are presented by the Department of Public Safety in one case and the Maryland Judiciary in another in their and I guess I'm happy to have you sit at your seat rather than up there. So in principle, your bill sounds terrific, and I don't see how anybody could find fault with it. But all the records these days are electronic, and
not all of them.
Many of them are. And dealing with electronic records is expensive and time consuming, and in some cases, according to what I'm reading, impossible. So let me read you what the Department of Public Safety first says and ask you to respond. They say that their technology and communications unit would have to reprogram its systems in order to filter out which records are limited and which records can be fully shared. Substantial program changes to the system would be necessary, and a manual unit would need to be created and staff hired to process requests. It says currently they don't have the capability to perform a partial expungement in unit cases. I'll stop there.
Thank you so much. So I'll let anyone else expand on this if that would like to, but my answer to your question is for 20 years.
I know.
They have been complaining about logistics and administrative problems. And as I ended my testimony, when we compromise fairness for expediency, which is basically they're saying it's inconvenient. This is going to inconvenience us. Oh, it's going to be a burden. Oh my God, we might have to hire more people. Meanwhile, we have a myriad of people whose lives are forever overburdened through no fault of their own, because allegations that were never proven against them remain on their record as a barrier to them having full participation in society, housing, employment, and all kinds of opportunities that everyone else enjoys, because an allegation never proven is still on the record.
Yeah, I'm getting the feeling of deja vu all over again, because that was exactly your response the last time the bill came up. Let me continue. And they write, the computerized criminal history system, which is the interface for their programs, must be modernized before partial expungement can be implemented. Once the modernization has occurred, they can begin to develop and deploy the technological solutions necessary for the system to accommodate a partial expungement. The modernization project is currently in the procurement phase. Once awarded, the project is expected to take at least 18 months. In addition, they estimate it will take over 3 years to complete the technological updates to the system in order to allow them the ability to implement partial expungement functionality. So what they're saying is they literally can't do it right now.
What I'm saying is we're the lawmakers. What I'm saying is that if we pass a law, then agencies will need to figure out a way to comply with the law. And if they need more time or they have to do it in increments, then that's understandable. But after 20 years to continue to say that's an impossibility is not an acceptable response. But I also want to make it clear that for decades now, the Judicial Conference has contended that once MDEC was up and running, they would then be able to accommodate this. And now they're saying, oh, well, now we got MDEC, it's all electronic, it's too difficult. May I remind this body that we provided something similar kind of in the reverse when we passed marijuana, because the law that we passed allows them to go in and where there is marijuana conviction along with other charges, now that we are allowing expungement for those, we now say extract the marijuana conviction, even if there are other things. So it's not impossible. We have done it in other instances. Also, I would urge you all to consider that this is also done very much in traffic cases. In traffic cases, there are a myriad of different ticket citations, and they are segregated, they are disaggregated, they are separated. And so that is, it's not an impossibility. My point is, I'll just end this before I get emotional. Because the fierce urgency of yesterday, Senator West, not even the fierce urgency of now, this is something that should have been done, period.
Well, now, so far I've been reading, apparently these records are maintained by 2 different state agencies. One is the Department of Public Safety and the other is the Judiciary. So up until this point, I've been reading to you from the opposition, or rather letter of information, as they style it, from the Department of Public Safety. Let me go on to the Judiciary for a moment.
I think I can help, because I read that and I think that Judge Moore or the Judiciary's is opposition to the original bill. As I've explained, it was a drafting error, as don't we hate that? But the correct version of the bill, their contention is that we already passed something that addresses this or something along those lines, but that is not correct based on the correct drafting of the bill.
No, I understand that. They do say the bill's unnecessary because they can already shield it in case search.
So, shielding is not
You
expunged.
appropriately stated that case search is just one element of the whole thing.
Right, it's still available in the MDEC system, and it's still available to be pulled up by anyone that has access to that system.
Yeah, but they go on after they say it's unnecessary because they've already shielded it in case search. Then they go on and say, in addition, this bill is unworkable and would create a large fiscal impact on the judiciary. It says the legislation has the potential to result in a tremendous number of petitions for expungement. If this bill passes, tens of thousands of charges that historically have not qualified for expungement would now qualify. And the bill also, they continue and say the bill is retroactive and would include any charge since the district court was established in 1971, as well as circuit court expungements going back even further. As I took a look at your bill, there doesn't appear to be any back date, termination date. It does go back, indefinitely, does it?
It probably should. People imagine that this happened to you 30 or 40 years ago. You ought to be able to take care of it now. They ought to be able to do it and accommodate it. And I apologize if this is something that my position is something that you don't find reasonable.
No,
But I
I'm reading it-
believe
I'm reading
that
it from the
we need to
test-
pass this law and that those complaints have been modified to fit whatever current circumstance we have for the last 20 years.
If I
and
could say real quick
they
too,
wanna say something.
I'm sorry, the technology does exist. They're acting as if the technology doesn't exist. It exists. It's about the implementation of it and it's about
Right,
actually
it's
going through the
logistic.
record. So I just want to clarify that the technology 100% exists. There's no issue with that. It's about implementing it. But I'm of the opinion that if someone has paid their debt to society, then they've paid their debt to society. I do understand that it will take long, but I don't think that that should be a deterrent as to why someone, should not be able to do this.
And if I could quickly say, Senator, on top of that, just to be clear, we had multiple work groups, as Senator Carter already said, where we were supposed to produce a methodology so that this can be done. We had those work groups and we're still hearing, and I think the original bill that Senator Carter was referencing, and I think was referenced in the testimony as well, was House Bill 1336. And I would believe on the cross file was Senate Bill 589. I remember that because that was my first legislative session right when COVID hit. And there was a work group to discuss how we can properly implement this.
Right.
And
that's
that
what I
work group
heard.
happened.
So
And
what
that was
happened?
over that was 4 sessions ago,
Yeah.
which would have been the 3-year time period that you had mentioned if things would have been properly implemented.
That was
So
that's my recollection, but what
Yes.
happened to the work group?
And that
I was on the work group, sorry.
They
Okay.
produce their findings. yeah.
It's the same conclusion that is always being said. We just don't have the resources, we don't have the technology, we just can't do it. I think the courts thought the one fix of the shielding would suffice for the expungement, but it doesn't. But I agree with Senator Carter. It passed the law and the courts and CJIS will abide. I think it's the only way to make it because we can keep talking and talking and spinning, but I don't know if it's ever going to get fixed unless the law is passed.
And that can't be the same excuse that they used 30 years ago. If they're saying that the technology didn't exist, 20 years ago. It exists now. It's been we've grown a lot, I guess, since then. And I just want a quick point that 93%
Streamline,
of
just one, I appreciate this. I'll let you wrap up, but let's just streamline the conversation so that it's not a bull session here.
Okay.
Just directly responsive to the senator's question, and then we can move forward. If the senator could direct a question to an individual responds, and we can move forward.
Sure.
But, Beth, go ahead, please conclude though.
Just a quick fact that 93% of all cases in the state of Maryland are dropped or dismissed. So the good chunk of that I understand that this is like a big, a large number of cases, but those are cases that have not been convicted. No one's been prosecuted, and your constituents have to live with that huge chunk of cases, and it's going to prevent them from living their lives, in a way in which they want to.
Okay.
Getting a job and
Let me ask one final question. Has anybody read the fiscal note for this? How much does the fiscal note show that it's going to cost in order to do this job? And how long does the fiscal note indicate it's going to take?
I don't believe that information was made public so that we could view it. Neither, very similar to the opposition testimony as well. At least the last I checked, maybe the senator may have that information. But yeah, I don't think that was made public. Otherwise, we would have had a common response to that,
Yeah,
Senator.
we can't get this kind of information until hours before the hearing. And I had other bills to work on, so.
Yes.
But it does seem to me that we can't ask the judiciary to do something which is impossible for them to do.
Well,
Because
I
they
don't
don't
think-
have the systems to do
I
it.
don't think that we can see that though, Senator. And my point is that it was impossible prior to MDEC, and now they're saying the very thing that we need to wait for in order to do it is the very thing, the reason that they can't. So at the very least, we should pass this law and work with them on implementation, but we should not any longer allow that to be a delay tactic or an excuse for our people across Maryland to have justice in this way. Thank you.
If I may add,
Actually, sir, I'm sorry.
I think my question.
Thank you very much. All right. Senator Muse.
Thank you very much. And thank you for bringing this bill. I remember 1995 over in the House. This was an issue then. I think it is absolutely horrific for any big institution to say that money and technology should trump what has happened to people's lives. Some were guilty, yes, but to people's lives who have been carrying it for 30 years. For 30 years, they couldn't get a job. For 30 years, they were looked at as though they were still guilty of it. And I hope that no one, I can't tell them what to say, will come up and say, again, and say, well, we can't do this because it's impossible. That's absolutely untrue. It is not impossible. It wasn't impossible 30 years ago. It wasn't impossible 20 years ago. It wasn't impossible 10 years ago. If they wanted to do something, they've always managed to find in this great big world a way to get it done. If I may speak, and before I ask a question from my historical perspective, my major is in Black history. And we know historically, I mean, maybe not so much today, but we know historically, going back 30 or 40 years, why that no one wanted to deal with that. Because it was disproportionately used against Blacks. And we know why. It was to keep them from getting jobs, to keep them from getting housing, and many are still alive, and it's affected them. I have some in my church who are deacons and elders and have been so for 25 or 30 years. They got in trouble when they were young people, and it's still a case. And I am going to talk in general. I'm going to ask you a general question. And so I think when we put our minds together, we can do anything we want to do. But to say I'm going to continue to let a prosecutor who had those charges, who used those charges, 10 charges and only 2 stuck. Well, how can anyone get up and rightfully say, gee, for the 10 that didn't stick, we're still going to allow that to interrupt and make your life miserable? How do we do that? How in good conscience, I don't care what the issue is. They'll say, well, they could have been, and maybe they'll get, no, maybe nothing. This is an issue that we've been on for 30 years. Is there any other legitimate reason that we should be working on that would help us to deal with any real issues other than is this not something we think that should be done? I just cannot see in any way, and pardon me if I'm ignorant on something I don't know about, but I've dealt with this for years and years and years and years. And I've heard nothing except we don't want to do it. We don't think we should do it. We did the charges with it. They didn't stick. They weren't there. So you're still punished for it, even though it didn't happen. I'm sorry, I don't say this, but that's why I am on it. And whatever the problems are, we should be pushing to make it happen. And if others think, well, gee, there's a few who will fall through the cracks, so we need to know their background. We'll do something with that. But don't paint a broad brush and say we can't do anything about thousands who have never committed a crime since then. Not committed one crime. And you can't say in any way that it's worth it to leave it the way it is. Is there any other legitimate issue that I'm not looking at, because I want to be broad-minded about it all? Any issue that I am not looking at, if somebody could tell me other than what I've already said, because that's not an issue for me. None of them are. If you could give me something that really says, this is why we can't do it, don't want to do it. And we're not talking about the 10% who go back and they will commit another crime. I'm talking about the 80, 90, or 90% who did not. That's where we are. And that's where we ought to be putting our emphasis. Right. Anything I'm missing here?
Senator, pick a panelist, any panelist.
I'm talking the senator.
Senator, all right.
Thank you so much.
I'm sorry.
Senator, I appreciate it. And I want to say at the conclusion of your statement that I rest my case because you've made the point very clear. I think that your question is better directed to those that would oppose this bill and that have opposed it, I believe, consistently for the past 30 years. That I have never understood how we could live with the idea that we are now going down a road of allowing people that actually found guilty of things and some bad things. And we say we want them to get another chance, a second opportunity. But non-convictions, an allegation thrown up at you that wasn't proven, it is not okay. And I agree. I don't know how we live with ourselves to let it continue because a big, huge institution says we can't, it's not practicable. So I think that we need to pass the law and we need to figure out how to help work with the institutions on implementation, whether it's more resources or whatever. I'm pretty sure we could point to a few hundred people that this has impacted that will be happy to come and volunteer their time to work on these expungement records. Thank you.
Thank you, Rich. All right, additional questions from the committee. We thought that body cameras were extremely necessary and urgent, but some jurisdictions couldn't afford to do it. There's a logistical and a fiscal hurdle. They got up. So what do? We backdated it. So maybe, maybe there's a path forward there to put the pressure on because it's in the statute, but the clock is ticking. I don't know. I just put that out there for offer because this is obviously a very important issue. But if it's logistically just impossible at the moment, they're going through the procurement process and it's happening. I mean, I don't know. I put that out there for offer. We'll do some more digging on the fiscal note. Senator West, go ahead.
Okay. Let me make the point because the Senator Carter suggested that I was personally opposed to this. I'm not personally opposed to this. I think this is a great idea. I'm simply talking about the logistical and the financial hurdles to accomplish what I think everybody wants to accomplish. So I'm not opposed to this. I think it's a terrific idea. I think we should move on it. If we had more will than wallet, we would do it immediately. But we're in a difficult financial position right now statewide, and the expenditure of millions of dollars would have to be cleared by people who are trying to establish priorities for the state. Maybe this should be one of the priorities, but please don't suggest that I'm opposed to this because I'm not opposed to it.
Well,
if I may, I know because I know your heart and I know that you're in this. I would not take issue if this were not the excuse that was given 25 years ago, 20 years ago, the same excuse. You know what we could have redone in 30 years. And so if we continue with this, it'll be done again and again. Somewhere we got to say it's meaningful. We're going to do it. If it takes you a year to do it, if we've got to put money that we're spending elsewhere on less important issues, we can do it. We should do it. It needs to be done.
If I can respond to that question.
And my question is to you.
Wonderful. Thank you, Senator Muse. You're phenomenal.
Way to exploit that little loophole there. I like that.
Yeah, no, Muse and Dues, we have a lot in common. I do want to just quickly say, because we keep hearing conversations about how it's not possible. And in my written testimony, in fact, I was a part of the work group as well with Mary Denise to discuss the physicalities of this. And on the other side of the aisle, other side of the street, David Moon was also a part of that. And one of the things that happened actually during that work group was a case that was actually released. It's in my written testimony. It's a little graphic, so I don't want to go into too many details, but Deputy Winkler's case. This was a law enforcement officer who he got caught with. He pled out to, I'll just say it. It was a rape charge that was against this law enforcement officer. He managed to beat the rape charge, but he was also given a minor misdemeanor charge as well. Let's just say that the lawyer found ways to work with the court.
Right.
And then they removed the entire docket and then re-uploaded the docket without that charge. And when the lawyer was asked about how this was possible, how could this have happened? He said, well, we've been doing this for about 10 to 15 years. And his argument was specifically because the expungement statute is not fair. This was written in the Daily Record. And like I said, I have a link to it in my written testimony. And I remember in the work group, we were saying, well, wait a minute, I thought we said this was not possible. So there are ways to have it done. And we have the technology already. It just seems as if, we're kind of determining who should get it and who should not. And I'm also responding to Senator West because we do know that you've always been really reasonable in these expungement conversations. And also this case did happen in Baltimore County, your jurisdiction, just something to be aware of. So it's not impossible. Our panel is just pushing back on the narrative because we keep hearing it and then we keep seeing it being done for certain circumstances. And so we're just trying to expand that to everybody.
And thank you for allowing me to express myself as I'm usually very, very quiet. The
No,
quiet
this is
on
good.
this committee.
It's good.
But it means a lot.
I felt like we were in church for a while, so.
Let the church say amen is what I want to say. But
I got
thank you.
drilled this Sunday, so I'm gonna miss, so it's good. I got my sermon today.
A final word,
Yeah.
I would hope that we would not let those delay tactics and excuses continue to stop this legislation. But my suggestion would be that we pass this legislation. And if it is so overly burdensome or so impracticable or completely impossible, we will certainly hear from those that want to come back before us and tell us of the burdens. And if we can help them with greater resources, then we certainly can.
I hear you. I hear what you're saying. I just, obviously technology has evolved rapidly over the last 30 years. And so like to say, it's kind of a weird equivalency because things are now to a point where we can do this. We can. That was not true in the 70s. That was not true in the 80s. It's true now. If they're going through the procurement process and they're going through that process right now, and it's going to take however much they're telling us that it's going to take to implement. I liken this like the body cameras. I mean, folks were telling us they were under financial strain. They could do, they want to do it. They can do it. It's in the pipeline. So if you put it in the statute, you start that clock. And so I just open that for discussion. Let's talk because I think
We certainly could give a future date for full implementation.
No, I hear you. That's what I'm talking about. Because I love this bill. So anyway, just trying to find a path forward for it. All right. Any other questions? All right. Thank you very much to the panel. Thank you very much, Senator. We'll bring up the next panel. Do we have George Townsend was up there? Let's see. Harold Coleman.
He had to work. He was not available for this.
Okay, excellent. And then E. Flannery Gallagher.
Oh, is he? No. Hey, I'm sorry. I got it.
There you go. All right. Come on up, Mr. Coleman. And then George Townsend, that was already there, right? You got me. Excellent. Thank you. Is there anyone else that I've missed that would? All right, got it. So we'll hear from Mr. Coleman first. Welcome. Welcome.
Yeah, how y'all doing?
Pretty good. How about
Yeah,
yourself?
welcome. I'm in that same situation. I have a bunch of unit rule charges or charges that, I cannot remove based off of the unit rule. And so it's pretty much, we need to move forward and start trying to free up some things so we can get people moved on, because I feel like once we've been held accountable, everything, and you pay your debt to society, things need to move forward. It really does. Because I'm still caught up in the same web. It's been almost 25 years, and I'm trying to move forward, so. Thank you.
No, thank you. Thanks a lot for hanging in there with us tonight. Questions from the committee? Excellent. Thank you. Welcome.
Good afternoon. My name is Flannery Gallagher, and I'm a legal fellow at the University of Baltimore School of Law's Center for Criminal Justice Reform. The center is dedicated to supporting community-driven efforts to improve public safety and address the harm and inequities caused in the legal system. We are grateful for this opportunity to testify in support of Senate Bill 11. Prohibiting the partial expungement of eligible offenses under current law unnecessarily and unfairly impedes Marylanders' access to stable housing, education, healthcare, voting, occupational licensing, rights to the parent-child relationship, and more, including well after they have successfully completed any sentence. Allowing for partial expungement of eligible offenses is one important part of a broader set of efforts to mitigate the collateral consequences experienced by those impacted by the criminal legal system. Senate Bill 11 would prevent the likelihood that a potential employer, institution of higher education, Department of Licensure, or housing provider that obtains a fingerprint background check would penalize an individual for a charge that this body has already determined should be expunged from that person's record. Charges that would be expunged include non-guilty verdicts such as acquittals, dismissals, and null prosequi dispositions. On behalf of the University of Baltimore School of Law Center for Criminal Justice Reform, I want to thank you all for the opportunity to testify in support of this important bill and welcome any questions the committee may have.
All right, seeing none, thank you.
Thank you.
They got it all out on the other panel. Okay. All right, so that'll conclude the testimony for the proponents of the bill. We'll now hear from the opposition, Mr. Kroll, Mr. Cox. And that's it.
Walking into this buzzsaw. Mr. Chair, Mr. Vice Chair, members of the committee, I'm John Cox. I'm Deputy State's Attorney for Baltimore County and also speaking on behalf of the Maryland State's Attorneys Association. There's another side to this that has not been disclosed here, or I should say, I'm not trying to imply something not being hidden. But this bill, as it's written, would mean, say, for example, somebody's charged with first-degree murder. They come in and plead guilty to first-degree murder. As a part of my plea agreement, I null-pros the robbery and the burglary and any other offenses that were within that indictment. That person can the next day file for expungement because I've null-pros counts within that case. And that is part of the logistical nightmare of how do you excise the particular details of the counts that were null-pros as opposed to that which was ended up in the conviction. Same thing happens probably, basically what this means is almost every case ever in the state of Maryland is subject to expungement. There's rarely a case where there's just one count and the person was found guilty of that one count. There are counts that are null-pros. Jury trials, the same thing happens. A sex offense victim who can't go through the trial process that we plead a case to second-degree assault, that person then would be entitled to expungement of what they actually did, even though the facts presented to the judge were that sex offense as the basis for that second-degree assault. The issue has been addressed already by this legislature through the expungement process. The vice chair came back last year and even narrowed down those timeframes. The example given of the delegate with this second-degree assault conviction 30 years ago, that makes no sense. That delegate could have had that expunged and would be expunged, and then the entire case is gone if there were other counts that he was subjected to. The bottom line is the issues that have been addressed, all of the minor offenses that we've heard about that are causing a major offense to still be there can be expunged and will be expunged should one ask. We are opposed to this bill. Thank you.
Chairman, Mr. Vice Chair, members of the committee, I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984. Let's take a little bit of history, Senator Muse. All the proponents, none of which in my 39 years I remember ever being a prosecutor, who allege that we overcharge or use tactics are wrong. We go through the grand jury, community members, citizens press charges. No tactics, no overcharging, citizens like you, like everyone else who come in to charge the case. Here comes Senator Carter, the defense attorney. What does she want? To go on one count. Why? It eliminates exposure to her client. Doesn't mean that her client didn't do the rest. Doesn't mean it at all. They probably did do the rest, but why? Come to Ms. Braveboy's court. Come to Mr. Bates's court. Come to Mr. Schellenberger's court. It's called plea negotiations. Doesn't mean they didn't do it. We do this because it's the right thing to do, what we've taken an oath to do. And that's something the proponents who've never been prosecutors have to understand. Didn't mean to do it, but here comes Senator Carter. That's what she wants to do. There are ways to expunge, as Mr. Cox said. The community does the charging. And I can urge this particular body to give an unfavorable report because, Senator Muse, I'm not saying people don't deserve a second. I'm just looking at you because you were the one who was so verbal about it. And I know you are, and I'm ready to challenge you on it. Because we do the right thing. We do the right thing.
Same thing all the time. And I'm sorry, but I'm sorry, I'm going on that road.
Well, you could ask me questions. You could ask me questions. I'm happy to answer them.
All right.
I'll waive my 30 seconds. I just don't want to be accused of overcharging in tactics. We will do the right thing. And when Senator Carter comes up there, we do the right thing for her as a defense attorney.
And I don't know why
I'm
that
not,
is.
I like you.
Because
You know, I personally like
and
you.
you're my friend as well. You know
Yeah,
that.
That's why I like doing this with you.
If something that you do because you have to get a conviction You've got your conviction, but there are eight other additional charges there. You got your conviction. What's the problem with, if you want to get a conviction, you have the evidence to get the conviction, but to just let them stick on there and stay on there for 20, 30 years, not 2 years, not 3 years. Gee, we want to continue to do that. And yes, I am emotional about this because I've seen it happen. I've seen good people for every horrific anecdote that you all can give. You can always give the worst case scenario. We're not just talking about the worst case scenarios. We're talking about people who couldn't get a college degree, couldn't get money for college, couldn't live where they wanted to live. And for anyone to tell me, and I apologize, and yes, you're my friend, I'm taking out buy you a burger soon. But for anyone to say to me that it's worth keeping the whole system like it is, because of anything that you just said to me, and in all due respect, I don't understand it, can't see it, and changes have got to be made. Yes, historical. I can talk to you from an historical perspective, cultural perspective, sociological, from any way you want it to go. At some point, to say that no change is warranted in this is just something I cannot understand, and it's something that I will never understand. I understand where you all are. That's your business that you're in. I got a conviction. Gee, I got a conviction because I said I'm going to throw all these other charges at you. And so, of course, I'm going to plead, and many of them should have. But then to say I'm going to leave it on there and just bye-bye, see you another decade, that's how I see that. No, I'm not with that. And thank you, sir, for that.
I may respond, Senator.
Sure.
And you are my friend.
Yes,
always
indeed.
will be. I enjoy this, just to tell you. But you use the word have. I don't have to have anything as a prosecutor. I have one thing to do. Justice. I don't have to have a conviction.
And
I don't have to have anything.
We're talking about justice.
Right, but you said I have to have a conviction. I don't have to have a conviction. I have to have justice. So to say I have to have anything is wrong. So please don't say we have to do that. Second of all.
Well, that's what I'm getting from you all. That's why what's the other reason for giving 10 other charges?
You have not used the word victim at all, and I don't understand that. A victim who's gone through, as Mr. Cox said, sex offense. Are you telling them that their case didn't happen?
Excuse me?
Are you saying to the victim?
Are you telling me that because I responded the way I do, that automatically means I don't care about victims? That's absolutely, that's not correct. And I'm sorry if it rubbed you the wrong way, but I'm sticking with what I've said, no matter what you say, to try to change that. And I don't like the way you say. Thank you.
Mr. Kroll, please.
Yes.
Thank you.
I'm sorry, Mr. Chairman.
All right, we're gonna take it.
I'm just saying,
just one
my
second.
passion.
1 second. I get it. I understand. Look, I appreciate this. This is great. I've had disagreements with everyone in this room. I've worked with everyone in this room. So just take a hot beat. Remember, just realize that this is pretty great. We get a chance to do this. We get a chance to come down here, spend 90 days together with our closest friends, and hopefully make some good progress for the state of Maryland. So just take a giant step back, everybody. Just for advocates, for the lawyers, for the members. This is great. This is a pretty remarkable experience that we're having here. It gets hot sometimes, but just keep that in mind, that this is a pretty unique and precious process. So, yeah. All right. I appreciate that. Senator Carter, go ahead.
Apologize, I'm going to end with a comment and not a question. And it's addressing something you said, Mr. Kroll, on a bit of a lighter note. I wish that it were true that I walk into a prosecutor and the prosecutor decides to go on what I say, okay? And if that is in fact true, please send out the memo to the prosecutors across the state of Maryland. But we know good and well that usually it is the prosecutor who makes the decision of we can go on this and not that, and for various reasons. But we know that what they go on usually is the thing that they think they could likely prove if we went to trial. And so that is the issue.
Well,
it wasn't a question, but
I know. I'll answer that and just say this. You and I have had a very good relationship as far as cases that have been prosecuted. And I've listened to you as a defense attorney many times. You come to me and say, what about this or what about that? So maybe normally a prosecutor is the first person to make the offer. But I've always listened, and I assure you the 641 other prosecutors would also do that. Mr. Chairman, my passion is victims and witnesses. You know that. Every member of this committee knows that. And I'm not going to ever take a step back from representing victims and witnesses, no matter what. Their cases should be heard. Their counts should be heard. If we do plea negotiations, it's because we have to. Doesn't mean it didn't happen. And I don't want it to go the other way to say we have to call every count. That would be wrong. But my passion And I'll let Mr. Cox, because it did get a little heated, and I apologize to Senator Muse if we did get heated, but you're still my friend. But you know my passion will always be victims of witnesses, and I will always represent their interest.
No, this is great. Look, we're all here for the right reasons, and it does get hot sometimes, but you know, when we forget that we're all here trying to further justice, open up opportunity, ensure that victims are taken care of, and ensure that there's equity in the justice system. That's why we're here. So this is a good exchange. It gets hot, but just remember that.
I know Mr. Cox wants to fill in what I missed.
Yeah, no, that's great. All right, I appreciate you all. That was fun, but no more. Okay, for the rest of the day. Let's keep it cool. All right.
I'm afraid to say there's more bills happening.
Yeah, I know, we got more
Wanted to push
bills.
them
Let's
aside.
keep it cool. Let's keep it cool. All right. All right. Yeah, that concludes the hearing for Senate Bill 11. We'll now move on to Senator Carter with Senate Bill 123. Senator Carter, you're up. Would you like to bring up a panel? Okay.
Chairman Smith and Vice Chair Waldstreicher and all members of the committee, thank you for always having great endurance and continuing to stay engaged. It's very important. I'm sorry that this bill is so late. I know that we're getting a little anxious, but please be patient and hear us out. I'll try to be as brief as possible, but it's a very important issue, and so it may take a little bit of time. The importance, efficacy, and necessity of this bill simply can't be overstated. For many years now, we have grappled with the idea of our mass incarceration, overcrowded population in prisons, how to enact justice as the state in this country that incarcerates a huge percentage of Black people disproportionate to the population. So many bills that we've dealt with, including the Juvenile Reform Act a couple of years ago, sponsored by Senator West. This bill is a necessary bill, and everything that we've done and every opportunity we've presented still is not good enough to really ensure justice for people that have been sentenced to excessive sentences that are unnecessary. And so with that, I do have to go into a bit of detail with this bill. It's the Second Look Act, and there is no other mechanism that we have in current law that would really allow people that have lengthy sentences that have been rehabilitated to file a motion to a court after 20 years and be able to have a consideration of a modification or reduction of that sentence. We have other mechanisms such as post-convictions and other things that deal with constitutionality, illegal sentences, but we don't have any mechanism that deals with the person and what they have or have not accomplished, how they have or have not been rehabilitated since the time of their sentence. And even with the Juvenile Reform Act, it did not address many of the persons currently incarcerated because it did not go back. And so with that, currently individuals serving exceptionally long sentences in Maryland can only seek a sentence review challenging the constitutionality of their conviction. I also want to point out this bill is really not an exotic concept because prior to 2004, this was already an option. In 2004, the Rules Committee decided to pass a rule that limited a person's ability to have a reconsideration of their sentence or a review of their sentence after 5 years. Now, here's why that's problematic. When people get long sentences, 5 years is usually not enough time for them to show that they've changed. It may not even have been enough time for them to prove for them to serve. But 20 years and 30 years is certainly enough time for that person who may have been as young as 14, could have been 17, 18 at the time, 20 years, may have gotten degrees, may have done every single program, every single therapeutic and system and counseling system that the prison system has to offer. Also could already be released. And because they have now done everything right and they are still on parole, or they still are inhibited from full citizenship. So they could still go back to the court and say, hey, I need a modification or reduction because this is really not necessary. I'm not a threat to public safety, and justice would merit that you would review and modify the sentence. We know also in this committee, because we passed the out of committee and out of the body a few years ago, finally, through the help of Walter Lomax and that group and many others, the bill to get the governor out of parole. We know that for 25 years in Maryland, individuals were basically sentenced to life with parole, but were denied parole. It was effectively non-existent for them until we passed the law to get the governor out of parole. This bill ensures that sentences can be reviewed based on our current understanding of fairness and justice, which has evolved tremendously over the last number of years. Frequently, it's asserted in this committee and outside of this committee that people serving life sentences are inherently the worst of the worst. I understand that sentiment, but it's not my personal experience. Over the years, I've gotten to know many, many people that have served lengthy sentences that have been incarcerated to long periods of time. I've been to the prison to visit persons that are serving life sentences, and I've found some of the most insightful, some of the most warm-hearted, some of the most helpful, some of the absolute best people that I have ever met. Within the confines of the prison, they work to organize, educate one another, and share insights with those beyond the walls, insights that may have steered them away from incarceration. These individuals initiate anti-violence initiatives. They seek ways to engage youth from their neighborhoods, and they attempt to mentor younger family members through phone calls and prison visits. On the first panel that I'm going to ask to come up, one such gentleman who I've met, Mr. Anthony Muhammad, who works with Baltimore Brothers and other organizations, is one such exceptional person. I'll just share with you that when Mr. Muhammad has come into court to speak on behalf of any of my clients about his program that we want to steer them into, the judges have been absolutely fascinated and impressed with him and asked, where have you been all of our life? Where have you been? We have been looking for someone like you. He's a joy, and you'll hear from him shortly. Many of the people who have been released from extreme sentences in recent years are like Mr. Muhammad. They are building public safety in the community. They are strengthening families in our community. And our mission ought to be how we allow those people to once again join society when they are actually a benefit and not a detriment. This bill in no way is a get out of jail free card. It is no way something that is a detriment to public safety. If someone is not shown that they ought to be out, then certainly there is discretion to deny them. So simply, it would require that after 20 years of serving a sentence, 20 years, they are eligible to file a motion for modification or reduction of sentence and have a court hear their case, hear their story, hear their reasons. The court denies it, they do get another bite at the apple, but 3 years later. As someone earlier spoke about, when you allow people a potential opportunity, it gives them hope and often causes them to be better people, causes them to avail themselves of educational opportunities and all of the other good things that are available in the prison system. We've seen, when we saw the results of the Unger decision, which involved 235 people, most of whom were released and very few have recidivated. We know that persons that are sentenced to longer sentences, once they are rehabilitated and let out, they're less likely to reoffend or recidivate than anyone else. We know that it takes about $38,000 a year to house an inmate. Even for those of us that focus solely on the worst act a person ever did, never believing they should have an option to see the light of day, we do care about our budget and wasting our taxpayers' money housing people that don't need to be housed. And so with that, I would like to introduce my panel, and I would ask that we would wait for questions for some of the experts that I have. And so I am pleased to bring up the panel, assuming they're all still here. It's a great honor and privilege for me to bring up Stuart O. Sims, who is the former state's attorney for Baltimore City, as well as the public defender, Natasha Dartique, Michelle March, who is with the Maryland Criminal Defense Attorneys Association, Anthony Muhammad, who I already talked about, and Yannette Emanuel with the ACLU.
Mr. Chairman, members of the committee, respectfully thank you for the opportunity to appear here today. My name's Stuart Sims. I'm a member of the Maryland Bar, and as I said, been involved in public safety roles and in private practice for quite a few years. I appear here today in favor of Senate Bill 123. As an advocate on both sides of the poll, including serving as Secretary of Public Safety, I was around when the last two executions were done. I was present. I've seen both extremes. I've been an advocate for victims' rights. But I'm here today because the legislation is practical, common sense. It is balanced, is consistent with our situation regarding decency and in the public safety interest. If passed and implemented, this bill would slightly expand post-conviction relief for a very small segment of individuals that are tiered specifically according to the bill. The procedure and eligibility for relief proposed are limited, and an individual can pursue relief even if the state, in its discretion, if they wanted to, could submit a claim. Procedure outlined in the bill gives a very clear 10-point factor for assessing factors for a person's transformance, if you will. And I just want to underscore what the senator has indicated. This is not a reversal of conviction if relief were given under this procedure. There's no forgiveness or exoneration, doesn't conflict with any other processes or gubernatorial authority, and it does not interfere with the parole process. I'm particularly attracted to the age factors in the bill, that is the 20-year period of time or 30-year period of time in that particular case, particularly with the 30-year period of time, because individuals over 60 or older are limited in Maryland, according to the last public safety annual report, to less than 1,600 persons. But I urge your careful consideration and hopefully favorable consideration of this particular proposal. And again, thank you for the opportunity to testify in support of Senate Bill 123.
Good afternoon, Mr. Chair and members of the committee. I am Natasha Dartigue, Maryland Public Defender. The Office of the Public Defender supports Senate Bill 123 and requests you return a favorable report. Senate Bill 123, Maryland's Second Look Act, will allow incarcerated individuals who have been confined for at least 20 years to apply for judicial review through a modification of sentence. We support Senate Bill 123 for several reasons. One, rehabilitation is the norm, not the exception. The bill aligns with evolving understanding of criminal justice and rehabilitation. It recognizes that people can change over time, and the punitive approaches of lengthy sentences are not always the most effective or fair responses. Second, it builds on Maryland's success in safely reducing the prison population by giving judges the opportunity to release individuals who have served a substantial period of time and shown themselves to be rehabilitated. In 2017, the General Assembly took a positive step through the enactment of the Justice Reinvestment Act, which allowed judges to modify sentences imposed in certain drug cases where they were mandatory sentences. But however, what predates that was the important decision by the Court of Appeals in Unger v. State. And as a result, from 2012 to 2017, individuals serving lengthy sentences for serious offenses were released. More than 5 years later, the recidivism rate is approximately 3%. Third reason, releasing a mature, rehabilitated individual who has demonstrated fitness and served decades in prison does not pose a risk to public safety. Extreme sentences, in fact, hurt public safety by consuming massive sums of resources that could otherwise support programs and prevent crime. Extreme sentences are also often unjust. OPD supports this bill also because it is a racial justice bill. Its importance can be understood in the context of systemic bias, and disparities within the criminal legal system. Black men make up about 14% of the population, but 73% of the prison population. Lengthy sentences disproportionately affect marginalized communities, especially Black and Brown people. It perpetuates cycles of poverty, limits employment opportunities, and compounds social disintegration. Senate Bill 123 provides a mechanism to address these injustices. The Office of the Public Defender requests that you return a favorable report. Thank you.
Thank you very much. Just an administrative note. I did not time you, obviously. So we have five, I think we have 5 or so elected state's attorneys, one of whom I did not time. So for balance, I did not time our public defender here, but for the state's attorneys that are coming up, the timer is going to keep going. So just to keep everything balanced, just so you all know. But thank you very much. All right.
Good afternoon, Mr. Chairman, members of the committee. Thank you, Senator Carter, for bringing this very important bill and for allowing us to support you. My name is Michelle Martz. I'm here on behalf of the Maryland Criminal Defense Attorneys Association, which is a 400+ membership group of private defense attorneys here in the state of Maryland. We support this bill. We ask you to return a favorable report. We encourage anything that allows for rehabilitation. This bill is a measured bill. It's a fair bill. It allows for articulated standards that everybody knows what the rules are, and it's an overall good bill. I echo and support everything that Mr. Sims and Ms. Darty just said, but let me say this to you. I am from Frederick, the western part of the state, and I may have been raised there, but I grew up in the courtrooms in Baltimore City as a young public defender in the mid-90s. And let me tell you what Senator Carter said is absolutely true. I stood there, I watched the hefty sentences, life plus, life for even when people didn't die. One of the things that I feel like this committee needs to understand is that those people are still, many of them are still there. I not only did trial work, I do a large amount of post-conviction work, a large amount of appellate work. It is very true. This bill fills a necessary gap. There is no remedy other than this type of bill for people that have passed the window of opportunity for modifications. But I want to say 2 quick things. The inchoate offenses also carry life. The conspiracies, the attempts, it's not just the people that pull the trigger. We have accomplice liability, aiding and abetting in Maryland. Those things are very important to understand. We sometimes focus on the worst of the worst instead of understanding that some people just get caught up and get swept up when they were young people. The clients that I have that have served decades in prison, they have something to offer this society, this community, and they deserve a meaningful opportunity to return. I'm happy to answer any other questions about the other remedies that are available if you have any.
Good evening, Mr. Chairman, Vice Chairman, members of the committee, to this distinguished panel, and Senator Carter, I'm honored to be with you. My name is Anthony Muhammad. 31 years ago on January 26, 1993, I was arrested for 2 homicide charges in the city of Baltimore. I was ultimately convicted and sentenced to life plus 20 years in prison. I served a total of 29 years, 7 months, and 29 days. During my sentencing hearing, the judge mistakenly believed that I was unredeemable, unreformable, and that the acts that I had committed were unreconcilable. The sentencing judge stated that I had little prospect of ever being able to come out and function, and that I had showed very little hope of rehabilitation. Thankfully, the sentencing judge was all wrong about me. 16 months ago, on September 20th, 2022, I was released under the Maryland Juvenile Restoration Act. In fact, the judge who released me said the exact opposite about me than the judge who sentenced me. In fact, the judge who released me said that in all of her years on the bench, what I had accomplished throughout my incarceration was so remarkable that this was the first time that she had absolutely no reservations about releasing a violent offender. My story is not unique. There are many other long-term returning citizens that are just like me, phenomenal records throughout their incarceration and are doing phenomenal work in the community right now. Currently, as we speak, I'm a community engagement specialist for the We Are Us organization. We are the new front line in the fight to make our communities safe and decent places to live. We go door to door, block by block, street by street, with boots on the ground, engaging the community, bringing them hope, bringing them inspiration, showing them a different way. And what we are asking this committee to do is to give dozens of other men who are just like us that are still incarcerated, who were not juveniles, were not under releases, but have the same phenomenal record, the opportunity to come out and help contribute to our community. For those reasons, we ask this committee to make a favorable vote. Thank you.
Good evening, Chair Smith, Vice Chair Wallstrecker, members of the committee. For the record, my name is Enid Emanuel, Public Policy Director for the ACLU of Maryland. The devastating super predator mythology and lock them up and throw away the key mentality for the last 30 years has led to harsh changes to law and policy. It has also resulted in Maryland's prison population system being filled with Black people who are excessively sentenced and denied parole. For more than 25 years, Maryland's parole system was not available for people serving life with parole sentences, which contributed to the bloated prison system and its extreme racial disparities. Now the governor is removed from the parole process for the most part. However, this is not enough to remedy decades of wrongful denials. Furthermore, unlike court hearings, parole is not a judicial hearing. People have almost no due process rights and no legal representation to prepare for strong presentation. Equally important, in the immediate aftermath of a serious harm, emotions are high, and it may be difficult for a sentencing judge to determine a person's capacity for change. But many years later, a judge can assess a person's growth, progress, and rehabilitation behind bars based on their actual track record. This evidence-based initiative recognizes the transformative potential of focusing on rehabilitation and the urgency of addressing racial justice in our criminal legal system. Lastly, the reality is that people do change and people can grow out of crime. And our law should reflect this. Many of our failed policies were enacted prior to the current research that we have on brain development and risk. For example, a 2019 National Academy of Sciences report concluded that emerging adults are more likely to engage in risky, impulsive, and sometimes criminal behavior because they're not fully developed. The report explains that most late adolescents will naturally grow out of this phase and fundamentally change their behavior, including through neurological growth and enhances in their capacity for reasoned decision-making under stress and future-looking orientation, and are uniquely amenable to rehabilitation. SB 123 represents a vital step towards justice, especially for those who may have encountered bias in their interactions with law enforcement, the courts, or corrections, by ensuring that decades later, sentences can be reviewed based on our current understanding of fairness and racial justice. For all the reasons mentioned, we urge a favorable report on SB 123. Thank you.
Questions from the committee? Senator Muse.
And I'll preface it by saying to you, sir, and to those in the room, you know, I'm very quiet, very mild-mannered. I say it all the time. But anyone who stands and points their finger at me, calls out my name and yells at me should expect whatever I say. So thank you for letting me remind people that's not generally me.
Isn't
Now,
that so?
to you,
Hey,
Mr. Muhammad.
I appreciate you, man. I
Mr.
appreciate
Muhammad.
you. All right.
Yeah, isn't that so, Mr. Muhammad? You're to be commended. You're the reason that we fight for people. You're the reason that we stand up for people, and you are the perfect example of what we do. You said that that they said you were not redeemable. How old were you then, and what would lead a judge to say something like that?
Could you come up to the podium? So thank you very much.
Thank you, Senator Muse. I was 15 years old when I was arrested.
15?
Yes, sir.
And at that time, it was decided that you were not redeemable.
Yes, sir.
Thank you. That's the reason we do what we do. Thank you.
Additional questions from the committee? All right, thank you all very much. Thanks. All right, we now go to is Edward Sabin here? Ami Forche? Or Amy? And Katya Hamilton? And Martina Hazelton? Parshell Shannon?
All right.
My name's Ed Sabin, and I want to thank Senator Carter for introducing this bill. I'm a member of the Maryland Alliance for Justice Reform, but more importantly, I've been a volunteer at Jessup Correctional Institution on and off for over 25 years. And I've been working with a organization that is a self-help organization, volunteer run, that I think is very effective. And it's called Alternatives to Violence Project, AVP. And some people who have been on the inside know about it. My written testimony spells out more details about the program. It's basically a series of 3 workshops that last for 18 or 20 hours. And people go through it, sometimes are changed. And I have met a number of men at JCI who have rehabilitated themselves over the years and are serving long sentences. And I've always thought, I wish I could do something, that their leadership is needed in the outside world. At JCI, there's a waiting list for inmates to take the weekend program. And one of the beauties of the program is that people who take these 3 workshops, weekend workshops, can qualify as facilitators themselves. And I love to see inmates leading programs like that. And it's much more effective, obviously, than outsiders coming in and talking to people. Thank you very much.
Hi, good evening. My name is Amy Fauché. I was asked to give my testimony on behalf of this bill because I served 8 years in the Maryland Correctional Institute for Women and have a personal insight into our criminal justice system. Prior to my incarceration, I was living what outsiders would consider an idyllic life. I was a productive member of society, working as an RN, married to a lieutenant in the police department, and a mom to a beautiful 3-year-old daughter. I was outgoing with many friends and participated in many community events. What people didn't see was the abuse I was living with behind our closed doors. This abuse led to some horrible decisions and ultimately my incarceration. All I had known about prison is what I had seen in the movies, and I was absolutely terrified when the county transport van pulled through those razor wired gates. The officer inspected the van, must have seen the terror on my face, and assured me that I was going to be okay. He was right, but it did take quite a few months to acclimate myself and try to make the most out of this worst case scenario. But what really surprised me about my incarceration is that there are so many women there who were just like me, in that they got caught up in a bad situation in an instant and made the wrong decision. It also wasn't surprising that the people I gravitated towards were all long-timers. These women inspired me because of their strength. Throughout their 20, 30, even 40 years of being incarcerated, they continue to be productive members and make the most out of their life behind those razor wired gates, all while dreaming about their freedom and the amazing second act that they are going to live. These women that I would consider some of my closest friends are by no means a threat to society and would flourish if given the opportunity for freedom. Currently, for most people serving life sentences, their only hope of release is through the parole process, which takes years. It's not a law, but they do have to go through a risk assessment. My friend Latina Smith is 53 years old. She's been incarcerated for 28 years, and she's waiting now 20 months for risk assessment, up to 27 months. And she would be a perfect person for a second chance. Thank you.
Hello, and thank you, Senator Carter, for presenting this bill. SB 123. My name is Brichelle Shannon for the record, and my husband is Omar Shannon. He's currently serving a life sentence. He's been serving that sentence for 28 years this year. And his case is actually with the Innocence Project, seeking his actual innocence. So today, lawmakers, we stand today at a crossroads. Before us lies a path towards a more just Maryland, a path paved with the promise of second chances and a commitment to dismantling the systematic inequities that stain our criminal justice system. That path is illuminated by SB 123. Let's be clear, Maryland's incarceration crisis is not merely a matter of numbers, though the numbers themselves paint a stark picture. The latest Department of Justice data reveals a shameful truth. Black people make up over double the national average in Maryland's prisons. This isn't just an imbalance, it's an indictment of a system that perpetuates racial disparities at every turn. And the injustice goes deeper. Look at the faces etched in despair behind bars serving life sentences. 77% of them Black. These are not simply statistics. These are individuals, mothers, fathers, sons, daughters, whose lives have been swallowed by a system that prioritizes punishment over rehabilitation, vengeance over redemption. This bills offer a beacon of hope in this pervasive darkness. It empowers prosecutors to petition for sentence reductions based on evidence of rehabilitation, changed circumstances, and diminished risk. It opens the doors for those who have demonstrably reformed, who have earned a chance to rejoin society and contribute positively. Passing this bill is not just about correcting past wrongs, it's about building a safer future. Studies tell a clear story. Individuals who've served 20 years or more successfully rejoin society and reoffend at significantly lower rates. Look no further than the Ungers. A mere 3% of recidivism in comparison to Maryland's staggering 40% recidivism rate. This bill isn't just about second chances. It's about investing in proven rehabilitation, a strategy far more effective than the walls of endless incarceration. I urge you to support this bill.
Thank you very much.
Hello, I am Martina Hazelton. I am the co-founder and executive director for Family Support Network. And who do I represent? I represent hundreds of family members that have incarcerated loved ones of Marylanders across this state. I've been before this body on several occasions, and when I stood there before, my husband was incarcerated. However, by the grace of God, on November 9th, 2021, he walked a free man. But I want you to know he was also sentenced at the age of 16 to 2 consecutive life sentences plus 23 years. To me, they threw him away with no hope of giving a second chance. I was here when the passage of to petition on the behalf of the JRA that was sponsored by Senator West, and we thank you. I was here 10 years ago across the street when Senator Foden sponsored a similar bill. And I stand here today with a champion and a hero, I say Shiro, Senator Carter, who is taking this up. I am still in this fight with the family members because I know exactly what they're going through. The previous speaker said redemption. That's a key word. Because if you believe in that, then you must also then believe in second chances. And these people have demonstrated, have shown, have taken every class, have mentored, have done everything they can. And all they need is one look for somebody to say, I believe you. Go forth and do great things. I urge you to vote favorably for the passage of SB 0123.
Thank you very much for your testimony. Seeing there's no questions from the committee, we'll keep it moving. We heard from Curtis Alston, is that right? Curtis Alston. No, he's right here. Anthony Mohammed, we heard.
Curtis Austin.
Yep, that's right. Yep, you can come on up. David Bradford. And Joan Dorsey. Miss Hilliard. Serena Lau. All right, whoever would like to take the podium first.
Thank you, Chairman. Senator Carter, for allowing me this opportunity and for believing in people like me. To all assembly. Today I stand before you to discuss a matter of profound importance. The passage of Senate Bill 123. The Maryland Second Act, this bill represents not just change in legislation, but a monumental shift in our perspective on justice, rehabilitation, and transformative power of time. Let's start with the fundamentals truth backed by extensive research. People age out of crime. Statistics show that criminal activity significantly decreases as an individual enters his late 20s and 30s. The National Institute of Justice affirms that the likelihood of reoffending diminishes with age. This isn't just a trend, it's the clerical call for reform. By adopting the Second Look Act, we acknowledge that this reality embraces a system that prioritizes rehabilitation over indefinite punishment. Consider the stories of those who have already walked this path. Individuals who, after decades of incarceration, have been given a second chance. Their stories are not just anecdotes, they are beacons of hope and tangible proof of transformation. Take the example of John, who after being released at age 40 has dedicated his life to mentoring at-risk youth, steering away them from the mistakes of his past. Or Maria, who is now an advocate of women's rights and provides support to those affected by domestic violence. Consider my journey, a former lifer who remained infraction-free for 16 years, navigated re-entry successfully, and completed 9 years on parole. Today, I don't live just as a free man. I serve on the Lived Experience Council. I'm a peer recovery specialist and show others how to do the same. My story is a testament and evidence to the profound impact of the Second Look Act. Those that spoke aren't isolated cases. They are people of growing body of evidence that support effectiveness of a second chance. The Maryland Second Look Act isn't about overlooking the severity of crimes committed. It's about acknowledging that people can change and that our justice system should allow the possibility of redemption. I had so much more to say, but I will say this. This is State Bill 123, so I encourage you to do 1, 2, 3, activate. Thank you.
Hello, everyone. Thank you. Thanks for allowing me to speak. My name is Davita. I'm here on behalf of a lot of people in prison who serving these lengthy sentences, who can come out and be model citizens. We all have made mistakes. I definitely don't want to be judged by the person who I was 20 years ago, even 13, 15 years ago. We all change. Being able to change does not have an expiration date. We can all grow. We can all be better people. And those people who've been in prison 20, 30 years have definitely grown. They are not the people they were the time ago when they committed those crimes. I would also like to say that holding them back, we are not giving the community what they need. They can be productive citizens. They have a lot to offer. My loved one who was behind bars, who was fighting for his freedom, is such a smart, amazing man. He's definitely not who he was years and years ago. He's studied. He's gotten degrees. He has a lot to offer. I ask that you please take a second look. Some of them haven't had a first look. Unfortunately, they were doomed from the womb. We have all had second chances. Some of us have had third and fourth and fifth chances. I beg and I urge you, I plead with you to please give this bill some consideration. Thank you.
Ma'am, before you go ahead, Senator.
During questions, and this isn't really a question, but to Ms. Bradford, I just want to say thank you. As I walked in early this morning, Ms. Bradford was sitting out in the hallway. She had come here early this morning, straight from working all night. And I asked her why she was here, and she said, this is important. Thank you very much.
My name is Joan McNear Dorsey, and I'm here on behalf of my son and in support of the bill SB 123. And I just wanted to just give a little backdrop on my husband and I adopted my son at 2.5 months old. okay, who had basically a number of health impairments, mainly Tourette syndrome. With Tourette syndrome, and it was very little that was known about Tourette syndrome back in 1990. And so he went through quite a bit with the intimidation, the teasing, running home from school. We had to pick him up and take him to school and pick him up from school. It was just a number of things, that threats, etc., that he endured. And he began to be involved in a lot of reckless and unruly behaviors, which even because of the fact that professionals, medical professionals, as well as teachers, being in church, nobody really understood, because he was a bookcase example of TS. And so with the jumping and the jerking and making a lot of different noises and everything, my husband and I were constant advocates for him. He has been incarcerated for was 19 when he went in, and he's been in now for almost 20 years. He has been a model inmate, and I know that he would definitely greatly contribute a great deal to society. We know that Maryland is leading in the number of incarcerations, particularly with Black men, and given the longest sentences in Maryland. So I just want to ask you all now, can you do more? Can you do more? Have you done more? I think this bill needs to have a critical look at it, to be examined very, very carefully, to see exactly. We've already heard all the statistics, so I don't need to go over that. But I think that definitely needs to take place. So I am in support, and I urge you to do the same. Thank you very much.
Hello, my name is Serena Lau. I am testifying in support of Senate Bill 123 as a lifelong Maryland resident, and I have a loved one who's been incarcerated for 35 years. He's had no infractions in over 3 decades. He has taken advantage of all of the programs that have been offered to him in every facility, and has expressed understanding and remorse for his crime. And at this point, it is unclear what else he can do to prove that he's worthy of release. And his case is not unique, as we know. This shows us that the mechanisms that are in place now are not enough. And this bill is an opportunity to create a viable pathway forward for people. The Parole Commission does not have the capacity, infrastructure, or efficiency to process the volume of people that this bill encompasses. And I think it's also important to note that the victims, they matter. And of course, the impact of serious crime has to be acknowledged. It's a long-lasting impact. And I believe that all victims and their loved ones should always have the opportunity to pursue healing in the way that's best for them. However, in the current system, they're not interested in pursuing that healing. There's no real avenues for any kind of restorative justice dialogue while a person is incarcerated. And so when victims are led to believe that the offender has not changed over the course of 20 years, that's a hopeless narrative for everybody. And I believe that the narrative we should be upholding is the capacity for change. So thank you. And please vote favorably for this bill. Thank you.
Good evening, Chair, Vice Chair, members of the committee. I'm Elizabeth Hilliard, representing the Office of the Public Defender. I'd like to start off by pointing out what this bill actually does. It allows a modification of sentence, which does not mean immediate release. It does not mean release in 6 months. It could mean release in 20 more years. It allows for a modification of sentence only if the judge first finds that the individual is not a danger to the public and the interests of justice will be better served by a reduced sentence. Those qualities to the decision ensure that we are recognizing the redemption of individuals and the fallibility of our law. This year, before you in your committee, you have Senate Bill 187, which is trying to remove the chain gang law that has been on the books since 1916. We have had that law for over 100 years, and it has still not been removed. I think it is safe to say that there is a possibility that there should be a reconsideration of decisions that we've made in the past. I think it is safe to say that in the interest of justice, there may be times when an individual should be and is ready to be released. And I think that it is an error to say all victims don't want this, or this somehow undermines the value and the care that we have for victims. They are not a monolith. They are allowed to present their case, present their information, and present their story at these hearings, and they should have a voice in the process and in the interest of justice as this bill requires. We hope you return a favorable vote on Senate Bill 123, and thank you for hearing us today.
Excellent. Thank you very much. Questions from the committee? All right. Thank you very much. All right. Do we hear from E. Flannery Gallagher? All right. Come on up. Magdalena Songus. She's virtual. Oh, she's virtual. Okay. And then Katya Hamilton. William Mitchell. Alexandra Bailey. All right, whoever would like to start.
Hello, good afternoon, Chair, honorable members of the committee. My name is Alexandra Bailey, and I'm the senior campaign strategist for the Sentencing Project, which for the last 30+ years has been at the vanguard of research and advocacy around our nation's carceral issues. And we actually count a former Maryland state's attorney amongst our ranks. You've heard a lot of statistics, and I was going to go into that, but actually I've decided to change my testimony because Senator Carter, I would actually like to thank you as a survivor of domestic violence who's only been safe for 3.5 years. And as a childhood survivor whose perpetrator is serving life without the possibility of parole due to the severity of the offenses that were perpetrated. I would like to thank you for introducing Senate Bill 123. And the reason that I would like to thank you is that people say that victims are not a monolith. That is correct. What this bill offers is not only just a meaningful opportunity for people to rehabilitate, but is also a meaningful opportunities for survivors. Because let me tell you what the system normally feels like. There's a technicality, somebody gets out, maybe you participate, maybe you don't. That is a very different scenario to listening to somebody take responsibility, to show contrition, to show that they have changed, to then come out into the community to ensure that what happened to you as a survivor doesn't happen to other people. That is meaningful to survivors. That is giving back for what we have gone through. I counsel survivors all over the country. And do you want to know what happens to so many survivors who fight back? They end up serving these sentences, and they don't have the opportunity for review. Please pass this bill. And if I may, Chair, I would just like to add one more comment.
Like very, very briefly.
Very briefly. So also, based on the prevailing evidence, several legal associations and experts recommend reassessing the necessity of imprisonment after 10 to 15 years. This includes the American Bar Association's policymaking body, who urges second look provisions at 10 years for youth and 15 years for adults. And the American Law Institute, which is a nonpartisan group who wrote the penal code, recommends the same.
Thank you very much. Thanks.
Please report favorably on Senate Bill 123. Thank you.
Okay. Thank you very much. All right, please. Thank you.
Good afternoon. Again, I'm Flannery Gallagher. I'm a legal fellow at the University of Baltimore School of Law's Center for Criminal Justice Reform. I'll reiterate briefly that the center is dedicated to supporting community-driven efforts to improve public safety and address the harm and inequities in our criminal legal system. We are grateful for this opportunity to testify in support of Senate Bill 123. This is a kind of common sense criminal justice policy that improves public safety, serves the needs of crime victims, and creates a valuable opportunity to both revisit sentences that may no longer be appropriate and to reverse some of the ill effects of mass incarceration. The Center has submitted written testimony, so I will confine my oral testimony today to two strengths of Senate Bill 123: the likely public safety benefits and the ways in which it furthers the interests of crime victims. First, allowing courts to reduce unnecessarily long sentences promotes public safety by allowing resources wasted on incarcerating people who pose a low risk of recidivating to be redirected to effective public health and safety measures, such as drug treatment and reentry programs. By creating opportunities for sentence reconsideration, Senate Bill 123 also incentivizes positive behavior within correctional facilities that would benefit incarcerated people and staff alike. Second, this bill responds to the needs and interests of crime victims. The narrative that crime victims always want longer sentences is false, and the research supports that. A national survey on crime victims' views found that a majority of victims believe that the criminal justice system should focus more on rehabilitation rather than punishment, and that more than half of crime victims prefer shorter prison sentences and more spending on prevention and rehabilitation over sentences that keep people incarcerated as long as possible.
Amen.
On behalf of the University of Baltimore School of Law Center for Criminal Justice Reform, I want to thank you all for the opportunity to testify in
Thank you,
support of
Ms.
this important bill.
Gallagher. And any questions, or have you testified, sir?
No, sir.
Okay, please come on up.
Thank you. My name is William Mitchell, and I'm a returning citizen. At the age of 23, I was sentenced to 70 years for an attempted murder case in which the victim was shot in her forearm and her leg. I went into prison as a young, dumb, thought I knew it all 23-year-old who was addicted to drugs and alcohol. In there, I met incredible men who had spent decades behind the walls, who spoke a thing to me called purpose. They helped me to find my purpose. While in prison finding my purpose, I took every program available. When I exhausted all remedies in the way of programming in self-development, I ended up designing programs that helped other prisoners change their lives and find purpose. Because everybody needs a purpose. If you don't have a purpose and you don't have a goal, if you don't have a goal, you're essentially lost. In doing so, I also learned that I could challenge my conviction. After 18 years, the Brown law firm in Baltimore City took on my case and found that I had an illegal sentence. That illegal sentence offered me, they found it, I went before a judge. The judge determined that my sentence was in fact illegal. When he resentenced me, that gave me the opportunity for a modification. Because I had that modification, I was able to have a second look at my case. Without that modification, without that illegal sentence, which was a legal challenge to the conviction, if I wouldn't have had that, I would have been 55 when I went up for parole for the first time and 93 when I was released. Today, I stand before you as a man who was in the community, kicking crime's butt. Now, from a guy who used to break the law, to say that now, it's very important to me to stress that there are men and women behind the walls who are no longer criminalistic in their mindset, who are willing to come into the community and do everything that they can. When I was incarcerated, the victim contacted me. I ended up making amends to them and helping them to get into recovery and getting their lives together. There are many people like me behind the walls who will not have this opportunity without this bill being passed. Please, pass the bill.
Thank you so much. I think that concludes in-person testimony. Any questions for this panel? All right, seeing no question. Oh, Senator Sidner.
I believe you said you're from the University of Baltimore.
That's correct.
You talked about statistics about victims and what victims were saying. Would you mind sharing who did that study and where that information?
Certainly. That's from the Alliance for Safety and Justice. And the name of that survey is the National Survey on Victims' Views on Safety and Justice from 2022.
I was interviewed for that.
So there was a national
Yes.
survey.
That's
Okay.
correct.
And
Thank you.
actually prosecutors were part of the study itself.
All right. Thank you.
Thank you, Senator. Any further questions for this panel? If not, I believe that concludes the in-person testimony. Is there anyone we've missed in person on this who wishes to testify in favor? Okay, then we're gonna go online. And I believe the order, at least in front of me, is Magdalena Sangus, then Sierra Robinson, then Deborah Idrissa. Let's take those three, if we could.
Hello?
All right, we've got two. I see Magdalena, why don't you kick us off?
Thank you. Can you hear me? My name is Magdalena Chungus. I'm the convener of the Maryland Second Look Coalition and a family member of an incarcerated person, John. I started convening the Maryland Second Look Coalition with other impacted family members and previously incarcerated people and advocates to create a pathway for hope and rehabilitation for families. John has served 17 years on a life without parole sentence since he was 19. So by 20 years of incarceration, he'll have spent more time in prison than he spent when he was free, and it's equivalent to his entire lifetime behind bars. A lifetime is enough for a person to be a different person. It's a difference between a teenager and a 40-year-old. With a life without parole sentence, the change that you make is based on your own determination to become a better person. You aren't accumulating good time. You aren't meeting with your case manager to make a reentry plan. You aren't prepping for a parole hearing, but still in those 17 years, I've seen the leadership in John that drives him to support others in rehabilitation, and being given the opportunity to get therapy behind bars has been life-changing for him, has let him unpack his own traumatic childhood, what got him to prison, allow him to address the harm that he caused and to gain wisdom about where he wants to go. And so our dream is to have our family whole. And nothing has brought me more joy in this fight than seeing other coalition members who have come home after decades in prison, who now get to raise their kids and support their elderly parents and get married. And that is the opportunity that as family members, we're all longing for. And this bill would give us that hope. For these reasons, I encourage you to vote favorably on the Maryland Second Look Act, SB 123. Thank you.
Thank you so much. We'll now go to Sierra Robinson. Sierra, it looks like your camera may be blocked in some fashion. If we could see you.
Yeah, absolutely. I am still here. So thank you, Senator Joe Carter, for sponsoring Senate Bill 123. I would like to extend my gratitude to the Judicial Committee for allowing me to speak in favor of the petition to reduce sentence. The criteria that an individual must have served 20 years at minimum is a solid measure of a person's change. SB 123 is a bill that the community can feel confident in supporting, because only those who have proven long-standing rehabilitation will be considered. Contrary to what the opponents may say, this bill is not a public safety issue. There are those who have made the decision to look inward for personal rehabilitation. We cannot continue to live in a society that has no reasonable consideration for the person who has put the inward work to rehabilitate themselves. I am in favor of SB 123, which mandates that the individual must serve a minimum of 20 years. A candidate for reduction of sentence should hold a prison record that gives the courts every reason to feel confident that there is no threat to the community. If we are being honest, we have individuals in prison right now who have been rehabilitated for decades. They are less of a threat than some of the people we live amongst every day. Former Governor Glendening said life means life in 2018, recanted this entire statement. He himself said it's completely wrong. I am in favor for SB 123. It coincides with the recent partnership of the Attorney General Anthony Brown and Public Defender Natasha Dartigue in the creation of the Maryland Equitable Justice Collaborative. Safety of our community is the top priority. However, we need to put an end to mass incarceration. We are asking the committee to do what's right, fair, and reasonable. This will be a step in the right direction, I ask the committee to vote favorably for Senate Bill 123 to help end mass incarceration, give opportunities to those deserving reduced sentence based on a proven track record of rehabilitation.
Thank you so much for your testimony.
Thank you.
So according to our rules, we're supposed to have everyone testify on camera as they would had they been here in person. So I just ask everyone going forward who's on Zoom to join us on camera, as is our rules. A quick audible, the state's attorney for Prince George's County is scheduled to testify on the next bill, which is similar to this bill, but needs to head out for an appointment. So I'm going to invite her up, State's Attorney Brayboy, to testify.
Thank you
for
very
the
much.
bill.
And thank you so much for the accommodation. For the record, I'm Aisha Brayboy, State's Attorney for Prince George's County. I will start by saying that I also support Senate Bill 123, though I am here formally or officially in support of Senate Bill 318. I think both of these bills address the very important issue of giving real second chances to people who absolutely deserve it. And in that respect, I'm not only here as the state's attorney, but I'm also here, and I use this very rarely, as a Christian. And as a Christian, I truly do believe that redemption is real. And not only do I believe that, as I look at the dozens of men and women that we have been able to give second chances through, whether it's through the JRA or other means that we have been able in our office to creatively come up with to provide second chances for individuals with lengthy sentences. What I have seen are men and women who are doing what we want every citizen to do, which is to contribute to our community. Zero have reoffended. Zero. And as a result of that, I think we should look at ensuring that our justice system is fair to everyone and recognizes that when we say that we have a Department of Public Safety and Correctional Services, when they are actually helping to correct individuals, we should celebrate that. We should recognize that, and the law should be available to those who are showing that they have, the ability to be contributing members of our society and will not reoffend. They should have the ability to come back to our communities. What I can tell you is that these men and women want to be boots on the ground. They are the ones at the community meetings talking to our young people, ensuring, and I'll be very, very quick, very, very brief. They are the ones that are ensuring that our message that we want to send, don't offend, this will happen. They can tell these individuals what happens on the other side when you are arrested, charged, convicted, and sentenced to prison. They are our greatest deterrents out in the community, making a real difference. So anyway, I thank Senator Carter for her bill. I thank Senator West for his bill. I'm happy to be here and support both of these two pieces of important legislation. I have two people here from my office who will talk more specifically about the cases that we have acted on in our office, but I can tell you we have had 0 people reoffend, and that says a lot. Thank you.
Thank you, Madam State's Attorney. Appreciate you. Now going back to our virtual testimony, we'll go to Ms. Idrissa, and then in the waiting room, Alonzo Turner Bay, Gordon Pack, and Joni Lawson. That's the order.
Good evening, everyone. Can you hear me?
We can. Go ahead, please.
Okay, yes, my name is Deborah Dutton. Idrissa was my married name, but that's another story. However, I'm new to this, even though my son serving a life sentence has been incarcerated 19 and a half years. I'm still a novice to a lot of these things. I too, however, support SB 0123, knowing that there is change in everybody. And I don't want to get off topic, but I was a crack addict for 20 years. And if God can change me, he can change anybody. And my son bore the brunt of my addiction being the youngest child, and he was angry. And I'm not trying to minimize anything, but he has redeemed himself, as the state's attorney for Prince George's County was saying. He has been redeemed. Any and every program that he was allowed to participate in, I've got about 10, 12 certificates here. He's got his GED. He's a mentor for the younger guys coming into the prison system. Even the correctional officers go to him to try to help with some of the inmates that are on his tier, and I'm just thankful that I have this platform that I can take. I'm a little nervous, and there's some things that I wanted to say, and I know I have like 2 minutes, but I just want everybody to know that this bill is more than a bill. It is a life for some people. And I thank you for supporting this bill. I thank you for all those that even created this bill, or however I'm supposed to say it. I don't know how I'm supposed to say it. I thank you all for just hearing me. And I pray that you all support this bill. And thank you.
We thank you for testifying here today. We know it's not easy. Mr. Turner Bay.
Yes. Thank you for allowing me to speak today. And thank you, Senator Carter, for presenting this bill before the committee. I'm asking that this bill move forward with favorable review. At the age of 17 in 1989, I was sentenced to life plus 5 years. I had a co-defendant who was in his 20s, who was convicted of first-degree felony murder and sentenced to 20 years. After serving 31 years, 6 months, and 15 days, I was released. But here's the ironic thing about my release. The same trial judge of Prince George's County, Honorable James P. Solomon, who served on Maryland Court of Special Appeals, who said that called me everything but the child of God during trial. In 2018, he wrote a letter to the Maryland Parole Board and to the governor saying after
Mr. Bay, you appear to have been muted. If you could unmute yourself, we'd love to hear the rest of your story. Mr. Turner Bay. All right, we will return to Mr. Turner Bay, who I'm not sure. Oh.
And one of those who they come to for resources for when they're returning back to the community. Thank you. I ask for a favorable review.
Thank you, Mr. Turner Bay. We'll now move on to Mr. Pack. Mr. Pack, please unmute yourself and you're good to go.
When they're returning back to the community. Thank you. I ask for a favorable review.
So, Mr. Pack, you're going to hear yourself if you have the YouTube page open. And so you'll need to close the YouTube page to prevent this repetition.
All right. Thank you for this opportunity. I appreciate it, and I apologize for not being there in person.
When they're returning back to the community.
My story is a little different. At 15 years
Mr. Pack,
old.
you're going to hear yourself if you have the YouTube page open. And so you'll need to close the YouTube page to prevent this repetition.
All right. Thank you for this opportunity. I appreciate it, and I apologize for not being there in person.
When they're returning back.
I'm sorry, I had to correct this. At 15 years
Mr.
old.
Pack, you're going to hear yourself if you have the YouTube page open. And so you'll need to close the YouTube.
I apologize. I'm having difficulty here. This is my first time doing this Zoom testimony. Again, I thank you for the opportunity, and I'll be pretty quick. First, I want to say that I was a 15-year-old who committed some very horrible crimes and served a life sentence. I did 42 years before I had an opportunity to be released, thankfully, because of the Juvenile Restoration Act. I had parole hearings in the double digits. I became eligible for parole during Glendenning's Life Mean Life's policy. So I never really had a meaningful chance until the governor was removed, which is around the same time I had my juvenile hearing. What I want to say to make sure that everybody understands, I don't believe that everybody is deserving to be released. I don't. I do believe that after 20 years, you know whether a person is ready or not. And what's taking place now is that people are not given that opportunity. As in my case, when the court denied my jurisdiction 50 days after my sentence, they no longer could do anything to act. But giving the court the opportunity to reconsider a case, to look at it and see if the sentence objective is being accomplished is a very good thing, because other people, just like the juveniles, just like myself, can be redeemable, have shown they have been reformed, and can come out in the community and be productive people. Some would argue, what about the victims? I am so sorry for my crimes. I'm so sorry for the victims. And on inside, as I do out here, I advocate for victim advocacy. I get involved in community engagement. I deal with reentry. I'm a parole advocate. I'm also a mentor for recovery and mentor for reentry. I believe that other people can come out and make the same accomplishments I've been able to do and show that people deserve a second chance. So I asked this committee to give everyone a chance just to have a court to look at the sentence and see if this is something that they want to continue or not. It doesn't mean that they're going to be released. Again, I thank you for your time, and I apologize for the difficulty in logging in.
So thank you very much for your testimony. Questions from the committee? Seeing none, I believe. Yes, so I believe that's the end of the panel for the proponents of the bill. We'll now switch over to the opposition panel, and we'll hear from Mr. Kroll, Mr. Schellenberger, and Ms. Mitchell. And actually, hold on, Rich. Mr. Gibson, yeah, come on up.
Good evening. Thank you for the opportunity to address you. My name is Rich Gibson, State's Attorney for Howard County, President of the Maryland State's Attorneys Association, career prosecutor for 20 years. We're here today to request an unfavorable report for Senate Bill 123. The rationale behind our request is several issues. The first is based on the victims. You heard earlier today in testimony from victims who've suffered from sex offenses, victims who've had traffic-related issues, and you saw firsthand how reliving that trauma triggered them. They were emotional in front of you. The victims deserve a degree of finality in the process. That's what they're seeking. And it's re-traumatizing to go over and over again, reliving, horrible moments that they've experienced. Additional issue we have with this particular bill is in Section 4, it wraps in policies that are in Senate Bill 318, which will address shortly, which potentially could politicize and monetize justice in the State's Attorney's Office, which we would seek to avoid. Finally, there are numerous pathways that one can challenge a conviction: direct appeals, motions to vacate judgment, motions for new trial, motions for modification, motions to correct the legal sentence, motions for post-conviction relief, writs of actual innocence, quorum nobis petitions. These are all mechanisms that currently exist for people to challenge sentences. Life sentence as it currently exists is eligible for parole after 15 years. And one final point that I'd like to make is there's a racial component that was raised in these cases. I think we should examine the racial impacts of our justice system. I agree with that wholeheartedly. I would point out, however, that crime is largely intra-racial. So when you have a defendant that is Black, there's typically a Black victim and Black victim's family on the other side of the equation. And I think that we need to make sure that we're acknowledging their perceptions, feelings as it relates to these issues. Thank you.
Good evening. I am Karen Piper Mitchell. I'm the Deputy State's Attorney for Charles County. We speak with respect to this bill that one of the things in creating these avenues, as Mr. Gibson has said, and I know Mr. Schellenberger will speak to, there are several avenues, but also the other critical thing is we also speak to the fact that the victims have an opportunity to be heard. One of the things that we observed as we're dealing with the JRA when cases are coming back in is that the pain is quite real for these victims and these families that have to gather and try to once again explain to the court why the sentence that was imposed was appropriate. They are once again having to sit on edge with respect to whether or not this person that was released. And we're talking about the crimes that are our most serious. Our murder cases or attempted or conspiracy to commit murders where someone has lost their life or someone tried to take their life. We're talking about rape first degree. And so I have a defendant who had committed 3 rapes. Under this bill, we have to bring his case back in if his attorney files. And if I'm going to file, or the defendant files. We're dealing with serious sexual abuse cases where we have one where it was multiple daughters in the household. We have to go back and tell them, hey, we get to call you back up so you can decide whether or not your stepfather should stay in prison. Those are the individuals. So just to say that the victims get to be heard, the problem is they don't want to have to come back. They need finality beyond the processes that already exist. There is one body that has been created, the parole board, after a certain point in time to address this. And you all have made several fixes with respect to that and removing the governor to make sure these things are happening. The thing with respect to the state's attorneys, there is no specific criteria that they get to look at and judge this. So again, I think that when we talk about justice, we have to make sure that we're truly looking at what the needs of the victims are. I ask you to pass unfavorably on this bill.
Mr. Chairman, Scott Schellenberger, State's Attorney in Baltimore County. Back to my more traditional role. I'm in opposition to Senate Bill 123. When I or one of my prosecutors walks out of a courtroom after a defendant's been found guilty and sentenced, the first thing they say to me is, finally, it's over. Well, guess what happens? There can be a motion for new trial, motion to modify or reduce sentence. You can file those every 5 years. If the modification is based on illegality, fraud, mistake, or irregularity, there's no time limit. You can go to a 3-judge panel. You can take an appeal to the Court of Appeals. You can ask an appeal to the Supreme Court of Maryland. You can ask for an appeal to the U.S. Supreme Court. You can file post-conviction, very often, more than one. You can file writ of habeas corpus. You can file writ of corpus nobis. You can file a writ of actual innocence. You can file a motion to vacate judgment. You can file a motion for post-conviction DNA testing. And you have a parole system that can have more than one hearings. So my question to you all is, when can I look at a victim and say it's over? It's done. You don't have to come back to court again. When can I say that? And because of this, I'm not only going to bring them in once, denied, 3 years later, twice denied, 3 years later, 3rd time. How many more times do we have to bring the victims into court and make them relive these crimes again when we have a system that is designed to work, and it's called the parole system? And you all made the parole system much more doable just recently when you took the governor out of parole. That was the complaint all the time. Oh, we'll take the governor out of the parole system, then I'll fix everything. And here we are again, bringing the victims back to court. I ask for an unfavorable report.
Mr. Chairman, I've said enough for one day. I'll yield my time.
Thank you very much. It's really just more of a point of clarification, Mr. Schellenberger. I believe that in your very fast testimony, you said that a modification can be filed every 5 years. Is that what you said?
No, I'm sorry. I did say that, but it was wrong. It could be held for 5 years.
Right.
So you can file it, and then the judge can say, I'm going to hold this for 5 years and then have a hearing. So you are correct. It can be held for 5 years, not filed every 5 years.
Correct. And that I addressed that actually in my testimony, the fact that 5 years is often not enough time for a person to be rehabilitated. And so once that 5 years is passed, there's no more obligation for the court to consider it. That's why we need this bill. But that was just, I wanted to clarify that point. And I also, for all of you that have testified to who purport to speak on behalf of all victims everywhere, are any of you familiar with the the 2022 National Survey of Victims' Views on incarceration?
I did hear reference to it. You got the.
Because we had some testimony from some victims, and so you would have to admit that some victims actually don't feel the way that you've presented that you know them to all feel.
No, so no one, I don't believe anyone, Senator Carter, I don't believe anyone said that all victims, we didn't present a monolithic picture. I spent 5 years in Baltimore City in homicide. I spent another 5 years in major investigations doing gang cases, human trafficking cases, organized crime cases. I've had victims tell me, Mr. Gibson, don't prosecute it, let them go. I'll take care of it outside. And I end up having to tell them, please, I don't want to do that. I'd rather not prosecute you. Let us handle this case. I've had victims show incredible forgiveness. I had victims show incredible anger throughout the entire process. There isn't one way that people relate to someone showing a lack of empathy and just disturbing the life, and sometimes in the most horrific ways. We're talking about 20-year sentences, so these are significant cases.
Right. But exactly, but all of you that testified, all testified that it's unfair to victims.
Yes.
Are any of you aware, but you're none of you aware of the survey, where 3-to-1 victims said in this national survey of 2022 that they are not in favor of lengthier sentences, that they're more interested in rehabilitation?
So again, anecdotally speaking, I spent 5 years in Baltimore City homicide. I've tried 30 homicides myself. I probably handled 100 or so. I can't give you numbers as to how many gang cases and things of that nature, but I've handled a lot of these cases with very exercised, very animated victims.
But I understand that.
And I'm saying to you that in that anecdotal experience, firsthand, I've had these conversations with people and seen their pain. And I want to spare them that pain if I can. I think we're all saying that. We see their pain first. We have to sit in the room and have the conversation with these individuals. And it's terrible. I feel horrible for them. It's heart-wrenching when they talk about the things they've suffered and how they feel. And now they got to relive and get ready again to go back into court and express all over again. You saw this morning when the people came before you and talked about sex offense cases and vehicular crimes and how that impacted them. They were certainly showing emotion when they described to you earlier, thinking back on what happened to them. That's what we're seeing. That's why we're saying what we're saying to you.
I understand, and you're going on pretty long for a simple question because you already indicated you weren't familiar with what the majority of victims in this country feel about these kinds of pieces of legislation. No, not all of you said you said it's not monolithic, and that's what we're saying. That's what I'm actually saying. I'm saying it isn't. So I think that when you stand here and try to deny thousands of people of an opportunity, which is not a guarantee, but an opportunity, because of anecdotally some victims might not agree with it, I think that is actually a bit disingenuous, because that does not represent even the majority of victims according to the data.
So that data you're relying upon, I'd like to know who founded it, who was the source behind it, was it neutral? There's a lot of aspiration, a lot of weight is being put on the study, and I frankly have not had the opportunity to review it, so I don't know who conducted it and what their particular biases may or may not be. And so I'm not going to put faith or weight into something that I have not actually seen.
I'm happy to share it with you. I have bits and pieces of it, but I would love to do that. Thank you very much.
Thank you.
Mr. Gibson, I just wanted to make certain that I heard you correct. During your earlier testimony, did you say something about something monetizing state's attorneys?
So,
or did I mishear that?
No, you heard that correctly, Senator Senior. Thank you. Section 4 of the bill, if you refer to it, gives the prosecutors the ability, and this kind of relates directly to the next bill, which I believe will be discussed, but it sort of wraps within Senate Bill 123 is wrapped in the primary thrust of Senate Bill 318, which is to give prosecutors the ability to initiate a motion for modification or reduction of sentence, right? And
so what, I'm sorry, so section 4, we're talking page 2, line 14.
If you look at section 4, I'll get to it right now. Give me a second. So section 4 reads, notwithstanding any of the provisions of the law, thank you, an individual who does not meet the requirements of paragraph 1 of this subsection is eligible for court reconsideration of the individual's sentence if a state's attorney files a motion to reduce the sentence during the individual's incarceration in the circuit court for the county in which the sentence was imposed, right? So Senate Bill 318 is discussing giving the attorneys that power that's kind of wrapped inside of Senate Bill 123 in that one section.
I'm trying to understand how does it monetize it? That's what I'm.
So in theory, if the state's attorneys do not have the current power to initiate this a modification like this, right? It would come from defense counsel or defendant, typically. And so if state's attorneys have the ability to revisit sentences they themselves have not handled, right? That could be something where it's politicized. It could be politicized. So the defendant's father is extremely wealthy, and defendant's father decides, I'm going to support a state's attorney candidate who will change my son's criminal sentence. They can then fund and politicize that action, that power. We don't want, 22 out of the 24 state's attorneys do not want that power. And so it's wrapped inside of this bill. And so we mentioned it in this bill, and we'll discuss it in greater length during the next Senate Bill 318.
Thank you.
All right. Thank you very much. With that, that'll end the hearing for Senate Bill. Oh, I'm sorry. Excuse me. We have one more question. No, Senator McKay, go ahead.
There was comment of that the victims have to relive this again.
Yes.
So 20 years go by, let's say this does pass. Really, does the victim have to relive it, or do they choose to be part of it, or do they have to be?
Well, we would contact them.
I understand that, but they still have free will to either participate or not participate.
Oh, of course.
And I think that's an important point, because while I know Senator Carter's hanging her hat on this survey, but I don't believe that it's apples in apples. That survey sounds, and I haven't read it yet, but what has been presented, that they would rather choose instead of harsher penalties and then have rehabilitation. Well, how long has it been since they were victimized? You follow what I'm saying? There's a lot that can go into that. So I guess we're just getting clarification that the victim doesn't have to if they don't want to. They will, because you have to notify them.
Yes, would you notify
But
them?
if they
You
want to
contact them.
participate, they don't have to be.
But in that contact, and I agree with Senator Carter's point. There are some victims that say, you know what, I feel fine, whatever you want to do, and they express that. There's some victims that go to parole hearings and express that, right? But when you contact them, it can be jarring, and I've had those conversations, and they're in that moment that there's a fear that pulses through them. It's palpable, you can feel it. And
We experienced that.
Right.
In the testimony today and last Thursday. So I get that. Is there a magical year?
Is there a magical year?
Meaning, in this case, this bill is saying 20 years.
So currently for a life sentence, under the way it's structured right now, you're parole eligible in 15 years. I'm not saying you'll get it, but in 15 years, if you killed someone, right, that person's gone forever, will never breathe free air again. Their family's got an empty chair every Christmas, every holiday, every birthday. But in 15 years, you will be able to ask for your release. Not saying you will get it, but you can ask in that period of time.
But aren't we victimizing then the victims again if it's at 15 years and then this is for 20 years? I mean, I hear what you're saying. I understand the victims need to be part.
Sure.
But if the parole system is already possibly triggering a victim at 15 years, I'm not trying to minimize the trigger, but what's the difference now at 20?
Well, it's
I
not,
mean, it's another option. I heard that.
right.
But
So it's not just 20. So it's 15 to parole, then 20, you file your first one. Then at 22, say 4, you file your second one. And then you have a clever lawyer who says, maybe I'll wait till 30 on this one. And at 30, you file another one. And then guess what? You get a call because there's now a second parole hearing because you've now served 30 years of that life sentence. And what I'm saying is that it's not just the phone call. It's not just the showing up. It's the reminder of going in to a courtroom and having to listen to that. And because of video nowadays, you might be in front of a different judge. I'm going to play that video of that murder. And that family is sitting there again. And we try to be very cautious and we turn the TV around so that maybe the family won't see it. But what if there's audio and you hear that? I mean, that's re-victimization and bringing everything back. And you can say, well, they don't have to come to court, but they feel a sense of obligation to the loved one that they lost. They feel like if they don't go to court, they're going to let their loved one down. And so now we're in front of a new judge because it's been 25 years and suddenly they have to relive this case all over again because their parent, sibling, or friend got killed. And now we have to present the case like it's brand new because we have a new judge. And that's the kind of victimization I'm talking about. And that's why I'm saying, please, at some point, there needs to be finality. There needs to be a point at which I can say, we're done. And
But I don't think there is, as long as we have a parole system.
that's correct. And that's why I'm saying, don't pass this. Use the parole system and let that system do its job.
I get that argument, but to say we need to have it done and we don't have that.
We don't, but you're adding more to it.
I didn't say that we weren't, but you were testifying that they need to have final say, but in our system, the way it is, we don't.
Well, you're correct.
I mean, anyhow, thank you, Mr. Chairman.
All right. Thank you all very much. All right, that will conclude the hearing for Senate Bill 123. We're now going to move on to Senator West with Senate Bill 318.
Thank you. Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 318. The day's been long and I'm going to try to go as quickly as I can through this, and I guarantee it will not last as long as the last hearing. So there is a principle in Maryland known as actual innocence. As explained by Chief Justice Matthew Fader in an unpublished 2021 decision that he authored when he was still the chief judge of the then Maryland Court of Special Appeals, actual innocence means that the defendant did not commit the crime or offense for which he was convicted. Maryland law provides a very limited opportunity for a person to seek release from prison if newly discovered evidence shows that the prisoner is actually innocent of the crime for which he was convicted. The relevant section of the Maryland Code is Section 8301 of the Criminal Proceedings Article. That statute states that a person convicted of a crime may file a petition for a writ of actual innocence if the person claims that there's newly discovered evidence that either could not have been discovered in time to move for a new trial under the applicable rules, or if the conviction resulted from a trial that creates a substantial or significant possibility that the result may have been different. So in Maryland, under existing law, if a state's attorney discovers that an incarcerated person is actually innocent of the crime for which he was convicted, unless various hurdles can be successfully surmounted, it may not be possible for action to be taken to get the prisoner released from jail. It seems to me that if a human being committed to prison is discovered at any time and for any reason to be actually innocent of his crime, he should be released as soon as possible, especially if I were a state's attorney and knew that my office had prosecuted and convicted the person who now turns out to be actually innocent. I would not want to waste any time before getting that person released. There's another reason why this bill is needed. For any sentence imposed after 2004, a motion to reconsider made by or on behalf of a prisoner cannot be considered after 5 years have elapsed. This bill is a very simple bill. It merely authorizes a state's attorney to file a motion for reduction of sentence of an incarcerated prisoner if the state's attorney believes that such a motion would be in the interests of justice. Such a motion would precipitate a hearing before the court, and at the conclusion of the hearing, the judge would be empowered to reduce or eliminate the remainder of the sentence if the court made the determination that the interest of justice will be better served by a reduced sentence. I want to emphasize that under this bill, only a state's attorney is authorized to file such a motion. No one except a state's attorney may file the motion. Further, the decision to file such a motion is entirely discretionary on the part of the state's attorney. I understand that while the Prince George's County State's Attorney, Aisha Braveboy, supports this bill, and the Baltimore County State's Attorney, Ivan Bates, also supports this bill, some other state's attorneys are opposing the bill. Speaking to those opponents, I want to stress that if a state's attorney does not feel that such a motion should be made and would be in the interest of justice, the state's attorney does not even have to consider filing the motion. In other words, this bill merely adds another arrow to a state's attorney's quiver, an arrow that the state's attorney does not need to ever take out of the quiver. So with that description of the bill, I turn this hearing over to my two state's attorneys. Actually, State's Attorney Braveboy was here earlier and I think spoke in favor of this bill. She had to leave, but fortunately with us is Doyle Neerman, who's one of her assistant state's attorneys, and he can speak on her in her stead. So, and I guess we'll answer the questions once the panel of proponents is over.
You're the state's attorney. Thank you. Good afternoon, Chairman Smith, Chairman Wallstreicher, and the other members of the committee. It gets a little odd because I'm not with the MSA on this. Aisha Braveboy and I, we're looking at it from a different point of view. Real quickly, for those of you who may not know about my career, I was a state's attorney for 6 years, defense attorney for 20 years, and now I'm the state's attorney for Baltimore City again. I feel like I see the entire system from a different way that a number of people don't. No one asked me, but I also do support Senator Carter's bill as well, 123. I see a need within the system because what we need to have is an opportunity for individuals incarcerated to have a motion for modification after just 5 years. The way the sentence is now, the system is now after 90 days, you get sentenced, 90 days, you have to file a motion for modification. A judge must hold it secure, means it has to be held to the side. And within 5 years, there must be a hearing. If there is not a hearing in 5 years, you lose that opportunity. Let me give you an example. 2 young people, one on the east side of Baltimore, one on the west side of Baltimore, both of them are 18. Both of them pull out a handgun and both of them shoot an individual. On the east side, the young person dies. On the west side, the young person lives. The east side person takes a plea on murder, gets 40 years suspend all but 20. Gets life suspend all but 40, which means basically they're going to have to do a minimum of 20 years before they actually realistically going to get paroled. You're not going to get paroled after 15 years. It's not happening. The west side kid shoots him, goes to trial. The person lives, comes in, testifies, and now that kid gets 60 years. That young person is not going to be eligible for parole at least for 30 years. Now you have 2 individuals. They're in the Patuxent Youthful Offender Boot Camp. They do phenomenal jobs and they're ready to be rehabilitated. But our system really doesn't have a mechanism for that person to file, to have the court come before the court to say, I've changed my life, judge, I'm ready to come out to society. 15,000 people in the Institution Division of Correction of the state of Maryland, 5,000 of them are from Baltimore City. This is very, very important to give individuals an opportunity to have a second chance. I understand victims, I have to balance both. But what I will say is this, I don't think it's fair that all state's attorneys speak for all victims, that we have to give the victims the opportunity because some victims do say, hey, enough is enough, it's time that we've moved on. We need to find that mechanism. I do believe this bill is this mechanism. And maybe if you combine Senate Bill 123 and this bill, I do believe we need to have a modification, opportunity for individuals who are serving prison sentences. It's very difficult. We cannot continue to fill up our jails as warehouses. If they rehabilitate themselves, let's give them a second chance. Thank you. Are there any questions? If not, I actually have to go. Okay. You have a. Yes, sir.
Thank you very much. I'm trying to understand on the other panel, on the other bill, Mr. Gibson talking about monetization, and he pointed to 318, and I'm still not. I mean, then he essentially was talking about political graft or something, which I'm trying to understand. How does that? I mean, what does that have to do with this bill?
Well, I think some of the concern, and I cannot speak for my colleagues. I think some of the fear and concern is that if the state's attorney has that power to say, hey, I'll give your loved one a modification, then you do not necessarily want to put that state's attorney in that potential political position where, hey, you know, I'll support you to get rid of Joe Smith if you support a motion for modification. And I definitely hear that. I definitely understand that. But I also think that as lawyers, we're bound by professional rules of obligation and ethics as we are, and that, you know, if that is the law and you pass the law, then I think we as prosecutors will have to continue to uphold our ethical core.
Yeah, I mean, that almost sounds like some sort of campaign finance situation, which would say the state's attorney shouldn't be accepting contributions or something. I mean, it has nothing to do with this.
Yeah, I don't.
All right, thank you.
All right, thank you. Okay. Thank you very much. Thank you.
Thanks so much. I appreciate this. Thank you, Mr. Chair, Vice Chair, members of the committee. I applaud you for being here so long. I'm Doyle Neiman. I'm Assistant State's Attorney in Prince George's County. I've been for 25 years, served 12 years across the street, but I was the state's attorney through all that. I am the chief of the Conviction and Sentence Integrity Unit in the Prince George's County State's Attorney's Office. I deal with these cases. I talk to the people who are in jail, including some you heard from today, who were on the video here. I talk to the victims. I have every case we reach out. We have a dedicated investigator who finds the victims, and that's not always easy. And we talk to them. We tell them what we're doing, and they are not universally agreed one way or the other. The majority, still would want the person to rot in hell, right? They're upset that they got a limited sentence, but others are not. And as a judge told me, he understands their feelings. He would feel the same if he was in their shoes, but he's got a different job, just as the state's attorney has a different job. And as to this politics monetizing, that's nonsense. Each of you are elected. Every state's attorney is elected. Every judge is elected. You make decisions based on the merits, not in this manufactured fabrication here. So let me talk about the bill briefly. And I've given you some supplemental testimony in there as well, but this bill deals with sentences, not convictions. All those long list of things you said, those are convictions, not sentences. There's only a couple mechanisms for dealing with sentences. This bill deals just with sentences, not with convictions. And let me suggest that Senator Carter's bill, I knew her as a delegate, is not a bad bill. This is the conservative alternative, the conservative compromise. And it was designed, whether our colleagues here believe it or not, it was designed to address the real issues. It's voluntary to the state's attorney. Nobody has to do anything. And it reduces and eliminates frivolous or non-merit worthy cases. Those are the issues. Those are really the issues. This bill addresses those in a meaningful way. If you do nothing else on this issue, this is the bill you should do. 60% of the cases in Maryland or more are in Baltimore City and Prince George's County.
Oh, I'm sorry. I forgot.
Good evening, no longer afternoon. I'm Jane Harmon. I'm a retired epidemiologist from Montgomery County. The American Bar Association's resolution 504 urges state governments to adopt, quote, legislation that permits a court at any time to recall and resentence a person to a lesser sentence upon the recommendation of the prosecutor of the jurisdiction. Prosecutor initiated resentencing, and SB 318 is exactly that, has already been enacted in many other states. In Louisiana, the powerful Louisiana District Attorneys Association helped write their version of the bill. In Maryland, unfortunately, to the contrary, you're going to hear leadership of the Maryland State's Attorney Association oppose this bill. I have to disagree with them very respectfully. I'm very pleased with the work they do in other domains. I think they're really wrong on this one. For one thing, as was mentioned earlier, prior to 2004, this rule 435, I believe it is, allowed resentencing consideration at any time during a person's incarceration. That was taken away in 2004. We're asking that it be restored, plus with this additional safeguard that the prosecutors themselves are the gatekeepers. If they don't want to reconsider the sentence, they don't need to. But I urge you to move Maryland forward, as these other states have done, and align Maryland with the American Bar Association. And please do not allow the retrogressive view of the State's Attorneys Association to derail this very well-written and very common sense law. I thank you.
And with that, I think if anybody has questions, our panel will be prepared to answer them.
Thank you. Just one question for the last witness. You had mentioned that it was in 2004 that the law was changed. Do you know what may have been the policy reason that we moved from allowing to then disallowing?
I'm not an attorney, so I'm going to let Attorney Neiman handle that one.
I actually know what happened there and understand it. There were a series of instances that got into the media, people whose sentence had been reconsidered by judges, and it created a controversy. I was in the House of Delegates at that time. There were serious efforts in the House and in the Senate to enact a law that would eliminate reconsideration. So in response to that, although he later denied it, Judge Bill pushed through the rules change that put the 5-year limit on it. So that was a political decision in response to a few bad incidences. But like Governor Glendenning, who was my governor and my county executive and my constituent, in his decision on parole, that one's probably was short-sighted and wrong and has proved to be counterproductive.
Gotcha. I appreciate it. Thank you.
All right.
Any other questions?
No further questions. Thank you, Senator. Thank you to the panel. Thank you all for hanging in there with us. We'll now switch to the opposition panel for Scott Schellenberger, Mr. Gibson, Ms. Mitchell. Sorry. Oh, I'm sorry. We have two virtual favorable. So we'll hear. I think they're all gone.
Okay.
Yeah.
Do you want to double check?
So is Nathaniel Erb here virtually?
He's virtual.
Okay, we'll do Nathaniel and then we'll do Annie Kirsch. Oh, I'm sorry. We have two virtual. Hey, Nathaniel, if you could shut down your YouTube page, and then we're getting a little bit of feedback. We're ready for you. There you go.
Sorry about that. Good afternoon, Mr. Chair, members of the committee. For the record, Nathaniel Erb here as the State's Policy Director of For the People. For the People works on this issue across the country. We passed the first piece of legislation in California, led by prosecutors, to provide this tool for those that wanted to use it. Since then, 5 other states have adopted it. Unfortunately, I'm not there with you in person today, as I would love to be, but that was because I've been spending time in Utah, where conservative lawmakers are pushing forward legislation in the same manner. This has been a very successful program across the country, leading to over 900 people being released back into communities. And in fact, less than 1% recidivism rate in terms of just arrests, and an even less percent of those folks who have actually been recommitted for any reason. This is an extremely successful program across the country. It is an entirely opt-in program, depending on if you want to use it or if you do not. There's no pressure to do so. We have seen it of wide success, just like my home state of Maryland. California and Washington and Oregon and Minnesota are not monoliths in terms of political elected officials. And so we've seen DAs from across the political spectrum use this to great effect, both to serve those in their communities by making sure they're enacting just sentences, and seeing how they have gone about the process of respecting the voices of victims through these processes. Part of the reason why over the 5 years only 900 people have been released is because of the labored intense process that district attorneys, just like I'm sure Attorney Neiman does in his office, take the time to hear from victims, to talk with them before even filing a position, and then judges have the option to review that. I strongly urge the committee to provide a favorable report. We've submitted testimony with a lot of information about how this has been successful without any negatives across the country. Thank you.
Hey, thanks a lot. It's good to see you. Have fun out there in Utah, but I'll see you when you come back. All right. Annie, you're up.
Thank you. Before I was an advocate, I was a mechanic. And so to me, this is like the roadside kit that you stick in the back of your car and you hope to God you're never going to need it. But if you do, you are just so glad that you have that flare to hold up and say help. And I hear a lot about people doing this alone, like a state's attorney is somehow going to overturn a sentence all by themselves. But that is really not what the flare is for. You still have a judge involved. You still have an entire court involved in the process. So I think a lot of what I was listening to earlier about the ability to find corruption here, and you can find corruption anywhere, but is really a false narrative, because a judge also is going to be involved, a defense attorney, the victims, as he just said, are going to be respected in the process. But what this is going to do is it's a very low cost solution, because you're not adding another department. You're not adding a whole new piece of a system. You are just empowering somebody that needs that emergency kit because they've identified a problem to be able to pull that emergency kit out and get the help they need to fix the problem that they've identified. If there's 24 people and only 2 of them have a problem, that's great. Allow the 2 people the access to the tools to fix the problem, and the 22 people can go on and they don't need access to those tools to fix the problem. But if they ever do, the kit's in the back of the car. I know that I've spoken a lot about what I see in the parole system, and I hear a lot about parole and second look. That is what I work in every day. Parole is not a venue where a prosecutor can put their hand up and say, hey, I need help looking at this case again. I feel like this needs a second look. Parole is a venue where the conviction is assumed and they are looking at the circumstances of the crime as stated and looking at a set of prescribed factors from 7305 or CS 7305. So those 2 things are incompatible, and I urge you to give the prosecutors this extra tool that they can use if they need it. Thank you.
All right, thank you all very much. No questions from the committee. So now we will actually switch over to the opposition panel.
Thank you. Rich Gibson, State's Attorney for Howard County, prosecutor for 20 years, President of the Maryland State's Attorney Association. Thank you for the opportunity to speak to you all. The state's attorneys, the vast majority of the prosecutors of the state oppose Senate Bill 318. We asked for unfavorable report. 22 out of the 24 state's attorneys do not want this additional power to be granted to them. Justice is not a commodity that should be exposed to politicization. Justice is not a commodity that should be monetized. And this bill does pose the risk of politicizing and monetizing justice, right? The risk is real. Someone could run on the issue of granting a reconsideration, a reduction in sentence for a case that was handled by another agency, another officer, another prosecutor. Someone themselves, if they were an attorney, could run with the ultimate mission of just changing an outcome on a case, right? That is inappropriate, right? There is a parole commission whose task it is to evaluate fully the individual before them, determine whether or not this person is reformed and safe to return to society. And then that entity is the person who is best suited, or that group is best suited to make these determinations. I feel very strongly that there is real hazard, that there's real moral hazard, there's real political hazard in this bill. And for that reason, the state attorneys of this state oppose and do not want this power. Thank you.
Good evening. Last time, Scott Schellenberger, State's Attorney for Baltimore County. I adopt my testimony from before and remind you of those 14 factors and times that we drag a victim back into court. So if I'm very clever and I'm Chris West, I say, but Scott, you know, I'm giving you the power. You don't have to do this. You never have to file one of these. And I would say to Chris West, well, Senator West, I really appreciate the fact that you believe I'm going to be in office for the next 100 years, but there's a chance that I might have to leave office one day. And therefore, could someone else go back and look at every life sentence and decide to give somebody a second chance? Or more importantly, and I know this might sound crazy, but what if a progressive Democrat ran against the current state's attorney and had a lot of money behind them and was running so that they could do that? Is that something that may have happened or could happen? The answer is yes. And therefore, what I'm coming to say again is finality. There needs to be finality. We don't want this power because we think there's enough there already. And we think that in a political sense, it could be abused by having an individual take those kinds of positions. And so therefore, I am against this bill. I don't want this power. And I certainly don't want somebody who gets elected 20 years from now undoing the things that I did for the last 40 years.
Good evening. Once again, I'm Karen Piper Mitchell, Deputy State's Attorney in Charles County, and I've been serving in Charles County since 1999. And in Charles County, we had that very real situation where, as a result of a case that the current state's attorney at the time prosecuted, and this was before the 2004 changes with respect to putting a 5-year limitation on when a judge could hold in abeyance MRS, that individual ran and was funded by the family and the individuals in support of the person who had gotten convicted and was serving an active sentence and trying to get that sentence change and get the change in how our office handled that, and ran on that specifically and ran and was supported actively by those individuals who actively also protested outside of our courtroom on a real basis. So when we bring to you the real concern about giving the state's attorney this opportunity to decide to bring it, because if you look at this statute, it doesn't set any kind of guidelines. It just says, well, in the interest of justice. That's kind of broad. It doesn't look at making some decision as to whether or not there's some mechanism set in place so that the 24 jurisdictions are even-handedly looking at those. And let me just say, the individual who was convicted, it wouldn't have resolved the concerns that we have about the over-incarceration of African-American men in prison because the person wasn't a man and wasn't African-American. And so when we talk about when you give this power, there is some concern about the abuse, and 22 of us don't want it. We leave this process as it is. The defense files it. There's a parole board and those things and the mechanisms that are in state place. But we talk about all the different, this is a safety net, this is this and that. None of that is written within this. It's just in the interest of justice, I can come forward. And had this existed at the time that the person who ran, they would, and they had won, they could have filed this, and again, at that time, the 5 years was still available. Thank you.
Chairman, I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases for 39 years. I'll be very brief. When Senator Carter brought forward people about a study, it was by the Alliance for Safety and Justice. Look who they are. Look who their background is. Look what their mission statement is. What we use, I'm surprised Mr. Neiman didn't bring it up because we talked about it at our summer conference last year, is the National Crime Victimization Survey. It's by the U.S. Census Bureau. It doesn't tell us everything about victims, but it's the most reliable victim survey there is. And I rely on that one. So that's the survey we want to look at. But even that doesn't tell the entire story. So again, look at the mission statement, look at the background. Finally, we need uniformity. We can't have two state's attorneys doing one thing because we're always criticized. Eastern Shore does one thing, Central Maryland, Western. Uniformity and 22 uniform state's attorneys say we don't want this power. Thank you very much. We ask for an unfavorable report.
Thank you, Mr. Chair. I just have one question for my good friend, the Baltimore County State Senator, and he already started, he knew how I was going to identify here. Scott Schellenberger. One of the great things about being the General Assembly is you can disagree on policy issues and go out after the hearing and share a beer. And we might do that tonight. So, but let me just, your statement suggested that it's all within the power of the state's attorney. And in fact, in the bill, the state's attorney only has the power to bring it to the court. And the judge is going to make the final decision as to whether the prisoner's term of imprisonment gets reduced, correct?
That is correct. It would be in the power of the state's attorney to ask. But that is where victims, in my mind, often get hurt. And that is now all of a sudden a state's attorney is asking, and you're talking to the victim's family again, and also bringing them back to court. That's why that's the problem. The other thing that I think is important, I know you're going to go to a court and have an independent judge make the decision, but obviously on the other side, there is going to be the defense who is going to do a whole entire case. So, in my mind, the problem is in just the asking, because that can re-victimize a family all over again. And Mr. Gibson has a follow-up.
I just want to add one piece to that, if I may, Senator West, which is that our system is adversarial by nature. So you have a state and defense, and the judge is supposed to be the neutral arbiter deciding the law. If the state's the moving party, defense is not going to ever oppose a motion for reduction in sentence or modification. So the defense is going to be aligned with the state, and the judge is unlikely to disturb both parties' presentation, right? In that the judge knows less about the case than the state does, right? And the defendant has access to the defense counsel. They at least have that information, right? And so the likelihood that a judge would ever differ is relatively small in the way our system is set up.
I understand. I was responding to Mr. Schellenberger's hypothesis that a very progressive individual might defeat the state's attorney and then come into court to ask that wholesale all these people be released from prison. And the progressive state's attorney would have to get past the judge, and the judge has standard that he must adhere to in terms of releasing people, and a lot of criteria that he has to go through in reaching his decision, correct?
And I think Mr. Gibson has made a great point by saying who's going to be arguing against those points, because now both parties are on the same side. And I thought that was an excellent point.
Yeah, thank you very much.
It's just interesting listening to this line of argument that, to me, it sounds as if our state's attorneys, the argument is that we can't be trusted with this power because we may be bought off. That's how I'm hearing the argument. But I wanted to say, I'm looking at this article that was written some time ago, I guess back when the law was changed, and Judge Joseph Murphy, who was the chief judge of the Maryland Court of Special Appeals at the time, he said, "I believe very strongly that somebody who has a motion for modification pending is going to be a better prisoner. As long," and it goes on, "as long as it's not abused, a motion for modification serves an important goal," Murphy said. "It can be abused, but so can presidential pardons." So again, what I'm trying to understand is, in some of the examples that were put forth, you're saying that somebody might be bought off and then they're gonna, or in Mr. Schellenberger's case, a progressive attorney's going to come in and change all these things. Now, that's the political, and the political has consequences. So if then the general public doesn't like what was politically done, that person won't get reelected. So, but again, that's the political, but the question here is about justice. And I mean, was Judge Murphy, is he wrong?
So let me touch on a few things. I'll take them sort of out of order, Senator Sidnor. So in terms of the political process and not getting reelected, if their goal was to do this thing, then their goal is achieved. They don't care about being reelected. They achieve their goal of undoing the conviction. So whether they get I want this so I can do that. Now that I've done that, I'm good, right? That doesn't speak to the underlying potential harm societally. Relating to the comment about prosecutors being bought off, I think most would agree in our society that money and politics have made a lot of challenges, have raised a lot of issues with how equitably and fairly our laws are created, crafted, and administered. And so we're just saying we don't want to have those pressures in this space. We want to be pure in each of us shares different visions. So prosecutor in a more conservative space, I'm state attorney, I'm a Democrat. I'm a centrist, however, in terms of my political views. Someone in a more liberal space may have a different vision for how they're going to implement the laws. Someone in a more conservative space may have a different vision of how they're going to implement the laws, but they're still pure in their motivations. We just want to keep unpure motivations away from what we do, right? And then as far as the judge, I'm not gonna disrespect his honor, but he was talking about the current system, not the one you're trying to create.
But it seems, but I think what has been argued earlier was that this bill kind of takes us back to the system that it was prior to it being changed.
I couldn't hear you. I'm sorry, Senator.
What was said earlier was these bills it's essentially trying to redo the reform that was made that was being spoken to back then. So he was talking about a system that I believe Senator West's bill is trying to bring back.
So I don't recall a time when prosecutors were able to initiate these motions. I don't believe that was ever the case.
Thank you. To Mr. Kroll, I took you up on, you said, look up the Alliance for Safety and Justice, and I'm looking at their data and methodology, and it says that some of the questions were informed by the largest and most comprehensive source of data on victimization, the annual National Crime Victimization Survey administered by the U.S. Census Bureau and the Department of Justice's Bureau of Justice Statistics. The National Survey of Victims' Views expands on questions related to the prevalence of victimization by deeply exploring victims' experiences with the criminal justice system that goes on. And it was David Binder Research that conducted the interviews back in August 2022. I'm curious, what was it that we're supposed to find? Because I'm assuming that
their mission statement. I'll be happy to offline to discuss the survey with you, the national survey that we used over the summer conference that we talked about, and the methodology. I know it's late, but it's the mission statement that we're concerned about.
Did the survey that you're referring to, are victims, do they look at things differently than what was mentioned under this survey?
It's not agenda driven. It's by the U.S. Census Bureau, so they have standardized questions. So there's no real agenda.
Right. So, but again, what did that survey find about? I mean, I'm assuming, do you know what did they find?
As far as who's favored or not favored, I don't think they made any conclusions, but I'll review it again. I'm just not sure at this time.
Okay.
But I know that's the standard right there.
All right. Thank you.
All right. No further questions. Thank you very much. Have a good night. All right. I think with that, I believe that concludes testimony in the hearing for Senate Bill 318. We'll now go on to Senator Waldstreicher with Senate Bill 4.
Well, good evening, everyone. Good evening, Mr. Chair, members of the committee. Before us now is Senate Bill 4. Senate Bill 4 was heard in committee last year and received a unanimous vote of support in this committee and a unanimous vote on the floor of the Senate. It got caught up on sine die and didn't complete its journey through the House. And so we are back again here today. Because it's gone through this process once, I will be very brief, but just as a refresher, the Department of Corrections is required to send a notice to people when to victims or their families when the defendant in that case is released from the care of the Department of Corrections. I have such a letter. It's right here. Last year we put it up on the screen. And this was received by my constituent Giselle Merck, and Giselle is with us here today. Giselle's son, JC, after whom the bill is named, was murdered a few years ago. It was a number of young men who committed the murder, and one of them was being released. And so the Department of Corrections sent Giselle a letter saying, basically that the murder of your son is coming out of jail. But what was interesting about the letter was how offensive it was written, how it was written without empathy, and how it was written without any resources available to the victim. And so I'll just kind of summarize here, but it basically says, Dear Ms. Merck, we're legally required to send you this letter, which is a great way to open an empathetic letter. This gentleman who killed your son is coming out of jail. If you have any questions, here's a 1-800 number. If you're concerned for your safety, call 911. Signed, of course, it's not signed by any human being. It's signed Office of Commitment Services. And when Giselle showed me this letter, I was kind of taken aback and realized that these should be written with empathy. And most importantly, they should be written in a way that provides real resources to victims in similar situations. And that the most important thing that a victim in Giselle's position could have is access to a victim services representative. So the bill we passed last year and the bill in front of you simply requires that these mandated legal letters have the name and phone number, contact information of an actual human being from the victim services coordination unit of the state's attorney's office where the crime was prosecuted. With that, Mr. Chairman, I'll ask for a favorable report. I think we're just doing sponsor tonight because this bill has been heard and passed before, but if it's okay with you, Mr. Chairman, I'd just like to recognize those who are with us. So Giselle Merck is here. Her daughter Gianna is behind us. Giselle, you're welcome to stand up if you want so people can see what you've brought. She is here with the Maryland Crime Victims Resource Center.
Excellent. Thank you very much, Senator, and thank you all for being here with us tonight. I know it's been a long day. So, but look forward to moving on the legislation. So thank you for being here. Okay. No questions for the senator. With that, that'll end the hearing for Senate Bill 4, and we'll now go to our final bill of the day, Senate Bill 380.
Thank you, Mr. Chair, and I'm going to bring a long day's journey into night to an end quickly. Under the current rules of this committee, this bill is a sponsor-only bill because last year the bill passed out of this committee unanimously and then passed unanimously on the floor of the state Senate. Now, in the process, a committee amendment was added to the bill and 4 floor amendments were also added to the bill. 2 of the floor amendments were sponsor amendments. The other 2 amendments offered by Senator Smith and Senator Rosapep, as well as the committee amendment, have been added in this year's bill. So this year's bill is identical to last year's bill, except it has had those 3 amendments added to it. That being the case, does anybody want me to explain the bill or would you rather go on to dinner?
All right.
I can explain it in 2 sentences.
Yeah, there you
Every
go.
police department in the state is experiencing a huge number of vacancies. Some of the most critical police departments really have a vacancy problem. So this bill creates a study, a summer study extending over the course of this year to try to figure out what's going on and make recommendations for legislation that we can pass next year to deal with what's going on and to try to end the vacancies in the police departments. That's the bill. Questions?
Amen and God bless. Thank you.
Thank you.
All right, that'll conclude the hearings for today. JPR After Dark.